September 2024, my lord. We have filed the contempt application that was to appear on 7th of March, my lord. That is not a reason, lord. Let it appear, my lord. Lordship kindly comes to page 6 and 17 the lordship's order, my lord.
So what you want?
My lord, at least that should be included in the list, my lord.
Have you filed the contempt application?
My lord.
It is not listed.
No, my lord.
What is the number?
Number is CC 47.
My lord, kindly to mention item number 23 and 24. Milad, this is a 3 p.m. fixed matters, Milad, by an order of 23 and 24 non-commercial list. These are 3 p.m. fixed matter for today. Milad, from 22nd of January. Milad, but we don't find Milad any marking on 2 p.m. today. 3 p.m. today.
3 p.m. because of my criminal appellate side matter.
Well, the difficulty is that Milad.
Nothing can be done, sir. I have to follow all the things.
Milad, I will be.
I cannot do anything. I have to.
Milad, may I
call the matters?
Very well. Urgency matter. No. He's putting pressure. What? No. Amendment application.
This is Milad. May I?
Just
today, Milad. Yesterday I was there, Milad. Mr. Jishnu Chaudhary said that he will not be doing 2 p.m. matter today because the witness is in China. Milad, may I take a chance at
other matter already fixed, I think.
2 p.m. fixed?
At 2 p.m. whether your persons will appear before this court?
I will not be able.
I don't know. I will. The court will be there.
I have difficulty at 2 p.m.
I will take
it can be fixed any other day.
Kindly keeps it any day at 11:30, Milad. Because
whatever, that is all. Any other day, Milad.
And I will be prejudiced, Milad. The 3 p.m. fixed matter for last 2 months.
What can be done? The court is handicapped. Court has to give the chance to all sides, appellate side, original side, suits, commercial.
I appreciate.
What can be done?
Milad, kindly, Milad, the age of the petitioner is 88 and 82.
See my age also.
88 and 88. 88 and 82. Milad, both the petitioners.
I don't put pressure unnecessarily. Keep it any other day.
I'm keeping it. Milad, kindly keep it 11:30 any day.
For what? What is
Milad, the amendment application? They will not otherwise see the fate of the suit. 88 and 82, both petitioners.
Amendment application, they will not see the fate
Milad
of
fighting against the sun. Milad kindly keeps it any day. Milad, it was fixed 3 p.m. today. Milad, just for the last 2 months we are waiting for this.
3 p.m. I know. My instruction is the time has been deleted because I have to give, because Thursday from 3 p.m. onwards I am taking the appellate side matters.
Kindly keeps it any day, Milad, 11:30, Milad, any time.
11:30 it is not, because if I take the
11, May, Milad.
that is another problem. If I will take the 11:30, then the bar is taking from, because new motion and adjourned motion has not been taken up for hearing. That is also one of us.
2 o'clock, but I know, Milad, it will go in May then. At 11:30, I believe some slots are vacant.
No, so 11:30 is vacant. But specifically, I directed my court officer 11:30 only some urgent matter which is parted. Then it has been, otherwise it.
It might get called even today. It's item 22.
Okay, let me call. If it come, I will see to that. Otherwise, at the time rising, you mentioned.
Very well. Give me liberty to mention at 150.
Correct.
150.
150.
May I seek?
Onwards, we are into some.
I don't know. The court will be here. If both the party will come, and I will take the matter. If not, the court will be case.
Your Lordship, may I be granted leave to mention item 5 and 6 with the consent of the other side, my lord? I'm mentioning, my lord. I hope they are there. My lord, kindly adjourn for the day, your Lordship. Item 5 and 6, the Oja's matter.
Non-commercial?
Yes, your Lordship. Yes. Non-commercial, the Oja's matter, your Lordship. Wherein Mr. Shakko Shen was arguing, your Lordship only knows.
For the other side?
I'm for the plaintiff.
It can be adjourned.
If it so commences, Mr. Ghosh had
they assured me that they will not oppose.
Ghosh had argued, then Mr. Sen is in reply. We'll kindly keep a short.
Yes. My lord, Mr. Shakko Shen was replying, your Lordship. I've taken the consent, your Lordship.
Counsel for the respective parties. On the joint prayer made by the counsel for the respective parties, hearing of the case is adjourned. Let the matter appear on.
Kindly not record both the parties.
Then I have to take.
My lord, I've taken.
Let the matter appear on 26th of March.
Deeply obliged, your Lordship. Deeply obliged.
Your Lordship, may I mention a matter? PLA matter, my lord. It appear in the list. The 2024 matter, my lord.
My lord, similar prayer, my lord.
PLA, give to my, all the PLA matters, give to my court office.
Your Lordship, leave was. My lord, may I have the leave?
Who is the senior? Yes.
I'm always the junior. Lordship would kindly, mentioning this matter, Your Lordship, I have to file this claim. I have affirmed and verified this claim, but it has been not accepted by the department due to my mistake, Your Lordship. The cost title has been printed on more than half the page, Your Lordship.
What?
Lordship, the cost title has crossed the margin of half the page. So the department has said that without the leave, they can't accept the claim. Without the leave, Your Lordship.
Leave granted to accept as it is. Subject.
Your Lordship, may I have you?
Yes, Mr. Sinha.
With trouble, Your Lordship, this is a PLA matter. I will give it the list, but the thing is, this is a no caveat certificate and everything. All the preliminaries have been completed. The only difficulty if it can be taken up in due course within next week or something, because
next week, Monday and Tuesday it will be
very well.
Your Lordship, may I have your kind leave to mention a matter? This leave was granted to cure the defects by the master on 21st of February 2025 and thereafter on 3rd of March, Your Lordship, within 2 weeks. The 2 weeks expired on 6th of March, Your Lordship. The corrections could be made there was 1 day's delay, Your Lordship. So I was seeking leave as if it could appear as to be mentioned or.
The matter is listed and the matter is mentioned by the learned advocate appearing for the plaintiff. The submits learned counsel for the plaintiff submitted by an order dated 21st of February 2025. This court has granted liberty to the plaintiff to cure the defects within 2 weeks from date, but due to some difficulties, the plaintiff could not cure the defects within the time framed by this court. Accordingly, the learned counsel for the plaintiff prays for extension of time. In view of the submission made by the counsel for the plaintiff, time to cure the defect is extended for a further period of 1 week from date.
Sincerely obliged.
My lord, may I have the leave, my lord? My lord, to mention, my lord, CS Com 539 of 2024, my lord, for filing, my lord, written statement, my lord. My lord, beyond 30, beyond 30 days, but within, my lord, 120 days.
When you receive the writ of summons?
My lord, 16th of November.
So when that 120th day is going
16th of this
16th
month.
of
Yes.
March.
Yes.
15th of March. Leave is granted subject to. Leave is granted to the counsel for the defendant to file the written statement in course of the day in the department subject to acceptance by the court.
Similar prayer, someone issued received on 27 January 2020, only 13 days.
Your Lordship, may I mention? Lordship, apology on the first hand because I am not supposed to mention here. It's a contempt matter on 21st. The last direction is that all the personal appearance of the 4 directors are supposed to be here, Your Lordship. Yesterday, we received a letter from the petitioner stating that they will be seeking adjournment on that day, but petitioners are absent.
Lordship, I am appearing for the contempt petitioner in the
When the matter is fixed?
21st, Your
on
Lordship.
21st, Your Lordship. We have some
Fixed on 21st.
21st. So let it be fixed to some other day, Your Lordship, because
but all the arrangements have been made, Your Lordship. 4 directors are traveling, Your Lordship. It's a personal appearance contempt matter.
Mr. Santan Bose, who is appearing. Mr. Bose, who is appearing.
Personal appearance is there, sorry.
Lordship would kind. No, I had already. That is why I have given him prior notice.
Personal appearance is there. How it can be a
No, that.
Okay, next.
May I permitted to mention item number 95 of the monthly list, Your Lordship. This is that matter where a section 8 application has been filed by the defendants 3 years after the written statement is filed. Your Lordship has heard it on 2 occasions. I'm praying that the matter be upgraded and a date may be fixed.
98.
95 of the non-commercial monthly list, Your Lordship.
$95
of the monthly list, Your Lordship.
Who is appearing for the other side?
Your Lordship, Mr. Rohit Banerjee was appearing.
What?
I am mentioning about
How
notice,
can
Your
you-
Lordship.
Lord, may I have my lord's
Yes.
Lord, may I have my lord's kind leave, my lord. Lord, to mention a commercial suit, my lord, for withdrawal, my lord. The parties have settled the dispute, my lord, and there is a terms of settlement entered. Page 2, my lord. Your
Next
lord,
on Monday.
extremely grateful.
For
my lord.
withdrawal.
Your Lordship, may I be also permitted to mention a PLA matter? Your Lordship, no caveat certificate has been obtained.
Give.
It should be included in the.
Yes, call the list.
So I am paying for the respondent.
After the response number 4, my lord.
Yes.
Your Lordship, we have filed our written notes, but yesterday during the course of arguments, we had submitted a wrong annexure had gone. So if your Lordship may kindly grant us the leave, we'll change the page of that particular.
Let I take a note of it.
If your Lordship.
That letter dated.
Yes, the 9th November letter. If
This is in the notes of argument.
yes,
Yeah,
it is
no,
there.
in the note they have enclosed one email
Email.
instead of the 8th.
I was only wondering, 8th November, and Milord's another document, purported minutes. Obviously, Milord, tailor-made after hearing our arguments and your Lordship's observation, Milord, it's like an affidavit in opposition. But shouldn't they give us a copy? Milord,
Your Lordship, we have given them our written notes of
no,
argument.
no.
No, we've
Minutes.
given it to them. We've given it to them.
No,
No, no, that
Yes, we
minute.
have.
That minutes.
That particular page we can have it right now. Not the minutes. Not the minutes. That was submitted yesterday that we are not going to
Anyway, don't want to
over
give,
the minutes.
what do I do?
Your
But
Lordship,
Milord, please just take note of this high-handed observation. Milord, just only
My
one
lord,
sentence.
my lord, we are handing over the document which we are trying to
You're
paste.
not
it
giving
and hand
us
over to them.
anything. It's
Yes,
very
yes.
high-handed.
At the time of
Anyway,
argument,
Milord, it's before your Lordship will, Milord, draw inference from this action. Just one sentence,
of
if your Lordship.
suppression. Yes, my lord.
Just
But-
one sentence.
But
In these minutes, your Lordship would find, Milord, an admission that the questions have been framed by the MRC. And Milord, subsequently, a lot of things done to cover it up. But that basic point, that basic issue, Milord, is admitted. After that, nothing remains.
okay.
Your Lordship, may I just renew my pair because we had handed a loose sheet. If it could go in, otherwise it may get misplaced and all. Yesterday we had handed a loose sheet. If we could just stitch it back with the written notes, it would be much easier.
So
And your Lordship, they may also hand over the written notes of argument to us.
suffering for the plaintiff, suffering for the defendant, like that. Full list of counsel for the plaintiff has filed written notes of argument. Give the after serving the copy to the learned
Give us-
counsel
give
for
a
the
copy.
defendant. Let the same be kept with the record. Counsel for the defendant number 1 and 2.
Your Lordship, we are appearing for defendant number 2.
2 and 3.
2 and 3.
2 and 3 have filed written notes of argument. The learned counsel for the defendant number 2 prays for leave only to change one of the annexure being at
Page 37.
page 27 of
37.
the 37 page 37 of the written notes of argument. Leave is granted to change to place the correct page of 37 in the written notes of argument in course of the day. CAV.
I don't want it. Milord, what has been given to us, the notes is, Milord, without any of these documents. I'm just bringing to your
Why?
Lordship.
Your Lordship, we have given them the written notes with all the annexures. They may show us the copy.
Where are the minutes? Please tell us.
The minutes are not there. That day we had
That's why
submitted.
recorded they are not given.
They will not give us.
That they
We have not given. We have not given.
And page 37, we
But
are
their
handing them right
choice.
now.
Mr. Mishra submitted that it will not be given. I take note of it.
And I can't ask for more. Their choice.
Item number 2, my lord, AP for the petitioner. But in this matter, my lord, your lordship had granted me the letters of administration by order dated 3rd of December. My lord, subsequently, in view of the registrar's report,
Yes.
the lordship was pleased to show cause the petitioner, my lord. Some points were required for clarification. But I filed a reply, my lord. May I just file before your lordship? But may I just take your lordship through the contentions raised? If my lord kindly sees page 16 of that affidavit, my lord.
Page 16.
16, my lord.
Yes.
Well, these are the contentions which have been raised by the registrar, my learned registrar. But may I just take your lordship through point wise, my lord?
No, you have filed the show cause, na?
I filed a reply to the show cause,
I am
my lord.
keeping one day for hearing.
As your lordship pleases, my lord, as your lordship.
So offering for the petitioner, the petitioner has filed the show cause as directed by this court dated 12th of February 2025. Let the same be kept with the record. Fix for hearing on 26th March.
Great.
Item number 3, I appear for the plaintiff over here.
My lord, I am for the defendants. You.
Huh? Empty. Yes, yesterday. Yes.
Your Lordship is pleased to pass a judgment decree dated 19th of September 2024.
Correct.
Your Lordship, subsequently, when the decree is being drawn up by the department, they want to send it to the office of the learned corrector for the stamp duty that is payable.
Correct.
Your Lordship, in lieu of that, we had submitted a judgment of the Honorable
So
Supreme
if
Court.
you are submitting the judgment to the department, how the department will see what is the judgment? Judgment will carry out the order passed by this court. And at that point of time, this judgment was not brought to this notice of this court.
No, Your Lordship.
So then I am fixing the hearing. So let you satisfy. I will go through the judgment.
The limited, yes, Your Lordship. The
Because,
limited conspectus is
Section
whether
17 of the
70 stamp
registration
duty,
act,
if it is
whether it is-
payable, the judgment says that
But only we have to say whether what is the prayer in the main petition, in the main suit.
Your Lordship, it was a suit for partition. Your
Partition.
Lordship, partition suit.
Okay. So I am fixing a date.
Because no new right has been
Correct. So
Yes, Your
fixing a date for hearing. If you satisfy this court, then I will pass an order.
About-
Need not to send in terms of the judgment. It is applicable. If it is not, then
most certainly.
so and so. The matter is listed as to be mentioned on receipt of the report from the office of the London Master of this court. Full stop. In the matter, in the present case, this court has disposed of CS number 65/2023 in terms of the settlement entered between the parties. Full stop. At the time of drawing up the full stop, at the time of taking appropriate step by the department, learned counsel for the plaintiff has submitted a judgment passed by the Honorable Supreme Court in the case of Mukesh versus State of Madhya Pradesh and another in civil appeal number 14808 of 2024, dated
20th December 2024.
dated 20 December 2024, wherein the Honorable Supreme and relying upon the said judgment, the plaintiff is of the view that the matters should not be sent to the
Office of the Learned Collector.
Office of the Learned Collector for ascertaining the stamp duty. Full stop. This court finds that the petitioner, the plaintiff, is relying upon the judgment passed by the Honorable Supreme Court, and as such, the matter is required to be heard on the said point. Let the matter appear on 27th of March 2025 for hearing on the point whether in terms of the judgment, whether the judgment passed by the Honorable Supreme Court is applicable in the present case or not.
Grateful to your Lordship.
Both, plaintiff and the defendants. जहाँ जहाँ plaintiff बोले ना, plaintiff and the defendants.
Grateful.
Yes, but that will be all decided one point. Under the heading for orders.
Could we come back on Wednesday, my lord, on this? But possibly we need to tone down the plane a little bit because my client can ill afford to go to Chennai, my lord. She's a widow, lost her husband, my lord, 10, 12 years back. She has to take care of his son who was very small at that point of time. And a property has been sold completely, my lord, disowning this line of lineage completely. But
that's why I'm asking.
No, I understand. He told me. The only thing is that, my lord, we'll tone down that prayer a bit because the document on the strength of which they got it done was issued by the Kolkata Municipal Corporation, an heirship certificate. So for that, the suit is maintainable and the money claim is there. So, my lord, even if I do not claim for deliverable and cancellation, then also we can, my lord, sustain the suit. So we'll.
But what purpose should be served?
I have a money claim. At the end of the day, my lord, if I get
my 1/6 share,
if my 1/6 share, if I get, then my but only one thing was I was humbly praying that, my lord, we shall discuss and indicate to the clients as well. But if since the plaintiff has not been presented yet, but in that event, my lord, we may seek your lordship's leave to take it back, and my lord, just tone down the prayers and a few pleadings, and then, my lord,
if you want to take back,
yes,
file afresh.
Not today,
next day.
On the next day, because
as per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on
Wednesday.
27.
As a regular next Wednesday, my lord, this coming
26, 19.
19.
19. Under the same heading.
Because I really do not want to, my lord, take the risk after the suit goes and also she cannot go to Chennai. So that is why, my lord,
okay,
we'll have to tone down a bit. Grateful.
Thank you.
Number 7.
My lord,
May
pursuant
your
to your
lordship.
lordship's direction, I have served upon all the parties, and my lord, it is my communicate করেছি. And my
My
lord,
lord,
I have received one report from BSNL only. They have communicated me.
my lord will recall
And
this is the matter in relation to that probate proceedings where lordship has passed certain directions. Unfortunately, we just received a phone call from the local police once. After that, we have actually received nothing. No letters, no communication, nothing we have received.
My lord, I have served upon all the parties with your lordships.
What you filed?
I don't
My
know
lord,
what is
Affidavit
filed.
service. Where is affidavit service?
My lord, just I have served it, not yet ready. I'll.
For the last many days, the matter is in the list.
My lord,
And your lordship passed this
my
order
lord, BSNL
8 weeks ago.
submitted a report.
Ah.
My lord, I have submitted before
I have
your
got
lordship.
nothing at all.
What
And
report?
one copy.
Where is the report?
My lord, I have a copy of this.
He's just serving me now. I've got nothing.
Just I have received. There is no specific direction what to do. My
And
lord.
this is in Bengali, your lordship. I think he needs to translate. Unless he wishes your lordship to.
This report filed by the authority, my lord. BSNL. This is agreement only. Will, that is will in Bengali, it is all along it was in English, my lord. English. Other things is English in English.
কি পাঠিয়েছেন তাকে পাঠিয়েছেন কি করেছেন
আরে বাবা, যেটা পাঠিয়েছে দিয়েছি। বিএসএনএল আমাকে একটা কপি পাঠিয়েছে, সেটা কাকে পাঠিয়ে আমাকে কেন পাঠিয়েছে দ্যাট আই ডোন্ট নো। I have submitted before the honorable court.
Yes, what about the other?
But,
Nobody has
we
come.
have,
No
we
one's
have
covered.
not received not any.
And what about your report?
I have received nothing. I have received no
Nothing.
no letters, no phone calls, no nothing from anyone.
No, you have been directed. Respondent one is directed to furnish the details of the rent collected from Bela.
Oh no.
Well,
I thought that
page 24.
yes, that is a difficulty because
Yes.
well, there's a difficulty with that. We thought that we would have to submit that to the police. If your lordship wants, I'll hand over to the court. I will hand over to the court next day. Next day I will hand over.
So whether it is served, where is service?
My lord,
This is not the way
my
to
lord,
conduct the case, sir.
excuse me, my lord, I am extremely sorry. My lord, may I pray one thing? Perhaps there is no specific direction, the report where will be submitted. My lord, they have communicated me that I don't know whether I am entitled to receive or not.
Since suffering for the
again, I will serve them.
Petitioner, since suffering for the respondent number 1. Police counsel for the respondent number 1 has handed over the document showing that the order copy of the order dated 15 January 2025 has been duly communicated to the concerned authorities as directed by this court. Counsel for the petitioner prays for time to file affidavit of service. Police counsel for the petitioner also handed over the report submitted by the Bharat Sanchar Nigam Limited, the AGM within bracket HR/ADM admin office of the PGMT Kharagpur, BSNL. Let the same be kept with the record. Police. The counsel for the executrix submits that prays for extension of time to file a report before this court in terms of the direction made in paragraph 43 within bracket E of the order dated 15 January 2025. This court find that by an order dated 15 January 2025, by an order dated 15 January 2025, this court directed the Chief General Manager Bharat Sanchar Nigam Limited, Postmaster General, branch manager or any competent authority of the Punjab National Bank, officer in charge of Integrated Child Development Services, Nandigram, executive engineer or any of the WBSCDCL, and officer in charge of Nandigram Police Station to submit report, but only the BSNL has submitted the report that to the learned counsel for the petitioner without to the petitioner, though the report is to be forwarded to this court. Accordingly, all the yes, you are appearing for
postal.
Yes.
Postal. I have a instruction. So far the rent, so far they have made a prayer in prayer B. We have a very limited scope, my lord.
What?
So far the rent we have a copy. If directed me to file an affidavit, by way of affidavit, I can bring this.
You have a copy?
Yes, my lord.
A copy of the order. You have a copy of the order. See the page 40, paragraph 43, prayer B. B. Page 23, paragraph 43, B.
43B. Order copy আছে?
Got it?
Yes, my lord.
So you have to furnish this detail.
Yeah.
So you have a details.
But so far I have got a copy of the rent. But so far the agreement I have to take.
Not rent, the total details. What the detail the court has asked for. You have to submit the total details. How many? What is the rent? What is the agreement? Since when? To whom it has been given? What it has been given the detail. Details shall be furnished to this court. Yeah, what you are telling to this court? Everywhere it is to this court. So, क्या बोला? Now.
Direction chain now. Exception if required. अरे दादा के पीछे के बोलो ना जीत बोले
No. क्या बोला लास्ट में? Directed ऊपर. हाँ. So and so. फिर last में to submit the report to this before this court, but only the BSNL has submitted the report that is also forwarded to the learned advocate appearing for the petitioner, not to this court. Not to this court. At the time of hearing of the case, learned counsel, what is your good name, sir?
The second part.
What is your good name?
Arunava Ganguly.
So and so appeared and submitted that.
I have a copy of the rent receipt.
Come. So submitted is he has instructed to appear on behalf of the Postmaster General, and he prays for time to file report in terms of paragraph 43 within bracket B of the order dated 15 January 2025. Considering the submission made by the counsel for the parties, the Chief General Manager, Bharat Sanchar, the above mentioned authorities are directed to file the report before this court in a sealed cover. On or before. आज कितना तारीख है? 13. On or before 27th of March. On 27th of March, on 27th of March 2025. It is made clear that by the date fixed, if this
But I am appearing for respondent number 4, superintendent of post office.
Correct. Recorded.
Not only one in that case. 27. Neither me nor my advocate and record will be here. Any day after 30.
Okay, second April. Second April. It is made clear that by the date fixed if the authorities and the respondent number 1 failed to submit the report in terms of the order dated 15th of January 2025, appropriate order will be passed. Full stop. The office is directed to communicate this order to all the authorities for compliance. List the matter on 2nd April 2025.
My lord, may I submit the affidavit of service in the on that day? I'll
Next.
Yes, appeared on the last occasion where I had said that we had received a bid after 2-3 years. We had received a bid from an intending purchaser after 2-3 years.
Yes.
3 years. So it was a lordship's pleasure that to ask us to use a supplementary affidavit and disclose that. We have done so. May I file the supplementary affidavit?
Your Lordship, I want to submit a prayer before Your Lordship that on verbal instruction received by me, Mr. Choyon Dash, one of the legal heir of Bholanath Dash, he wants to intervene in this matter. So kindly, if you give me a 2 weeks adjournment to file an application to that.
Why the court can give you? If it is your choice, you want to intervene, you come with an application.
Your
Not
Lordship,
leave is required.
He's out of state now, so he cannot sign the Wakalatnama also. So
That
kindly
is the
provide me.
problem. You are not in the state and you wanted to deal with the matter.
So
They are not trustees. Kindly sees I have annexed the resolution
But they
of the minutes book.
He is telling that if we let
Yes,
the
yes,
file
Lordship,
application,
we are-
the court will decide whether he is having interest over the property or not.
The only problem is the buyer.
1 week time
Only
for that.
problem is the buyer might.
Where is only that?
They have come. We have managed to get a buyer after 3 years. Kindly seize the minutes book, once, and I'll try and satisfy your lordship, page 35 is where the all 5 trustees have attended and the vote is unanimous. The resolution.
Where is that?
Page 35, I have annexed the extract of the minutes book. It's a public charitable trust. It will go into the trust funds.
35.
Page 35 of the supplementary affidavit. Annexure C,
Yes.
Your lordship would see the attending members, all the 5 trustees.
What is your name?
Your Lordship, my name is
Your client's name, not your
Mr.
name.
Choyon Dash.
So he's not a party here.
Not a trustee.
He's not a trustee.
But he is a legal heir of Bholanath
But
Dash.
as per the trust deed, whether he's acquired a trusteeship over the property, over the trust.
Your Lordship, we have
Property
applied for
belongs to the
the
trust.
copy of the application.
The question is that whether you are the trustee.
No, I am not a trustee.
Then you might be legal heir. What is the trust deed says?
One other thing, even if the sale is confirmed, the money is received, it will go into the trust account. So even then, if my learned friend's client can make out any
Okay,
case.
I am fixing after a week. After a week, if he is interested, let's see come. If, otherwise, the court will proceed. No problem. One person has come, so let the place her interest before this court by way of
I understand.
application. If the court satisfied he is having interest, then we'll see
They
to
should
that.
come up with an application by that time. Otherwise, then again.
That's why I am fixing after my.
My lord, for my lord's benefit, my lord, the trust deed is already there at page 11. My lord, we shall place on the next occasion.
Have you filed the supplementary?
Yes, ma'am, today.
So suffering for the petitioner.
And I am for the defendant, my lord.
So suffering for the defendant. So suffering for the intervener. The counsel for the plaintiff has filed the supplementary affidavit. Let the same be kept with the record. The intervener prays for time for taking appropriate steps to file an application to intervene in the matter. In view of the above, in view of the submission made by the counsel for the intervener, the case is adjourned for the interest of justice. The case is adjourned for a week. In the meantime, the intervener is at liberty to make appropriate application. It is made clear that by the date fixed, if the intervener failed to take any steps, the case will proceed accordingly. Let the matter appear on 3rd April.
My lord, could I prefer an earlier date, my lord? The only difficulty is we have got a buyer after 3 years. All of us apprehend that he might.
Only 2 crore.
It's a fully dilapidated, fully tenanted building.
But
This is my a word in hand is worth more than 2 in bush. My lord.
But the land, this cost of the land, 27.
But you have to
27 crore.
Great.
27.
Well, item number 10, I appear for the plaintiff, my lord.
Defendant, my lord.
Respondent was supposed to deposit 30 lakhs by the order of the division bench, my lord. They could not deposit within time, my lord. Thereafter, they had taken out an application for extension of time, my lord. By order dated 5th March 2025, 2 weeks time they were granted to deposit, my lord. The 2 weeks is getting over on 19th of March, my lord.
My lord, I'm
praying, my
2
lord, may
weeks
kindly
time.
keep it. My lord, may kindly keep it on 20th March, my lord. 19th March, the 2 weeks is getting over, my lord.
Have you deposited?
No, my lord.
Then 19 March. Next week,
Kindly, my
Wednesday.
lord, give me 2 weeks time.
What? This court cannot. It is the appellate court direction, madam.
Lordship, may kindly keep it on 20th March, my lord.
So appearing for the plaintiff. So appearing for the defendant. Counsel for the plaintiff submit that. As per the prayer made by the counsel for the defendant, the Honorable Division Bench by an order dated 5th of March 2025 extended the time to file and time to deposit an amount of rupees 30 lakhs for 2 weeks from 5th of March 2025. Counsel for the plaintiff submit that the 2 weeks is going to be completed on 19th of March 2025. Fully counsel for the defendant prays for 2 weeks time. Consider the submission made by the counsel for the respective party. This court find that the Honorable Division Bench has extended the time to deposit the amount by the defendant, deposit an amount of rupees 30 lakh by the defendant within 2 weeks from 15th of March 2025. In view of the above, let the matter appear on 26th.
My lord, by 5th March, my lord. Not
Correct,
15th
come
March.
on,
Lordship recorded 15th March.
Okay, 5th March. Come on, 26th.
I'm grateful, my lord. My lord, let it appear on the same heading, my lord. I'm
Under the
grateful.
same.
Well, I'm for the plaintiff.
Should I be to for some of the defendants?
The judge's brief of documents has been filed, issues have been framed. The only purpose is to have this done through commission now, Milord.
Lord,
Even
I
the last
did
suit
not
he will
consent
oppose
to
because
that.
he wants the suit to get lingered. If it crosses September, my suit practically becomes infructuous because we
Lord,
challenge
I
the
don't,
election.
Lord.
He will not agree. Last time also, Milord, in the same suit where between the same parties, it was done on commission. There also they are naturally opposed because it augurs to their advantage if it gets pushed. So at least, Milord, may I just make this prayer? I will bear the cost. Last time the commission expenses, this is slightly difficult for me to say, but last time the commission expenses were 75,000. If your lordship keeps it at that, I've spoken to my client. I will bear the cost for commission. We can come back to your lordship with the commissioner's report within 3 months. Let it be done on that basis. Now he can't have a problem.
I don't understand one thing, Lord. How can someone force commission on me? Lord, then order 26 has to take a back seat completely. It's thrown away in the Ganges. Fast. Lord, second thing,
It's
Lord,
right
the
here. You
previous
can
suit,
quickly throw it.
the previous suit, Lord, with respect to that, Lord, I don't, Lord, recall any commission being conducted for evidence because the stage of evidence never came. There's no stage of commission. Lord, Mr. Banerjee, I'm sure, Lord,
How
should be
many witnesses
instructed.
you are having?
I have one.
And how many witnesses you are having?
Lord, witness. What are witness?
What is the declaratory
Lord,
suit?
1 or 2 maximum.
Declaratory?
1 or 2 maximum.
That the earlier
basically
election,
they are
what
wanting
happens is,
to
Milord,
challenge.
in a suits that were filed before, special officers were appointed. They were supposed to conduct and hold the elections on the basis of a voter list that's formed in terms of the articles of the of this organization, of the association. There's ex facie violation of that because there are certain qualification and eligibility which allow somebody to become a voting member. From this, we'll be able to show evidence. Also, scope will be quite limited, only to show that factually these people are disqualified. That's why I have only one witness who will just come and show their own documents.
Date will come here.
No,
My
Milord,
lord,
this
fixes
will.
dates will come
But
here.
I
What's the
understand. Mr.
Why-
Karmakar,
why
the
Mr.
problem
Banerjee
is primarily.
Go with the commissioner.
Lord, my
But he
client
just
is-
wants to put. No, his client doesn't want to agree. I will pay
I
the cost. Lord, why Mr. Banerjee is insisting upon commission? Two reasons. I'll I indicate do two not reasons. understand. One, my client is 69 years old. He has a renal complication. He undergoes dialysis. Second primary issue is the constraints of time with this court and the pressure that this court is under. It's unfair to come and foist a witness action on this
If the
court.
other
Then
side is not, if the other
every
side is
witness
not-
has to be
Well,
done on
other
condition.
not giving
Courts
consent,
have to be
then the
shut
court
down.
has to decide on merit.
Yes, then your lordship will
The court
decide.
has
I
to
don't need an application. Your lordship can do
Court
it on
has
the
to
basis
decide
of.
on merit.
Your lordship will just consider my prayer. I don't need a separate application. I am indicating that I will bear the cost. Lord, I'm indicating why he will Lord, not. in such a situation, Lord, I understand, Lord, an application in that case would be required.
Yeah, Manutosh.
Lord, kindly considers order 26 rule 4 once. Original side rules are not. Original side rules are lage na.
Because this court is very bad experience with the commission also. Till date, for the last 2.5 years, I am dealing with this determination, and several commission has been appointed, except the undefended suit. In the contested suit, not in a single case the commission has filed a report.
I am guilty in one of these.
What? I'm not telling you. I am not recognizing.
I am only guilty, sir.
Yes, yeah. January. मेरा वो सर्किट 30 को है ऑर्डर सर्किट 30 जून से I am fixing when the court opening कब है 9 से 10th 11th and 12th 3 date I am fixing here.
June. Very.
And
very great. And thereafter, my lord, we shall, after completion of that, my lord, then we shall come with our witness.
Then otherwise I will fix up so that
yes,
matter
no
can,
difficult.
Can be, otherwise then the
Look,
how much time will take you will file exam. It is non-commercial.
Non-commercial.
So you have to
but one day I'll do the chief.
You will do
one day I'll do the chief.
Then 2 days they will take.
2 days they can take.
9, 10, 11.
Tentatively for the time being, Lord, 9, 10, 11.
No, I want if you will not, then I will fix the other date. So that
kindly does that.
That will
Lord,
be better.
this will be, I think, understand it's too early for that. 3 dates for the time
No,
being.
I am next week. I am not continuing that. Next week I am fixing, not continuing. And 18 और 19 जून को देखो 18 19 जून.
Lord,
18,
some
19.
temerity, may I just pray for one thing? Instead of the 9th of June, can it be 10th, 11th, 12th?
So and so applying for the plaintiff, so and so applying for the defendant. Counsel for the respective parties submitted. The pleadings have been completed. Judge's brief of document has also been filed, and issues framed. Yes. Issues have also been framed. Full stop. The counsel for the plaintiff prays for fixing the matter for witness action. In view of the submission made by the counsel for witness action. In view of the submission made by the counsel for the plaintiff, let the matter appear on 10th, 11th, and 12th June 2025 for witness action of the plaintiff for examination chief and cross-examination. For examination in chief and cross-examination of plaintiff witness. And 18, 19th, and 20 June 2020 is fixed for defendant's examination of the defendant's witness and cross-examination.
Very great. Great. But one further
at 3 p.m.
One further request, if I may make, would it be your lordship pleasure to make this part heard? So I can, at least I can chase your lordship wherever. But he was saying that it's pressure on court.
That pressure I will not take. Some pressure I can, but the whole pressure can't.
Grateful.
My lord, for content number 2 and 3, my lord, my senior is engaged in a different code. A fixed matter is going on.
Who is for the petitioner?
Number 12, my lord.
Who is your senior, sir?
Mr. Mahendra
He
Prasad
is
Gupta.
MP Gupta.
Lord, Mr. Thakkar is leading us, my lord. He is. Wait, you come on this side.
What is the contempt? Which one?
But that, my lord, Bajaj contempt. My lord, Mr. Thakkar is leading us, my lord. He is out of town, and my lord, he has requested me, my lord, to humbly pray before your lordship that the matter be posted after 19th, my lord. That would be, my lord, easier for me to attend. Everybody was appearing in this matter, and your lordship remembers, my lord, there is an aggravated act of contempt. My lord, affidavits were exchanged, my lord, as per directions of this honorable court, and my lord,
What was the last order in the CC? Contempt case?
last order, find out last order. And last order.
12th February. What has happened on 12th February?
Directions were there, my lord, for affidavit.
Filed an affidavit in opposition.
Pleadings have been completed.
Yes, pleadings are complete. My lord, affidavit was also filed. And my lord, reply, my lord, I have served long back. My lord, the reply is yet to be filed before this honorable court. My lord, may file the reply. But it has been served long ago.
Consensus suffering for the plaintiff's petitioner's plaintiff. And consensus suffering for the alleged contender 2 and 3. 2 and 3. What about the 1? Who is appearing for the 1? And appears on behalf of the alleged contender number 1. Full stop. It is submitted that the pleadings in connection with the content CC 102 of 2024 is completed and is ready for hearing. In view of the submission made by the counsel for the parties, this is the matter for hearing on
Any day, my lord, post 19th, if your lordship pleases.
Post
19th of this month, my lord. As per as a comment to your lordship.
3rd of April for hearing.
Deeply obliged.
Next.
This was the directorship matter. Lordship had directed
for the
physical presence, personal appearance of the respondent number 10. He had evaded police service.
You are appearing for
9, my lord.
9. What about the 10 is not here? Notice served.
Notice served, your lordship had last time he evaded police warrants. Your lordship will have a look at my lord's order of 5th of February 2025.
No, there is a report 5th March. When the container was being searched, it could not be learned from the local police as well as from Afsana Khatun, Mukhya Gram Panchayat, Raj Arza, Jamui. Without the name of the father of the contemner, the proper identity of the contemner Azaz Ahmed cannot be fathomed. As there are more than one person, namely Azaz Ahmed. You go to the report. Give the.
It's a copy card. 5th March. Huh?
Opposition
Quite a valid reason. Because there are two.
So you find out the father's name, then the police will do their work.
Look, we have the Aadhaar card. The police had the Aadhaar card. It has the father's name on
the Aadhaar card. Father's name is not there.
Not there.
Father's name is not there in the Aadhaar card.
Father's name has to be there.
Obvious.
Look, while she looks up, there are two aspects. This 10 has been evading. Why am I insisting on 10? Is because 10 has filed an affidavit before this honorable court saying that there is a separate mastermind who is the third party, who is designing everything. Now, Lord, two aspects I may just have to bring to your lordship's notice. In the order that was passed by your lordship in the contempt order, well, there was a status quo with regard to directorship as on 31st of March
until further order.
2024. Until further orders, yes, Manoj. Well, this your lordship will kindly clarify that the plaintiff or the petitioner before your lordship is entitled to change the directorship and shareholder. Because now there's obviously something happening. I want to change the directors and change the digital signature. They've all come up and given affidavits that they have nothing to do with the company. They want to give up whatever right, title, interest they have in respect of the company. That's a separate aspect. Kindly clarifies that this order will not preclude the petitioner from changing.
No, then I have to hear the petition, then your application is to be allowed. That's all.
My injunction application. Yes.
Permanently it has to be.
Permanently it can be allowed.
That is to be taken into. Yes. They have filed the affidavit. Then
yes,
it's not
that's actually a better way of easier. Yes.
That will be better.
Then we can take steps with regard to respondent number 10.
You take steps.
Yes.
And I am fixing what pleadings have been completed.
Yes,
with
my lord,
regard
in
to
the
others.
injunction application.
So I am
Yes.
fixing for hearing.
Yes.
Then kindly direct them to serve the copy original
What?
Of the original suit, my lord. An injunction
Writ of
application.
summons.
Origin, no, he is not a party to the suit. He is a contemner.
Suits you are not the party.
Suit is not a party. He's just
Suit
a
you are not
contemner.
the party.
On the respondents who were there, they have been grafted in breach of your lordship's order. That wrong has been undone. So the injunction application can be fixed on any day.
So and so appearing for the plaintiff petitioner. So and so appearing for the 127 who is appearing. Nobody is there.
Lord, I am appearing, but at present the problem is that Vakalatnama I have got the sign. That is who is not advocate on record. That's why the department has not accepted. So, my lord, I have to file a fresh Vakalatnama.
So and so appearing for the alleged content number 127 and prays for leave to file a fresh wakalatnama on behalf of the alleged content number 127. The leave is granted to file a fresh wakalatnama on behalf of the alleged content number 127 within a week from date.
Yes.
Concept so and so appearing.
Three, my lord. Three chartered accountant.
1 2 1
4 5 6
1 2 4 5 7
7, yes.
1 2
1 2 and 3
and 4 to 7.
Not
Except 3. 1 2 4 to 7. Full stop. So and so appearing for the conduct. It is full stop. The report though. The Deputy Sheriff of Calcutta has filed the report dated 5th of March 2025, wherein it reveals that the police authority of the Superintendent of Police Jamui, Bihar had submitted the report stating the fact that without the father's name of the alleged contemner, the proper identity of the contemner, namely Azaz Ahmed, can't be traced out, can't be identified. And as such, the warrant could not be executed. And as such, the rule cannot be executed.
Let me just interject. That I'll give a copy of the Aadhaar card which doesn't have the father's name but bears the picture of the gentleman.
So you file an application, I will pass appropriate order.
Look, I could just give it to the sheriff here of your lordship, and he will.
That has to give with the supplementary affidavit. I will enclose this Aadhaar card.
Well, look, this is already a part of the record. This is his opposition to the
file a
contempt.
supplementary affidavit. I pass appropriate order. This may be along with this contempt. It has been sent to the police authority for identification.
Very well. I shall do
from the Aadhaar.
I shall.
Executed. Full stop. Counsel for the petitioner prays for time for taking appropriate steps by filing supplementary affidavit disclosing the document for the identification of the alleged content number 10. Full stop. It is submitted that the pleadings in connection with CC contempt application is
over, right?
Contempt application as well as injunction application.
They haven't filed any.
Injunction application also pleadings completed.
Injunction application, I don't think they filed anything.
Nobody has come.
Nobody.
Then what?
They were given multiple opportunities. Nobody's come and filed.
Pleadings in connection with the content application is completed except the contender number 10. Full stop. As none appear, counsel, it is found from the record none appears on behalf of the original defendants, and they have also not used any affidavit in connection with the interim application. This court find that the interim application is to be heard expeditiously as possible. Let the matter appear on on 8th of April 2025 for hearing of injunction application as well as contempt application. It is made clear that in the meantime, if the defendants fail to file their affidavit within 2 weeks from date, the injunction application will be taken up for hearing without the affidavit.
I'm very good.
Like in regard to defendant number 127, we have already filed a supplement.
Already got it. Next.
16, my lord, in respect of GA number 1, I am for the applicant.
Mr. The applicant in GA number 2.
Mr. Ghosh is leading me. Mr.
Lordship, I am appearing for one of the intending.
I am here, my lord.
But I appear for the official trustee.
The sale has already been confirmed in favor of one purchaser. Acted upon partly, the purchaser has paid 25%. I shall start with the facts which are against me. I shall start with the facts which are against me. I am an intending purchaser who missed the bus initially. Now I am offering 50% more the price.
I am for the intending purchaser, my lord. My lord, before they proceed, my lord. May I just...
How many intending purchasers?
Even I am appearing for one of the intending purchasers.
My lord, I am one of the intending purchasers. This is GA1. Mr. Gupta, I understand, has filed an application also as an intending purchaser. So that makes it 2. And I see another learned friend of mine who says that he also appears on behalf of another. So there are 3 intending purchasers
Total 3
who's willing to pay.
Okay, whatever the intending purchaser wanted to do, let the parties are directed to continue with the original order.
Lordship. No, but there is a violation.
Sorry.
They have to, my lord.
You have nothing to do with this, sir.
They have to complete the.
They will do. Who are you? Who are you to say this that they are violated? Who are you?
No, my lord, may I just say this, my lord?
How can you say?
Advertisements were published. There was a full publicity. Nobody came. Now, my lord, one after
Mr. Bose is there. If I will interfere. I will go through your application. Then it will be a further problem. I am dismissing all the application because you missed the bus. Already, this court has accepted the tender and the process is going.
Well, may I just say one thing? May I just say one thing?
Because you have started now, all the total bar members are coming here.
I'll just tell you, Lordship, why. Well, I'll tell you, Lordship, why. Well, this property has been sold. The sale was confirmed by your Lordship at a price of rupees 21 lakhs per kata.
Correct.
Well, admittedly, my lord, there were, when your Lordship confirmed the sale in favor of Mr. Mitro's client, my lord, admittedly, there were total 10 bidders which were before your Lordship.
Correct.
My lord, your Lordship was pleased to consider one of the bids, which is Mr. Jayantu Mitro's client, as the highest bid, and your Lordship confirmed the sale.
Correct.
Well, this was by an order of 28th of August.
Yes.
And thereafter, my lord, your Lordship gave further directions that this is the manner in which payments were required to be made. So when we filed the application, Lord, admitted that this is a position which cannot be disputed by us, that we did not make an offer at the time, my lord, when the possible publication was made. My lord, we were otherwise unaware. My lord, this is in the state of Jharkhand. This property, it's a residential property in the state of Jharkhand. And in view of, my lord, the fact that it is now a smart city, it has become a valuable property. So indeed, my lord, we have missed. My lord, what we are respectfully submitting is that the price at which the sale was confirmed,
yes,
Lord, we say that is not an adequate price. The market price of this property, Lord, could be much higher than the rate at which it has been confirmed. So, my lord, my submission is based on, my lord, it is a trust property.
Yes.
So, my lord, if today there are offerers who are willing to pay a higher price, my lord, the only person who could be prejudiced is the party whose offer has been accepted. Apart from that party, there cannot be any other party who would be prejudiced.
Yes.
So, my lord, that is why I had initially submitted before Lordship, my lord, to come to a level playing field, we must first deposit the money which has already been paid by the successful purchaser, because when we filed the application at that stage, my lord, the entire money had not been paid. My lord, we had filed the application on the 18th of December 2024. As on 18th of December 2024, my lord, the entire purchase consideration had not been paid.
Yes.
So, my lord, today the successful purchaser in whose favor your lordship had confirmed the sale, they cannot take the point that any right had otherwise accrued apart from your lordship's order of 28th of August.
Yes.
Because they had admittedly not paid the entire consideration which came to be paid
This is
after
wrong.
we filed
I'm
the application.
controverting this. This is wrong. We have paid the entire money.
Of course, they have, but after 18th of December, after we filed the application.
Yes.
Not before that. That's what I'm saying. So, well, since that has been all that I'm saying today is, well, today the market price we understand of this property per kata would be in excess of 30 lakhs.
Okay.
So, well, today 30 lakhs and well, considering the total value of the property, well, the trust can get well, overall much in excess of 1 crore. Would be eventually, that would be the eventual benefit that would come to the trust property. So it is under this and it is my limited understanding that it is not the law that a sale on inadequacy of price can never be reopened. But if we can justify before your lordship that there are buyers who are willing to pay a market price and the market price is higher than the price at which the sale has been confirmed. Yes. There is my lord sufficient jurisdiction of your lordship to reopen the sale, and thereafter, my lord, and then the highest bidder takes it, my lord. If they are willing to match our offer, my lord, I'm sure, my lord, they should be given the. So all we are respectfully submitting, my lord, so far as my clients are concerned, that my lord, an opportunity should be given to us, my lord. In fact, my lord, my client we are carrying a check of my lord, sum of rupees 2 crore, my lord, which to prove our bona fide that we are not fly-by-night operators. So my lord, we are willing to put in, and then my lord, eventually, my lord, if there is a higher offer, that we'll see.
Yes.
If I may, my lord, submit for the applicant in GA2, my lord, there was another matter, my lord, almost identical. May I indicate that, my lord, in a nutshell? But here, what happened was in an execution sale, because the judgment debtor was unable to, my lord, pay the awarded amount, the property was directed to be sold. Now, my lord, my learned senior friend's client, Mr. Mitro's client, had participated in that matter and was directed as the highest bidder. Thereafter, certain other persons, my lord, sought to bid, or saying that I will offer higher amount. The court rejected their case. The division bench also dismissed, saying subsequent offer of higher price will not. But in the Supreme Court, the entire thing has been uprooted, saying that since other offerers are there, it has to be republished and there has to be re-auction. May I hand up the Supreme Court's order and also the division bench's order? Kindly takes a look at the Supreme Court once.
Unreported judgment. Give copy.
Give the copy. Give the copy.
I'm putting it. If your lordship is taking a look at the Supreme Court judgment first, kindly turns to the second page. May I place it? Having regard to the peculiar facts and circumstances of the present case.
Reference the key?
Sir, SGDA. SGDA, sir.
Oh, acha. এখান থেকে
Bengal unit.
Shiliguri.
Having regard to the peculiar facts and circumstances of the present case, and as we are informed that applications, inquiries are being received from third parties who are ready and willing to deposit rupees 50 crores and participate in the proposed auction, we deem it appropriate to pass the following order. Then your lordship would see the next paragraph: the Shiliguri Jalpaiguri Development Authority shall, on or before such and such, publish a fresh advertisement setting out the terms and conditions of the auction akin to those fixed earlier, subject to the following. Then each interested party, so the sale has been reopened. Your lordship would see the detailed modalities have been given. The division bench's judgment had proceeded on the premise that, once a sale is confirmed and the bidder has acted, then subsequent offer of higher amount can never, and relying on judgments. But for the Supreme Court judgments, possibly I would not have had much to open.
Whether the sale was confirmed by the court.
Yes.
That case.
Yes, sale was confirmed, deposit was made. Yes, yes. May I indicate? Kindly comes to page 2. The second paragraph. Page 2 of this judgment.
Yes.
The proposed transfer, the paragraph starting with. The proposed transfer by lease was duly advertised in the newspaper after fixing rate of 322 crores as the reserve price on the basis of the circle rate valuation obtained by the special officer. On such and such, he published an advertisement for lease of the property for such and such. 29 June 23 was the last date for receiving bids. Till date, no offer was received by the special officer. When the matter was taken up in court on 20th July, SR SLRL Private Limited, which was a successful bidder, had offered rupees 400 crores together with earnest of rupees 40 crores for the property. Later on, an application by TerraIT was offered rupees 350 crores. However, they could make an earnest deposit of only 1 crore. Although they were asked to deposit such and such, 40 crores. They approached the court for an opportunity to bid for the property. The application was dismissed. On dismissal of the application, the court, by its impugned judgment and order such and such, recommended transfer of the property on lease in favor of SLRL for rupees 400 crores, observing that they were the only intending purchasers available. Then the terms of the sale were set out. So when the sale was confirmed, thereafter, if your lordship kindly turns to the fourth page. The page number is at the bottom, your lordship.
Yes.
May I place from the top, my lord? After a month or so, after the impugned order was made, on or about such and such, one organization such and such made an application before the learned judge. It does not appear from the records that the application was ever moved. Thereafter, my lord, the other applicants have been mentioned. The higher offer of 500 crores is mentioned. And my lord, if your lordship kindly turns over to the next page, page 5, it was shown that the property would have, the market value was much higher. It was 700 crores and the sale was confirmed at 400 crores. The court thereafter, my lord, and may I draw your lordship's attention, my lord, straight away to the operative portion at page 24.
Mr. Mitra, you had appeared.
Yes.
I appeared in this court once successfully.
But I had also appeared and I lost.
I was not taken to the Supreme Court. Had I been taken, my lord, perhaps I would have won.
So, my lord, these were the facts, my lord, on which, my lord, this appeals preferred by the authority, by the SJDA, as well as the other intending purchasers, everybody preferred separate appeals, were dismissed. But Supreme Court, my lord, had undone everything and said that since there are higher offers, those have to be deposited and the bid can be reopened. If your lordship kindly considers this, and my lord,
well, I shall deal with that.
This is the last.
I am ready to deal with this. Yeah, my lord, the first thing kindly note, the market value was 700 crores. Offer was accepted 400 crores. Here, my lord, your lordship has been pleased to record the market value was 4 lakhs rupees per kata. Correct. And my lord, the offer was made at 21 lakhs rupees per kata. After considering all that, your lordship has been pleased to pass the order. My lord, I shall make my submissions on this. This is a, my lord, I am quite confident that I shall be able to convince your lordship that this sale should not be set aside at the instance of my learned friend, either Mrs. Boseskine or Mr. My lord, I submit to your lordship, my lord, this is not a matter in which, my lord, this should be disturbed. After a lot of, my lord, efforts, your lordship has been pleased to obtain the highest bid and thereafter confirm the order. Well, if your lordship gives me time, my lord, I shall definitely, my lord, I am ready to argue the matter. Whenever, if your lordship wants to hear it today, I have got Supreme Court judgments, which is, my lord, my learned friend client is citing a judgment, my lord, where, my lord, earlier judgments have not been taken note of. But in any event, the market value was said to be 700 crores and offer was accepted at 400 crores. Yes. That was the reason why, my lord, it weighed with the learned judge.
Only one person was there.
Yes.
Only one person.
That's
there.
right.
Here the 7 persons.
That 3 persons have come.
3 persons have come here.
I but kindly see that their contention is not that sufficient publicity was not given. The largest selling, then the thing was published. Court waited, not once, twice, thrice, 4 times. My court waited, adjourned the matter, and thereafter, my lord, it was done.
Yes.
And my lord, Supreme Court has unequivocally said, starting from 1970, the judgment, and that has been followed throughout up to 2024-22, which I have got Supreme Court judgment, fully reasoned, well-written judgment. Whenever your lordship has it.
The publication was not wide.
Hello.
Publication
well,
was,
would it be your lordship pleasure that we deposit the money so that there will be a level playing field?
All the 7 persons of participants.
10 persons.
Sorry, 10 persons.
10 persons.
Paragraph 8 and 9 of the application, but I have stated.
I shall meet all my learned friends' clients' contention. I'm quite confident that I will be able to persuade your lordship.
You will use the affidavit.
One affidavit we have filed, another.
Well, we have filed an affidavit to one of the applications. Well, what of the other applications are coming? Well, yes. I have never seen, my lord, so many applications coming on.
That's what I'm telling. If it is a floodgate. To all bodies.
I don't know who is setting up these people.
But that is why I was saying, my lord, so that fly-by-night operators don't come in, your lordship direct that whoever is interested must put in at least whatever, 1 crore, 2 crore, and then your lordship will decide. Because so that, my lord, the unnecessary who are not genuine buyers, so they will go away.
So and so appearing for the plaintiff, petitioner, sorry. So and so appearing for the petitioner, so and so appearing for the purchaser, and so and so appearing for the intervener, namely
Third one to service
intervener, namely
Lord, I appear on behalf of Aditya Kumar Soni.
Aditya Kumar Soni.
That is GA1.
So and so appearing for the intervener,
International Commerce
International Commerce Limited. Full list. The intervener, namely Aditya Kumar Soni, has filed an application being GA1 of 2024, and the second intervener, namely International Commerce Limited, has filed an application being GA2 of 2024. Full list.
I am filing affidavit to Sony's application.
The plaintiff, the petitioner, the purchaser has filed affidavit in opposition in connection with GA1 of 2024.
Yes.
After serving the copy to the learned counsel.
I shall file affidavit to GA2 and GA3 has not been served.
For the intending purchase, for the intending and for the intervener. The counsel for the petitioner, counsel for the purchaser, press for time to file affidavit in opposition in connection with GA2 of 2025. Let affidavit in opposition file within 2 weeks, 1 week.
I will be able to file it. But
1 week.
When is it your lordship's convenience? Fix a date, I shall come.
Let the matter by 1 week, reply if any there to be filed within a week thereafter. List GA1 and GA2 for hearing on 1 week, 2 week बोला ना?
एक कॉपी दे ओके जजमेंट
सर दे दीजिए
3 तारीख को देखो 11:30 है क्या?
Could it be any day after the 5th, my lord? My learned
I'm the copy date.
9 तारीख को
I'm the copy date.
9th April at 11:30.
I am appearing for the one of the intending purchaser, lordship.
Another one.
File an application.
You do one thing. You made a publication. What any other intervener, you come with all application. Then the court will hear it.
Let the name be recorded.
9th of April.
Eta tumi pabe. Name should be recorded.
Next.
Grateful.
Your lordship has fixed it on 9th April.
9th April.
9th April.
Lordship.
I appear for the plaintiff petitioner, my lord, for an interim trial. Lordship will remember, my lord.
Item number?
I was making submission.
Item number?
36.
The only thing is that, my lord, when we are approaching Holi, my lord, I believe, my lord, this matter is going on today for the 4th day. 3 days have gone, and well, this is for the 4th day. And I think Mr. Sen had
2 days have
submitted.
gone.
Mr. Sen had submitted, my lord, for half an hour, and then it is all about Mr. Banerjee and Mr. Banerjee. It makes me remember, my lord, in our older days, my lord, when, my lord, we had no case, our seniors used to say carry bags and keep it on the top of the table so that the judge will see and it will go on for hours, or, my lord.
That is what you also do. I have heard.
We used to say in the court, the hathi ke daant dikhane ke
Yes, yes. Now, my lord, I only feel that, my lord, Mr. Banerjee will now conclude in 15 minutes time, because we know that today.
That's why it is fixed today for the matter.
Yes. Otherwise, my lord, I believe he will carry on till 12:25. So today is also.
I have also seen him making submission interlocutory matters hours and hours. So
that is
happens.
required.
Okay,
required.
This might also be required for
Okay,
objecting to your
continue.
case.
No problem. Yes.
My lord, is it my lord's pleasure that defendant number 3 will again be called?
You are the culprit. I will call you. Next.
He has
You
gone
are-
handing over possession and saying that now I should be.
May
Yeah,
I
the main-
just, my lord, factually just, my lord, since he had made factual submissions, he is only to, my lord, cite few authorities on that position aspect. The factual position, may I just clarify? Because if I am not there, my lord, I may get stuck, my lord. That's
Yes.
the reason.
Only you give the answer.
Yes, ma'am.
With regard to the agreement entered between You and the defendant number
Yes.
2.
My lord kindly takes note of 3 facts. There was first MOU referred to in the second MOU which he had placed the other day, which is a MOU of 7th of September 24. Lordship will have that document.
Yes.
This MOU is the second MOU. Kindly marks this, my lord.
7 September.
7 September.
Yes.
Kindly takes the 7 September MOU.
Hmm.
I will show 2 recitals from here, my lord.
Yes.
My lord kindly comes to page 78, my lord.
78 of
Yes.
the application.
Oh, I'm sorry, my lord. Kindly comes to internal page 3 of the MOU.
Yes.
My lord, the second recital, whereas the second part was facing financial problem, approached first part for friendly advance to start up bar cum restaurant business. This was the understanding. My lord kindly comes to the next page, internal page 4. At the top,
Yes.
according to the previous MOU, party of the first part have provided a sum of rupees 1 crore as friendly accommodation advance to the second part. So 7 September is the second MOU, previous MOU, 1 crore advance to me. This 1 crore was to be repaid, my lord, the third recital. According to previous MOU, second part agreed to pay first part amount of 1 crore only at 4 lakhs per month for a period of 2 years before getting license of the bar cum restaurant. Next recital, according to previous MOU, second part has agreed to pay to first part remaining part of the amount of 1 crore at 5 lakhs per month only. So, my lord, 1 crore to be repayable, my lord, in 2 parts. Before bar license, I get, my lord, before I get the bar license, 4 lakhs per month. After I get it, 5 lakhs per month. Then, my lord, kindly comes to internal page 5. Habendum 1. The party of the second part, confirming party, has agreed to transfer absolute right title interest of the said company, Seokjin Hospitality, along with possession of the said bar cum restaurant, Seoul story in favor of the parties of the first part in equal share. This is what he was relying upon. Second, my lord, clause. Second part and confirming party has agreed to call an EOGM by giving 3 days notice. The, my lord, business to be transacted in the EOGM is also mentioned. 50% transfer of the share of, my lord, both the, my lord, persons in favor of both the, my lord, defendant numbers 1 and 2. And 4 is to transfer physical possession. No document has been shown in course of arguments by Mr. Banerjee to establish that either, my lord, this MOU has been acted upon for the purpose of transferring my 50% share to D1 and D2, or, my lord, handing over possession of the, my lord, bar cum restaurant to, my lord, D1 or D2. There is no document. And he relies, because one of his argument was, though I am not appearing for the plaintiff, one of his argument was that there is nothing to show except, my lord, an agreement that possession was taken, or except a letter that possession was surrendered. My lord, the same analogy should apply for him. There is no, my lord, no document shown by Mr. Banerjee which would establish that I had acted in terms of this agreement to hand over possession to him, or to give him transfer 50% to D1 and 50% to D2.
Yes.
Now, my lord, very important one document I want to show, because this stand was taken. My lord, after 7th of September, my lord, 2024, an FIR was lodged, which is, my lord, 13th of October 2024. My lord, kindly seize the stand in the FIR.
Who has lodged?
My lord, Mr. Banerjee's client.
Against you.
Against me. My lord, it kindly takes the second page, my lord. Lordship will find the date 13th October 2024. Signed by Protapaditya Lahiri. Lordship has found that. Second page of, my lord, I have just given the, my lord, complaint page. I have folded that, my lord. Lordship has found that.
Yes.
Now, my lord, kindly comes to the first page.
Second page, date.
Second page, Lordship will get the date.
13th
October. Now comes to the first page of the complaint, which is addressed to the OC Shakespeare Shoreni Police Station. Complaint and request for lodging FIR against Peter Jong Seok. Seok Jong is my client. Mr. Prashanto Khara, the other shareholder, 1%, and others.
Who is Nilanjan?
Nilanjan is, my lord, according to him, a mediator or a friend of mine.
Okay.
My lord, middle of that page, first paragraph. After, my lord, he refers to the MOU 4 lakhs and 5 lakhs per month, the way it was to be repaid thereafter. But he failed to make his payments as per the agreement. Lordship has found that?
Supposed to pay every month.
My lord, middle of the second paragraph. But he failed to make his payments as per the agreement and he stopped taking my calls and did not respond to my messages.
Yes.
However, his friend Nilanjan acted as a mediator, indulged me into second agreement at Seoul Story, where he handed over company to me when the business was about to be shut for non-payment of 3 months rent, electricity, maintenance, restaurant business. So to restart restaurant, I paid all necessary money to the building authority to reopen the business, sum of rupees 17.5 lakhs, which was supposed to be paid by Seok Jung. In lieu of this fresh agreement, he agreed to work for me for 9 years to repay his debt to me for a monthly wage as per the agreement. So this is what he is saying.
Yes.
He agreed to pay 2.5 lakhs monthly here on, but again he failed to pay on so and so. So I tried to contact him several times. He is unreachable. Above mentioned persons, namely such and such, made up a criminal conspiracy and misappropriated the entire amount. Kindly takes note of the amount. 1 crore 17 lakh 50,000. 1 crore is under that agreement, my lord, the first agreement which he has referred to in the 7 September MOU, and 17 lakh 50,000 which he says he paid me so that I could repay the electricity and other charges, my lord. This is his allegation. Yes. And his allegation is that I have failed to repay, therefore he is lodging the complaint. So, my lord, no question, my lord, because allegations were made also against me that I have actually not handed over possession. My lord, I had, my lord, Mr. Sen's, my lord, petition contains those documents. So it was not necessary for me to, my lord, place those documents independently. And it is my specific instruction from my client that I had handed up, my lord, possession to the plaintiff. Yes. And, my lord, whatever disputes and differences are there, que, my lord, or inter se defendant numbers 1 and 2 and the defendant number 3, this is only, my lord, a financial transaction. I have my own defense, my lord, to this transaction, which I am not required to disclose here, my lord. As and when the need arises, I will, my lord, if, my lord, that occasion arises. Okay. I just wanted to clarify this position. Thank you.
From the submission of Mr. Dotto, one thing is very apparent, that the collusion which I was hinting on the last occasion, that is very apparent.
Yeah.
Defendant number 3 being a lessee, not in a position to repay the dues, brought our client as an investor. We paid 24 lakhs within September to December 2024, which has not been disclosed. The plaintiff has accepted from my account. In their letter of 21st November, they admit that I am an incoming lessee to the property and a fresh lease agreement will be entered into with us, which they have not done. Now, the fact is that in his admitted position, your lordship knows the difference between license and a lease. Once you lease out the property, you lose actual physical control. You might have constructive possession through the lessee, but you lose actual physical control. So from 4th July 2023, they lost actual physical control. Now here what they have done, since the defendant number 3 was not in a position either to run the restaurant even after taking money from me or to pay the lease rent, they entered into a backdated some collusive agreement that I will hand over the property. Now since somebody else is in possession, now on the basis of this letter you go before the suit court and seek a decree for eviction, though only declaration injunction has been sought, but the prayers has been couched in a manner so that if it is granted effectively, it will amount to my dispossession. The fact is that what I was submitting, your lordship, I will cite judgments today only on the basis of mere pleadings that the plaintiff has access, physical possession to the property, and disturbing their access and restraining their access will not do. Materials has to be shown. Now, today, your lordship finally first sees the order and compared the prayers made in the injunction application with this suit. Whatever prayers in injunction application they are seeking for, if granted, that will amount to a final writ.
Yeah.
Kindly take the prayer in the injunction application first. Page 22 onwards.
Yes.
And the prayers in the suit are from page 143. If your lordship keep them side by side, it will be easier for your lordship to compare.
Page 143.
143, the reliefs in the suit starts.
Yes.
Volume 2, your lordship.
Yes.
Your lordship will straight away take page 144, prayer C.
Yes.
Prayer C, if your lordship sees, decree for perpetual injunction against the defendant's main agent servants from restraining them from illegally encroaching or entering or trespassing into the stored property and putting their padlock.
Yes.
Your lordship will compare this with prayer A in the injunction application. Order of interim injunction against the defendants, restraining them from illegally encroaching, entering or trespassing into the stored property and putting their padlock.
Yes.
So if this relief they are pressing for, if granted, this will amount to a final relief as they are prayed for in the suit. Then prayer B. This is what I believe Mr. Sen has harped upon for the interim relief. This is the prayer. Order for interim injunction restraining the respondents, their main agents, and representative from unlawfully obstructing the entry or access of the plaintiff and or his main agents, representatives and officers into the suit property, and from wrongfully interfering with the right of the plaintiff, lawful and peaceful control and possession and occupation of the user of the suit property. Now, lordship will compare this with prayer D, exact same relief prayed for in the suit as a decree for perpetual injunction.
Yes.
Today, if this relief is granted, that will amount to finally decreeing the suit.
Yes.
Then, your lordship, the next prayer C in the injunction application, order for temporary / interim injunction directing. This is in the nature of a directly and ad interim mandatory injunction directing the defendants, particularly the defendant 1 and 2, to remove their main agent servants and assignees and representative from the vicinity of the suit property. So this is, your lordship, is similar to prayer E in the plaint.
Yes.
Mandatory injunction directing to remove the main agent servants. If
Yes.
this relief is granted, this will also amount to finally decreeing the suit.
Yes.
Prayer D. Order for interim injunction restraining the defendant's main agents from unlawfully obstructing the entry or access of the plaintiff herein and or their officers into the suit property, wrongfully interfering with the lawful possession. This is exactly the verbatim copy of prayer F in the suit. Same.
Yes.
So apropos to this, your lordship, I will like to rely upon a judgment which says that at the ad interim stage, for obtaining an order of ad interim mandatory injunction, prima facie case is not enough. Even though for prima facie case you have to prove materials, you have to make out a case higher than the prima facie case. And for that, your lordship, at the ad interim stage, final relief cannot be granted. Your lordship will take the judgment of 2004, volume 7, SCC 478.
2004.
Volume 7, SCC 478.
Yes.
It's a 3-bench judgment, very short judgment. Just a second. Yes, sir. Now, she will take paragraph 6 onwards. It's a 3-bench judgment of Honorable Supreme Court. Paragraph 3, 6 onwards, sir. 6. Shri Jayadev Gupta, the learned senior counsel appearing for the appellant, submitted that it is an admitted fact that the appellants were in possession of the suit property and the suit itself was for eviction and for possession. He contended that there were tribal issues as to the nature of possession. Hence, a decision to hand over possession or not could not have been taken only after deciding the issue on the basis of law applicable to such relationship. Learned counsel pointed out that the trial court has for a good reason rejected the interim application of the plaintiff, holding that allowing such application will amount to grant of a decree even before trial, which is normally is not permissible in law. He submitted that there are no extraordinary circumstances on the facts of the present case which could have permitted the appellate court to exercise its extraordinary jurisdiction of granting interim possession in favor of the plaintiff in a suit for possession. He placed reliance on the judgment of the court in case of Dora of Kawa's warden. Your lordship, this judgment I placed on the last occasion, 1990, so I'm not repeating. Then paragraph 9. Having considered the arguments of the learned counsel for the parties and having perused the documents produced, we are satisfied that the impugned order of appellate court cannot be sustained either on the facts or in law, as noticed by the court in the case of Dora of Kawa's Vasanji. It was held that an interim mandatory injunction can be granted only in exceptional cases, coming within the exceptions noticed in the said judgment. In our opinion, the case of the respondent herein does not come under any one of those exceptions and even on facts. It is not such a case which calls for issuance of an interim mandatory injunction directing the possession being handed over to the respondent. As observed by the learned single judge, the issue whether the plaintiff is entitled to possession is yet to be decided in the trial court. And granting of any interim order directing handing over of the possession would only mean decreeing the suit even before trial. Because Joshi, this is what I'm on. Joshi, since they're asking, they are saying that they are in possession, I'm hindering their access. I am saying that you are never in possession from the date you have executed the lease deed, and mere execution of a letter by a lessee does not prove that you are in actual physical possession. So status of possession is disputed. So today, if an ad interim injunction in the nature that I will not restrain their access is granted, effectively, your lordship, they get access to the property. That means they get actual physical possession of the property. They acquired a status that they remain in possession of the property pursuant to this order, because they will continuously access the property, which they are not as on date. So today, if that order is granted, that it amounts to my dispossession. So without issuing the issue of as to who is in possession, interim mandatory injunction should not be granted. Once the possession of the appellant, either directly or through his agent, is admitted, then the fact that the appellant is not using the said property for commercial use or not for beneficial purpose of the appellant has to pay a huge amount of damages. Paragraph 10, for the foregoing reasons, we are of the considered opinion that the appeal court erred in reversing the order of the single judge and granting a mandatory injunction. In view of our above findings, we think it appropriate that even the appointment of receiver be at the interim stage or otherwise to supervise the possession of the property in question is also unnecessary. The court held that without deciding as to who is in possession, relief of possession could not be granted because that will amount to finally decreeing the suit. Then, your lordship, this next judgment is 2005, 9 SCC 733.
Same principle. Same principle.
জানি না দেখো পড়ছি
মাল্টিপ্লাই করছি
প্যারাগ্রাফ 8 to say the list paragraph 8 here. Paragraph to say the list. Your lordship has got it. The approach of the learned single judge and the division bench is judicially unsustainable and indefensible. The final relief sought for in the writ petition has been granted at the interim measure as an interim measure. There was no reason indicated by the single judge as to why the government order was to be ignored. Whether writ petition was entitled to any relief in the writ petition has to be adjudicated at the time of final disposal of the writ petition. The court has on numerous occasions observed that final relief sought for should not be granted at the interim stage. The position is worsened if the interim direction has been passed with stipulation that the applicant government has been ignored.
Yes.
Time and again, the court has deprecated the practice of granting interim orders which practically give principal relief sought for in the petition for no better reason than that of a prima facie case having been made out without being concerned about the balance of convenience, the public interest, and the host of other considerations. Now, Your Lordship, the next is on the principles of another judgment on the principles of ad interim injunction, saying that no new right can be created by an order of court if the position of the plaintiff is disputed as on the date of filing of this suit. Now, this is the Calcutta judgment, very celebrated judgment, Nandan Pictures, 1956 Calcutta. I will finish within 15 minutes. I will not take much time. Side comment to bhalo karo, ঠিক আছে, no problem.
আমি ডাইরেক্ট কমেন্ট করছি, সাইড কমেন্ট না।
সাইড কমেন্টই করছি, ঠিক আছে। এই তো দিচ্ছি, আমি দিচ্ছি। The division bench judgment. Lordship, paragraph 3, kindly have a look.
On what?
Lordship, this is on the ground that on what principles ad interim injunction, if it creates a new right, the court should not grant it. If the position of the parties as on the filing of the suit is disputed, then. So, Mr. They who appeared for Indira Cinema contended that somewhat favorably that even regarded as the mandatory injunction, the order has been made with the jurisdiction and has been properly made. As far as I could understand him, he did not ultimately persist in the contention, but based his defense on the order of another ground to which I shall advert in a moment. It appears to me that regarded as a mandatory injunction, the order complained of cannot be held to have been properly made. I need not refer to any collateral questions to which Mr. Mayer referred, because each of them is a controversial character and remains to be decided in the suit or in the application for an injunction during the pendency of the suit, which is still pending before the learned trial judge. I consider it sufficient to point out that it is only in very rare cases that mandatory injunction is granted on an interlocutory application, and instances where such injunction is granted by means of an interim order pending the decision of the applicant are almost unknown. I do not wish to say, because it is not necessary for the purpose of this case to say so, that in no circumstances will the court have jurisdiction to issue an interim order of mandatory character pending the disposal of an application for injunction. Injunctions are form of equitable relief, and they have to be adjusted in the aid of equity and justice to the facts of each particular case. No court therefore ought to lay down absolute proposition where such are not necessary and for fetters for itself. At the same time, I may point out that the accepted principles have been, and what has been according to the reported cases, the practice of courts. It would appear that if a mandatory injunction is granted at all on an interlocutory application, it is granted only to restore the status quo and not granted to establish new state of things differing from the state which existed as on the date when the suit was instituted. So court has to come to a finding whether at all he was in possession or not. Then only, Your Lordship, the question of protecting the status quo arises. No new right has to be established. Now, Your Lordship, on the principles, what prima facie case? Your Lordship, if a prima facie case has to be made out,
Yes.
strong materials have to be there on record. Your Lordship will first see the judgment of a division bench of our Calcutta High Court, 2004, Volume 1, CHN 267. So she will take paragraph 8 of the judgment. From the discussions above, Your Lordship has got paragraph 8, Your Lordship. Of this judgment.
Yes.
From the discussions above, it is evident that the plaintiffs have abused the process of law and that the court has not kept itself within its bound. In fact, the court has a duty to find a prima facie case on the basis of materials placed before it. It cannot act mechanically simply because jointness have been claimed in between the parties related to by blood. The court has to scrutinize the averments made in the plaint and the application for injunction and the materials placed before it. While considering the existence of prima facie case, it has to apply its mind. It cannot proceed cursorily. Then, Your Lordship, the facts has been stated. In regard to this case, Your Lordship, what are the consideration for prima facie case? That materials has to be there, and court has to scrutinize and peep into those documents whether those are genuine for the prima facie case or not.
Yes.
My Lordship, the next judgment which I will rely upon is on the fact that ad interim injunction can only be granted after the court comes to a finding regarding the status of the parties on the basis of materials produced. Otherwise, it should not be granted. 2006 Supreme Court judgment. Your Lordship, this is 2006, Volume 3, SCC 312. Lordship will straight away take Your Lordship the
paragraph.
Yes, Your Lord. Ten onwards. It is seen that after the remand, the parties produced some evidence. The additional district court set out the arguments on the side of both the parties. Your Lordship will first take paragraph 6, sorry. Paragraph 6. Page 317 top. Page 317 top. Unless a clear prima facie finding that the plaintiff was in possession on those dates entered, an order of interim mandatory injunction could not have been passed, and as such order passed would be one without jurisdiction. And an interim mandatory injunction is not a remedy that is easily granted. It is an order that is passed only in circumstances which are clear and prima facie materials clearly justifying a finding that the status quo has been altered by one of the parties to the litigation, and the interest of justice demanded that the status quo ante be restored by way of an interim mandatory injunction. Keeping this principle in mind, it is necessary to see whether in this case of the hand, the additional district judge was justified in passing the order of mandatory injunction or not. So we will see paragraph 13 once thereafter. The jurisdiction under Article 227 of the Constitution may be restrictive in the sense that it can be invoked only to correct the errors, but when court asks itself a wrong question or approaches the question in an improper manner, even it comes to a finding of fact, the said finding of fact cannot be said to be one rendered with jurisdiction, and it will still be amenable to the correction at the hands of the High Court under Article 227 of the Constitution. The failure to render the necessary findings to support its order would also be jurisdictional error. Here, the jurisdiction to grant an interim mandatory injunction could be exercised on entering a finding that on the date of order for maintaining status quo was passed, the plaintiff was in possession, and the day after the interim order was passed, he was in fact dispossessed. The interim direction is to maintain status quo was an ex parte order. The court has to come to a specific finding on the materials as on the date of filing of the suit, his possession in the suit property was uncontested and he was in possession. Last is that since I have submitted that the plaintiff, even after accepting the sum of 24 lakhs that has been suppressed, for a purpose this money was received so that I cleared their dues and I come in. So Lordship, injunction is in the form of equitable relief. If he suppresses material facts, the plain there is no averment that 24 lakhs has been received. If he suppresses that material fact, then he is not entitled to an equitable relief on the principles that a party who seeks equity should also do equity with the court. On this proposition, Your Lordship, I will rely upon a judgment if Your Lordship kindly have a look at this. 2012, Volume 12, SCC 133. Paragraph 44 to 46.
Yes.
The appellants have not approached the court with clean hands and therefore not entitled to relief. Whenever a person approaches the court of equity in exercise of extraordinary jurisdiction, it is expected that he will approach the court not only with clean hands but also with clean mind and clean heart and clean objectives. Thus, he who seeks equity must do equity. The legal maxim thereafter has been referred to. Your Lordship, on the last date, we have got certain photographs asked that whether there is any proof that I am there in the property or not.
Yes.
Whether I am in possession of the property or not. These are the photographs which we have taken. This with the newspapers. The dates are not very much evident, but these are of recent dates. Your Lordship, just after the suit has been filed, Your Lordship, since Your Lordship posed a question, Your Lordship, we have taken certain photographs. Copy.
After the suit is filed, you are in possession.
Yes, Your Lordship.
After
I am still in possession. Your Lordship, what I propose to Your Lordship today, Your Lordship, I am very confident that I am in possession. They are not. I can show it. If Your Lordship today appoints any officer of this court to go and visit and make an inventory and file a report as to who is in possession, the things will be cleared.
Police report is otherwise.
Police report does not say that I am not in possession.
No, police report said that it is locked and both the parties claiming possession.
No, locked. Your Lordship, what is their condition? I have put my padlock. My padlock is there. If Your Lordship sends anyone, Your Lordship will see that my person is coming and opening the padlock. The key of the padlock is with us. Key of the padlock, it's not their padlock. If Lordship sends anyone, the things will be very clear. that to find out as to who is in possession. Shobhi ache? Acha. So these are the documents that so that we are in possession, and your lordship, there is a recent restaurant billing as well, just few days before filing of the suit.
What is the date?
So that the newspaper person to which this photograph we have taken, that they have not been able to highlight the date.
Photograph means?
The photographs which we have taken with our personnel therein, your lordship, they have taken the photographs with the newspaper only to show on which date the photograph was taken. But at the time of taking the photograph, they have failed to highlight the same. Documents the billing হয়েছে। ফুলের এরম ভাবে দেবো? I will just hand over a document issued by Zomato which shows that the billing has been made with regard to the food from the restaurant. You will see the two dates. Zomato billing.
Zomato bill.
You will see the transaction date.
আমাকে তো একটা কপি দে কি খেয়েছিস
এই তো।
আমাকে দে
আমি খাই
খেয়েছি আমাকে দিয়ে
তোমার অন্য লোকেরা খেয়েছে
যে খেয়েছে আমি দেখলাম এটা যদি
So,
পজিশনে
admittedly, your lordship, this is plaintiff was not running the restaurant and the defendant number 3. It is the case that the defendant number 3 has handed over the property.
much.
What is this?
So this is the transaction date, your lordship. This has been forwarded by Zomato.
To whom?
Your lordship, to my client.
To associates Malik.
So that the restaurant is being run from the restaurant, from the property. So I am not repeating with the documents where I have already shown that they've admitted the fact that I was an intending lessee. The judgment which they have cited, one judgment, only that. This 2019 volume 14 HCC 1. This judgment also helps our case, the contention which I was trying to put in.
Which one?
This 2019 which they have cited, 2019 volume 14 HCC 1. This was a case, your lordship, the issue was as to who will be appointed as the chief mutawali under a particular waqaf.
Yes.
So lordship will see paragraph 57 helps our case, and this does not say anything new which I have not said.
Yes.
Paragraph 57, your lordship.
Yes.
The grant of mandatory injunction is not prohibited. Even in Sabir Narayan Bhojwani case, it has been held that unless a clear and prima facie material justifies a finding that status quo has been altered by one of the parties, the order of mandatory injunction can be given. So court has to find that the status quo has been altered. Their status in the property regarding possession has been altered by me. Then only status quo ante in the nature giving them access can be granted. They have cited paragraph 58. The ad interim injunction is to be granted not on the asking but on strong circumstances, so that to protect the rights of the interests of the parties as not to frustrate their rights regarding the mandatory injunction. In Deoraj versus State of Maharashtra, this court held that the court would grant such an interim relief only if it is satisfied that withholding of it would prick the conscience of the court and to do violence to the sense of justice, resulting in injustice being perpetuated throughout the hearing. At the end of the court would not able to vindicate the cause of action.
Yes.
And thereafter they have relied upon another judgment which your lordship will see strong prima facie case on materials has to be made out. And 59, your lordship, this was granted because the position of the parties were admitted as on that date. That's why interim injunction was granted in this matter. Kindly see paragraph 59. Here the position of the plaintiff is disputed. The argument that under order 13 and 1 and 2, the court has the jurisdiction to maintain status of the parties on the date of filing of the suit or on the date of passing of the order, but cannot direct the parties to do something which was not in existence at the time of filing of the suit, which is not a general rule or universal application. The nature of the orders claimed by the appellant are not passed ordinarily in a routine manner, as the plaintiff is required to have a case which should have higher standard than a mere prima facie case. But in view of the agreement between the parties, as recorded by the division bench in an earlier round of litigation, The primary question was agreed to be that who is to act as chief mutawali. Both the learned single judge and division bench have examined the question even before the court. The parties have argued primarily on the question that who shall be the mutawali. Therefore, in prima facie opinion would lead to a consequential order in respect of management. So there was an agreement before the division bench that who will be chief mutawali. In spite of that, somebody else was claiming. So on the basis of uncontested position, this order was granted. Your Lordship, on that, those and Your Lordship with possession and definition, Your Lordship, only with regard to the fact that Your Lordship is just one more submission. Possession, which I said that possession are of two types. Actual, physical or constructive. Actual physical means I have a control over the property. And constructive means I have control, but I do not have physical control, but through the person who is in possession, either the lessee or a tenant. Your Lordship will only see the definition which I am handing over of law lexicon regarding the definition of possession. Say second page, Your Lordship. Yes. Possession is a detention or enjoyment of a thing which a man holds or exercises by himself or by another who keeps or exercises in its name. Your Lordship, the second page, Your Lordship, right at the bottom. Bottom left, Your Lordship. Left side bottom.
Possession defined, yes.
Possession, Your Lordship, it is mentioned in quotes, Your Lordship, possession defined. Physical control, whether actual or in the eyes of law, over property, the condition of holding at one's disposal, the area in one's possession. Possession is a detention or enjoyment of a thing which a man holds or exercises by himself or by another who keeps or exercises in its name. Possession is of two ways, either actual possession or possession in law. Actual possession is when a man entereth into lands or tenements to him descended or otherwise. Possession in law, when the lands or tenements are descended to a man and hath not as really actually and indeed entered into them. Possession is law is that what in eye and consideration of the law is deemed to be in possession is as much as he is liable to every man's action. Yes. Judgment, yes. Lordship, I am not formally placing the judgment, but handing over to Your Lordship and to the other side with regard to what is the meaning of possession and what does actual and physical possession means. One is the 67 Supreme Court, paragraph 6 and 7, Your Lordship will just note. And Your Lordship, the other one is AI 65, Patna 160. But আমার কত?
মোড়া আছে, হ্যাঁ। আরো আছে আরে? আরো? এই নাও, বই থেকে কি?
Paragraph 21 only, Your Lordship, sees one para of the 65 Supreme Court Patna judgment, and the Supreme Court judgment is para 6 and 7.
Yes.
Possession, paragraph 21 of the 65 Patna judgment. Possession means simply owning or having a thing in one's power. It may be actual or constructive. Actual possession exists when the thing is in immediate possession of the party. Constructive possession is that which exists without actual personal occupation. So they might be in constructive possession, but immediate possession of the property is not with them. So Your Lordship, these orders should not be granted. Your Lordship will kindly give us a chance to use an affidavit within the shortest possible time.
My Lord, as I have said on a lighter note, I was correct, my Lord, at the first instance. I think, my Lord, at least 10 judgments he has shown. So if it was books, my Lord, it should have covered, I think, the whole table, my Lord. My Lord, let me start with the document as to, my Lord, why one should not mislead the court. Kindly takes, my Lord, the first document, last document that he gave, although this shouldn't be looked into even because Lordship should see the plaint only. My Lord, that Zomato, my Lord, Zomato document. Kindly takes the next page. When you don't have a case, I understand, my Lord, that I have to drag, but then not in this way. My Lord, kindly, my Lord, takes it. Yes, I will use it. I'll show it.
That is not expected. Don't use this.
My Lord, kindly takes the document. My Lord, the next page. Kindly sees the date and time. If Lordship can see it, my Lord, it's too, my Lord, small even to read it.
Yes.
When one is handing over documents, one should look into it. My lord, kindly sees the date. 5th of January 2025. Lordship has seen it. Kindly sees, my lord, this document, which is the relevant document. This is a mail sent, my lord. But this document, second column, is very small, 5th of January 2025. Now, what is the date of surrender in the plaint? 17th of January 2025.
Yes.
So, what is the dispute? I'm saying that from the date that I'm in possession, there is no business there because I am in possession. Obviously, on this date, there was. So, why this document is shown to the court?
Yes.
You are not in possession as of
But
that
this
date.
I don't like. I never uttered a word. Please take your seat.
Making side comments.
Please take your seat. My lord, kindly sees this document. Why is it then been shown? The plaint does not say so. Plaint says from 16th I am in possession. This is the 5th of January. Second, my lord, this document. This document kindly sees if I stand in front of Mr. Puritosh Sinha's flat or house and take a photograph, will that house will become mine?
He is going to file a caveat against it.
Exactly. But after Holi, not before Holi. But this is dangerous then. A photograph taken in front of a house or a place that will give the possession to that person. No date, nothing at all. When the police report says otherwise, complaints filed by him.
Yes.
Plethora of judgment shown to my lord on injunction. We have all got educated, my lord, on possession, definition. But this, and my lord, prima facie, my lord, one would always, my lord, show the date. There is no date even in this.
Can I be excused, your lordship, if your lordship leave? Okay.
There is no date even shown in this. My lord, this document will, my lord, at an interim stage, when I am establishing a prima facie case before my lord, will, my lord, stop me from getting, my lord, a possession which is stopped by 2 persons sitting in front of my gate.
Yes.
Then, my lord, kindly takes the judgment. Let me deal with them first. What he has shown. I did not want to show this, but then this is very unfortunate since he showed that the pleading is there. My lord, kindly takes this document. Here, my lord, copy. Here, my lord, this is from the CCTV camera. Kindly takes the date. It's all, my lord, 16th of January 2025. Kindly sees the time. At 11 o'clock at night. How, my lord, they are trying to take away possession by, my lord, kindly sees, my lord, getting, my lord, people to break the lock. And that's my pleading at paragraph 33 of the plaint. This is from the CCTV camera with the date and the time. Defendant number 2 trying to break open on a date after surrender. What more is required? And that's entirely pleaded at paragraph 33 of my plaint. Well, this is page 138. Apropos this, kindly sees, my lord, paragraph 33, page 138.
Yes.
Date, time.
Plaint or
Plaint. I will not show anything else, my lord.
Yes.
I will follow the principle, my lord, of age-old, my lord, that one has to look into the plaint only. Page 138, paragraph 33.
Yes. 138?
Yes, page 138 of my petition, my lord, paragraph 33, my lord. It starts with the sentence, my lord, in the circumstances, plaintiff was shocked and surprised when during the late evening at night of January 16, 2025, and thereafter during the morning of January such and such, repeated attempt to disturb plaintiff's possession of the suit property.
Yes.
And this is, my lord, the complete picture of that time and everything. He's standing there. Now, my lord, kindly sees the judgment that he's relying upon, my lord. My lord, kindly takes this judgment of 2005 9 SCC. My lord, it's good to, my lord, become educated. My lord, I'm sure I will over the evening, my lord, call him up and, my lord, get educated, my lord. My lord, kindly takes 2005 9 SCC, page 733. What is this matter all about? Paragraph 4 kindly sees the last, my lord, 3 lines. My lord, just now handed over. My lord. This is a writ petition, writ jurisdiction, 226. Now, my lord, kindly sees, my lord, the last 3 lines of paragraph 4. Writ petition number such and such was filed by the respondent inter alia seeking for a direction to the present appellants to appoint the writ petitioner in any suitable class 4 post under dying in harness rules. Learned single judge, while issuing notice, directed the competent authority shall consider the writ petitioner's claim of giving compassionate appointment. How is it relevant to the facts of this case? One has to look into the facts of the case.
Yes.
Then my lord kindly takes the next judgment. This is my lord 2004, volume 7, SCC 478. This is a case where possession was admitted. The principle then that he is showing, my lord, under this case is correct. Now, my lord kindly takes, my lord, paragraph 9. One should read, my lord, the proposition which is laid down, my lord, apropos the facts of the case. My lord kindly comes to the middle. There is a sentence which starts just beside placitum E. Once the possession, lordship has got it, my lord. Once the possession of the appellant either directly or through his agent caretaker is admitted. Where have I in my plaint, I have admitted that he is in possession? Where has he shown one document, my lord, that, my lord, he is in possession, it is admitted? On the contrary, respondent number 3 and 4 came and said that, my lord, they have a financial transaction which has not been, my lord, executed. That's, if I have correctly heard, my lord, that was the submission. So, my lord, this is a case where the possession was admitted in his favor. Then, my lord, kindly takes 2006 3 SCC page 312. This is, my lord, a judgment on status quo. Kindly takes paragraph 11 once.
2003 SCC Calcutta.
My lord, 2006 3 SCC 312, my lord. Just now handed over.
Yes.
My lord, kindly sees, my lord, here there is a finding, not a prima facie case, my lord. Kindly comes to paragraph 11. Towards the middle, my lord, the sentence starts, we are of the view. So there is a document, my lord, of finding. We are, lordship has found, my lord.
Yes.
We are of the view that there is a proper or adequate finding by the additional district judge, either of a prima facie possession of the plaintiff on such and such, or of his forcible dispossession on such and such. Apparently, not even a neighbor or occupant of any part of the building was examined in support of the case of forcible dispossession on the morning of such and such. So there is a finding of the court to this extent, that he was, my lord, either in possession or, my lord, he was, my lord, forcibly, my lord, dispossessed.
Yes.
Where is that here? Where has he made out that case before, my lord?
Yes.
Then, my lord, kindly takes the next judgment, which is, my lord, 2003 SCC online, Calcutta 385. Kindly comes to, my lord, paragraph 7. Kindly sees the facts of the case.
Yes.
That part of action is pleaded against the defendant number 1 alone in paragraph 12 of the plaint. In the plaint, no averment of cause of action for partition is pleaded. As against the defendant number 2, series 3 and 4, the alleged cause of action pleading encroachment has nothing to do with partition and is independent of the cause of action against the defendant number 1, who is sailing in the same boat with the plaintiff so far as the allegation of encroachment is concerned. Where is this case before, my lord? But if I type injunction, I am sure in SCC online or Marupatra, thousands of judgment will come out. But I have to see which, my lord, fits into my case. This is a case, my lord, on partition, which regard to encroachment of two, my lord, plenty for defendants who are parties to the suit. A case is been admitted, and then, my lord, there is an allegation of encroachment concern. Where is that case made out here, or this facts of the case suited to, my lord, the case that has been shown to my lord?
Yes.
Now, my lord, he shows Nandan pictures. My lord, kindly takes 1956 SCC online, Calcutta 36. Kindly sees the cause of action. Kindly comes to paragraph 5.
Yes.
Before proceeding further, it would be useful to set out the order of the 7th of March in which a reference to the statement made by the learned counsel for the appellant is to be found. It reads thus: an ad interim order injunction in terms of clause B of notice. Injunction against Ujjwala Cinema restraining them from selling further tickets for the picture in dispute. Is the cause of action same here? Mr. Such and such states that his clients have already delivered prints and publicity of Ujjwala Cinema and are willing to deliver the prints and publicity to applicant as early as possible. I may explain that Ujjwala Cinema is the rival show house which is engaged in the present squabble with Indira. That's a cinema hall close by, my lord, for priority in exhibiting the film Shaib Bibi Golam in south sector of Kolkata. The applicant referred to in the order is the Indira Cinema. The undertaking or statement relied by Mr. Dey is the assertion of Mr. Mayor, incorporated in the order to effect that the applicants were willing to deliver the prints and publicity to the applicants as early as possible. So this is a, my lord, quarrel between two cinema halls with regard to, my lord, exhibition of a film, my lord, by way of tickets being sold as to, my lord, a competition. How is it relevant, my lord, of a situation where I'm seeking, my lord, in terms of prayer and an ad interim prayer for, my lord, I am being in possession for somebody disturbing me, sitting in front of my door.
Yes.
Then, my lord, kindly takes, my lord, one.
It will take time.
No, my lord, 1 second. Kindly takes, my lord, the Transfer of Property Act. I don't know, my lord, why, my lord, this entire 4 days, 5 days of hearing, my lord, before this court. I'm very sorry for that, my lord. Kindly takes the Transfer of Property Act, my lord. Kindly takes section 11. The surrender letter, that is, my lord, enough for my lord, to pass an order of ad interim injunction. Kindly takes, my lord, section 111. Kindly takes, my lord, section 111, my lord, subsection, my lord, E and F. I think that squarely finishes the matter. My lord, may I read 111, my lord?
Yes.
A lease of immovable property determines, and then the, my lord, the reasons by which it can be. By express surrender, that is to say, in case the lessee yields up his interest under the lease to the lessor by mutual agreement between them, and kindly sees F, by implied surrender. And that's exactly, my lord, kindly comes to 118. This is the, my lord, plaint that one has to look into, page 118 of the plaint. We hereby confirm, if I may read, my lord, page 118 once, after this, my lord, provision being relied upon, kindly takes 117 and 18. I think, my lord, it's an open and shut case. Who is issuing this? Respondent number 3. My lord, with whom I have a privity of contract. 15th of January 2025, 16th he handed over. Now, my lord, kindly sees your letter dated 20th December 2024 for handing back vacant possession by 15th of January for determining registered lease dated 4th of July 2023 for the premises being a covered area of such and such, building such and such. We have been unable to clear all the furniture and installations from the subject premises in terms of your letter dated such and such. However, in order to stop further losses, we would like to surrender the possession of the premises as is, where is basis. we would further not make any claim or insist on handing over any such remaining installation from you, which you would be free to deal with in any manner whatsoever you desire. Now, my lord, kindly sees 118. After that, F is complied with. My lord, we hereby confirm and accept possession of the subject premises. So, my lord, what document further do I need to show? And kindly sees, my lord, it is signed by the directors, my lord, on that page, who are still the director in the, my lord, ROC, according to the document of the MCA. And, my lord, they have not shown even one document to show that he has been, my lord, made a director, my lord, of this company. So, my lord, I have to show a prima facie. My lord, the director who is there has given, my lord, a letter saying, my lord, it is to be handed over. Thereafter, my lord, it has been handed over, which is been, my lord, signed here. Kindly sees, my lord. Now, my lord, kindly sees, he says the last submission that he made, my lord, is that 24 lakhs I have paid. 24 lakhs. They have suppressed. My lord, have I suppressed? Let us take the plaint. One document and, my lord, it is enough to, my lord, close the arguments, my lord. Where is the suppression? He showed judgment on suppression also. Kindly takes the paragraph in the plaint, my lord. Plaint starts from, my lord, 134. 124, my lord, kindly comes to 100 and 136.
Yes.
My lord, kindly sees, my lord, paragraph 26. The defendant number 3 thereafter handed over a check to the plaintiff for an amount of 471. Lordship has got bank statement is there to be credited in his account. Yes. Then, my lord, kindly sees, my lord.
That is the bank statement that you handed over.
The bank statement which was handed over by Mr. Sen, my lord, I believe to my lord.
Yes.
Now, my lord, kindly takes 24 apropos that. My lord, there is a payment of 4 lakhs. 26, my lord, as a payment of 471. And, my lord, kindly seeks paragraph 25, where, my lord, I have demanded, my lord, 14 lakhs 71,000. So, after giving the adjustment of the payments made, my lord, paragraph 136 only. Kindly takes, my lord, paragraph 24 first.
24 is 4 lakhs.
4 lakhs. Then kindly takes 26, 4 lakhs 71.
Yes.
Now, my lord, kindly takes 25. In the interregnum, the plaintiff issued a notice dated such and such for clearing entire dues of 14 lakh 71,000 within 30 days. Yes. Now, this, my lord, takes care. After, my lord, the adjustment, this demand is been made. So, my lord, it is not that the amount that they have paid, that is, my lord, the 3 and 4 has not been given adjustment to. Now, my lord, if he says that payment has been made, so therefore I am in possession, then he has to show first, my lord, prima facie that he has a, my lord, a privity of contract with me. And, my lord, secondly, my lord, is that this amount, by any document, he is saying that I am paying as an individual entity and not through, my lord, 3 and 4. Defendant number 3 and 4. Where is that document, my lord?
This with regard to the paragraph 26, 4
Yes,
lakh 71.
Yes, my lord.
4 lakh 71, which date he has paid?
He has. Date, yes, my lord. That bank statement which I have handed over. My lord, copy. Gives me one moment, my lord. I'll give the date. My lord. The ledger was also given. If your lordship kindly takes that ledger, no, date. 471 টা চাইছে। My lord, kindly takes that ledger. My lord, 10th, the last page, 10 December 2024. 4 lakh 71. So we have given, my lord. Why should we say, my lord, that we have not? Something which has been paid on behalf of respondent number 3 and 4. Obviously, my lord, I have to give a credit for that, my lord, into the claim that I have made.
Yes.
And my lord, last document, I have not shown any.
Yes,
I have not.
law.
No, I'm
No,
nothing.
he has not completed.
But kindly comes to 113 once, my lord.
113
of the, my lord, application.
Yes.
He relied on this document. Now, kindly takes, my lord, paragraph 2. Paragraph 2, my lord. However, thereafter, a meeting was held on 6th August 2024, wherein it was conveyed to us that due monthly rent for July and August 2024, along with electricity dues, would be cleared by one Mr. Probate and Mr. Freddie Leo. It was further requested of our representative at the meeting that after making such payment, a deed, or kindly sees, a deed of revocation is to be made.
Correct.
It has not seen the light of the day. Is to be made for the subsisting lease agreement, and a new lease would be entered into
Incoming lessee.
With the incoming lessee, Mr. Protabaditto and Mr. Freddie Leo, who would then continue to pay the lease rent as before, for which due discussion were to be held. What to be held? With the management of Silica Commons. So there is no approval, no final execution, no, my lord, agreement which has seen the light of the day. And I am relying on this document because he has relied on this document.
Yes.
This is his case which he has made out. So, my lord, until this has been done, where is the, my lord, contract with him? Yes. Where is, my lord, where is the question of possession being handed over to him?
Yes.
This entire case made out is, my lord, is this paragraph only. This is something which will happen in the future. If it happens, my lord, I can always, my lord, if he's such a good businessman in West Bengal, I'll give it to him.
Okay.
So, my lord, therefore, I say, my lord, at this moment, since my possession is there, my lord, these two gentlemen who are sitting outside, my lord, should be asked, my lord, to have their Zomato foods from somewhere else. And, my lord, the possession, I should be, my lord, allowed to enjoy the, my lord, possession, my lord, unincome.
Now, should 2 minutes rejoinder, 4 sentences.
Yes.
Now, the first sentence is that he has relied upon 11EF, saying that a letter will amount to implied surrender. That is in case of a normal circumstances. Your lordship, the lessee can surrender. That does not amount. That is person who is in possession, his possession has also been surrendered. Then why did he file a suit? There was no requirement for filing a suit. He would have just gone there and taken possession.
Correct.
Once you have sought for a declaration injunction, the court has to adjudicate who is in possession. Till that is not adjudicated, no interim injunction should be granted.
Correct.
Second point is that Second point is that my learned friend has not understood the interpretation of the judgment.
My lord, I have not understood. I have not, my lord. This will go on then.
I said rejoinder. You have said something. I have to reply.
Rejoinder to a
He is
rejoinder.
saying that I have not made out a prima facie case that I am in possession.
Sir, you had argued. He has argued.
What he has
upon the court will say whether you are having the prima facie case or this.
Yes, no, I am saying that he is saying that I have to prove. It is his case. He has to prove that he is in possession.
You have interpreted the judgment. Let the court interpret the judgment.
Correct.
Okay, thank you.
And
Grateful, my lord.
So 24 lakhs has nowhere been
But
shown.
3 days is holiday.
No, I know, my lord, that lordship is so prompt today evening, my lord, I might see it, my lord. I am, my lord. Otherwise, my lord, again some Zomato bill will come, my lord. That is the fear I have. Where I will not be able
You will not get the judgment. You will get the order on Tuesday.
Very
Because
grateful.
stops.
You have to.
No, the only thing is that, my lord, I have to buy now Zomato food for Mr. Banerjee for lunch, my lord.
Pre-holy part. Grateful.
And Mr. Dasgupta standing behind me.
Hearing concluded. CI mat karo for orders. For orders. Hearing concluded for orders.
But that matter which was fixed at 3 o'clock, my lord, that small amendment matter, if that can be taken on any day, my lord, today we are very sorry, my lord, that we can't help some certain things crop up, my lord.
That will see.
But
Okay,
can it? No, lordship said that if it's not taken up, you can mention before, my lord.
But let this matter be completed. Already 20 minutes.
Item number 315. It was fixed on 7th of March. 345. This is that power of attorney matter, your lordship.
Which one? 1899. Acha, calm industry. Yes.
My learned friend is here. They were on
taking their submission, then it stopped because they say give a proposal came.
So there is no proposal.
Ultimately, your lordship has recorded that there is no proposal.
कोई है कुछ time है 3:45.
Your lordship has in fact heard the matter.
I heard the matter.
My lord, Mr. Probal Mukherjee
have
is
to
appearing in
conclude
this
that.
matter, my lord.
Huh?
Mr. Probal Mukherjee is appearing in this matter, my lord. My lord, kindly keeps it any day on April first week, my lord. My lord, he has
I do not
submissions to make on.
I don't think, my lord, we
It'll
can
take
as
only half an
counsel
hour,
seek
my lord.
such accommodation.
As it is, the diary is exhausted. Now, if we try and choose date for that is very difficult. Your lordship.
Leave it to your lordship, my lord.
2nd April 3:45. 1819. So and so appearing for the plaintiff, so and so appearing for the defendant, as the matter is, let the matter appear on 2nd April at 3:45 p.m. Yes.
I appeal to the petitioner, my lord. Today there are two GA applications pending before your lordship in this. First,
My lord,
GA
one is
mine,
mine.
GA1.
The second is mine.
The GA2 is the first GA. The GA1 we have prayed for discharge of caveat on the ground that they have filed the caveat in the month of May 2024, but they did not file their affidavit in support of caveat.
Two, my lord, is for extension of time.
Extension of time. Yesterday, this matter appeared. Your lordship has asked
My
them
lord,
to bring
directed.
the affidavit in support of caveat.
Yes. Next.
And my lord, in GA1, I have got one a very innocuous prayer, my lord. Dipali Brahma, the wife of the testator, has
No, the
married. So
mother
I
of the
just
executor and caveatrix, my
so
lord.
the mother of the caveatrix also has passed away. So I'm praying for deleting his name. Her name, sorry.
That's the GA1.
That's
Yes.
the GA1. That's the GA1. Your lordship kindly takes the GA1. The death certificate is annexed.
And what about your caveat?
My lord, the affidavit in support of caveat, my lord, I have with me, my lord.
Ah.
The issue that arose, my lord, is that when I went to file the same, my lord, before I went to file the same, my lord, the department had told me that unless it is extended formally by the
Correct,
court,
my lord,
correct.
it cannot
Because of
be
the 8
accepted.
days
My
rule,
lord,
my
that,
lord.
my lord.
Your
My lord,
lordship has granted them leave.
Okay. So you're ready?
yes, my lord,
Have
it
you
is.
served the copy?
My lord, it
Serve
is
the
yet to be filed, my lord. If,
Serve it. I am
my lord,
allowing
I'll,
the in now.
copy kore diye dijiye.
Yes. Where is the death certificate?
Death certificate. Okay.
Page 7 of the GA1, my lord. Annexure C. Dipali Brahma.
Dipali Brahma. Died on 24 July 24.
Yes. And if your lordship kindly takes the application for grant of probate, although Dipali Brahma has given a consent, but in page 3, it as item number 1 of as intested heirs,
Another
Dipali Brahma's
PLN
name.
Page.
Page 3 of the probate application, madam.
Yes.
Item number 1.
Dipali Brahma.
Yes. So
Only the name is to be deleted.
death to be recorded. Only death to be recorded.
That's all.
But the other prayer is your lordship has already taken. Well, I'm not. I can totally understand, my lord.
Very grateful, my lord, for that.
Not grateful, but very difficult.
We should not quarrel on unnecessary things.
So and so appearing for the executor / petitioner.
My lord, my witness is ready to come in the box and solve.
No, let it be first. You accept, then I will.
My lord,
I will direct for the testamentary
Discovery.
number. Then issue will be framed.
As your lordship pleases.
Discovery and inspection. You are having any document?
My lord, no, my lord, nothing. My lord,
I
only
am
the.
facing short date, so
Yes,
that
my
matter
lord,
can be
grateful.
expedited.
I'll be grateful.
So and so appearing for the petitioner / executor, executrix.
Executor.
Executor.
Thank you.
So and so appearing for the caveatrix. Caveatrix. Petitioner has filed the present filed an application being GA1 of 2024. Praying for recording the death of Dipali Brahma, 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 who died on. Who is the petitioner of the testatrix?
The wife of the testator.
Who is the wife of the testator and the mother of the caveatrix. Caveatrix, who died on 24th.
24/7/2024.
Consider the submission made by the counsel for the petitioner. Peruse the application and the death certificate. Full stop. Name of the full stop. Name of Dipali Brahma.
Only death be recorded.
Police to. क्या बोला last में? Let the date of the death of Dipali Verma be recorded and delete the name from the at page number 3 paragraph at paragraph 6 page number 3 of the probate application. Police to. Considering prayer B of the master summary, sir. The Cavitrix has filed an application being GA2 of 2025, praying for condoning the delay in filing, affidavit in support of caveat. Full stop. Consider the submission made by the counsel for the petitioner. The counsel for the petitioner, consider the submission made by the counsel for the Cavitrix. Full stop. Cavitrix, this court find that the Cavitrix has already affirmed the affidavit in support of caveat and is ready to file in the department. Accordingly, taking into consideration that the affidavit of caveat is ready, and this court is also of the view one opportunity should be given to the Cavitrix to contest the present proceeding by filing the affidavit in support of caveat. Full stop. The Cavitrix is directed to file the affidavit of caveat in course of the day in the department.
Very well.
After serving the copy to the learned counsel for the
But I've served the copy, madam.
Full stop. As the affidavit in support of caveat is accepted, accordingly, the department is directed to assign the testamentary number within a week from date and to place the matter within a date. Full stop. In the meantime, the parties are directed to complete the discovery and inspection of the document within 1 week thereafter. Full stop. And to file and to exchange the suggested issues. List the matter on 1 week, 2 week. List the matter on 2nd April 2025 for framing of issues.
Grateful, madam.
GA number 2 and GA number 1 and GA number 2 are disposed of. उसमें ना नोट कर.
Grateful.
Yes.
Well, this is the matter where Mr. Dotto has completed his submissions, well, with regard to a revocation of a letters of administration taken by my mother. And we don't have too much of time. Let me give an overview of what I'm going to submit, Malad. Then I'll take one point at a time. Malad, I submit that this application is not maintainable. Primarily on the ground that the person who is before your lordship, admittedly, under Schedule 1 of the Hindu Succession Act, does not fall within a person interested. Now, if we take
J2 or J1? J1.
We are doing J1, Malad. J2,
no,
Malad.
This is J2.
No, Malad, J1. Both are being taken up together, Malad. If J1 does not survive, if the revocation, then Malad, no question of J2, Malad, injunction, Malad.
Okay.
Malad, that is only for us lawyers, Malad, sometimes. Now, Malad, Your Lordship, my lord, before I go through the points, my lord, one is that, my lord. Next is, my lord, an application for grant of letters of administration before your Lordship's court will be in accordance with the original side rules. Even, my lord, the citations which are to be given is under the original side rules. And, my lord, it is an admitted position that inventory was filed before this court in December 2024. A question of law will arise that whether an administered letters of administration having been administered completely, whether this can be revoked at this point of time, one. Second is, what happens where the person who was holding the letters of administration or the administrator has passed away after administration? What happens then? Because these are the factual matrix, because we cannot shut our eyes to that. Because I am here before your Lordship as the son of the administrator. So this is another point, my lord. And thereafter, my lord, your Lordship will kindly have a look at their application. Because, my lord, I will be arguing as to what my learned friend could have argued and is entitled to argue, and whether he is entitled to argue beyond the pleadings. So let us see what is the case Mr. Dotto's client has made out. Well, we'll kindly take GA1. I'll be again very quick, my lord. My lord will see that the master summons is issued to a lot of people. 9, as a matter of fact, 9 persons have got the master summons. And your Lordship will kindly see
master summons to 9 persons.
9 persons.
No, where from you got?
And I have the master summons. The copy of the master summons, I find it has been addressed to 9 persons. To Jyoti Wadhwa, Harshavardhan Wadhwa, Meghna Wadhwa, Varsha Wadhwa, Nirmal Pujara, Jayanta Pujara, Kusum, Mainthia, Yashu Thakkar and Rita Mukhi.
As per the genealogical table.
I will show you, Lordship, how and who they are saying are the heirs. Now, my lord, kind of is the petition. This is an application by Jayasri Wadhwa.
Yes.
For revocation of the assets and properties of Damodar Das Wadhwa.
Yes.
Does not talk about any co-personary property. His properties. Of the properties and assets of late Damodar Das J. Wadhwa. The deceased Wadhwa was the son of late Jerambhai. Jerambhai Wadhwa had 3 sons and 2 daughters. And such genealogical table of the Wadhwa family. Then, my lord, admitted Damodar Das was a bachelor. Then, my lord, Damodar Das was survived by his sister Onushua Pujara. May I just pause here for a moment? So, my lord, according to my learned friend's case, I was the sole survivor.
You are the Ansuya.
Onushua, my mother.
No, your mother.
My mother. Well, just now I was talking to a senior counsel, Mr. Molay Ghosh. So he said a beautiful thing. In Bengali, he was saying that, is your matter in Iholok or Porolok? Because Iholok is this side of life. I said, no, Porolok, because I'm in the testamentary jurisdiction. So I got a bit confused whether I'll be in Iholok through myself or through my mother in Porolok. So, my lord, his brothers, Govardhan Wadhwa and Dungeshri Wadhwa, predeceased him. Admitted position again, my lord. Late Govardhan Das was married to Ratan Ben Wadhwa. Dungeshri was married to Shokuntala, survived by their 2 sons, and had 3 children. There is no dispute about this. No dispute. Point is predeceased. Admitted position. Then, my lord, 5Cs, Dilip Wadhwa was married to applicant herein, opposite is survived by his sole legal heir, who's Jayasri Malad, and Bhushan Wadhwa is survived by his widow Jyoti and their 3 children, namely Meghna, Varsha, and Harshvardhan. Now, your lordship kindly correlates with the master summons. So, according to them, it is limited to the 3 sisters, the sister, 2 sons, and their descendants. Not all co-parceners. Because Malad kindly appreciates, co-parcener is a different concept altogether, Malad. As it goes down, it becomes smaller. That is, as on death, it becomes bigger. Then it should go back. Then all in the genealogical table had to be made.
Go to the one and come.
Yes, then they would all have to be cited.
Correct.
According to them, it is not required. Why is that? Because they are aware of the law. That survivorship does not, in any manner, for even a joint Vitakshara family, does not determine how it will be succeeded. It was there earlier. Now it is not there. I will point that out later. It is not there. So they are also aware that it is by way of intestacy. And if it is by way of intestacy, then Malad, they are conceding to section 8. And under section 8, I am, or rather again, my mother, had a higher hierarchy and was the person who was entitled to in intestacy or otherwise as succession, not as a survivor.
So you are going with the intestacy.
That is what I am saying. My learned friends on the point of survivorship, co-parcenary, I am on the point of intestacy.
So that is the only point.
Well, if they can take any further points, because now they have taken a point, Malad, of a will being present. Now, I don't know, in so many words, they have not said so, but they are trying to say that a cloud may have been caused on the interest of the deceased testator. He had made a will, then he has revoked it. Why has he revoked it? Then your lordship should revoke it. Revoke the letters of administration. This is, this is not really the legal part, but whatever, this is what has been submitted.
No, their contention is that once you had the knowledge and you filed the application for grant of probate and you had the knowledge with regard to the earlier will, which was subsequently restored, why you have not disclosed all the things?
Yes. I'll come to that.
Could have been disclosed.
Yes.
If that have been disclosed, he's not telling that it is legally you have to disclose. He's telling that if could have been disclosed.
So that is what I'm saying, Malad. He was trying to create a cloud.
Could have go through the all pleadings, then the might be the probate cannot be granted without the issue.
Malad, that is why I say, Malad, he's trying to create a cloud because he understands legally I'm not required to do that. He's trying to clear a crowd so that your lordship feels that yes, there might be something fishy about this. Sorry for my colloquial language. And that is why, Malad, he has also made certain comments after saying that I do not intend to, but has made submissions about the lawyers also. Aspersions have been drawn that they were the same lawyer.
Correct.
Right. But Malad, this is nowhere in the pleadings. So let us, that's why I said, Malad, let us keep to the pleadings of this case. So that is why I was on that we should only look into the pleadings at the moment. Now, Malad, kindly sees paragraph 7. Damodar Das Wadhwa had, along with his brothers and sisters, inherited by survivorship the estate of their late father Jerambhai Bhulchand Wadhwa, and there was nothing which was self-acquired by the deceased Damodar Das Wadhwa. So, Malad, today they say, in the first paragraph, they say, they have come before your lordship that letters of administration was for the properties of the testator. Now they say that deceased couldn't have had anything of his own. So challenging.
So how the property has come? Where from the property has come?
Now that is the point, Malad. They are raising a dispute with regard to title before your lordship.
No, no, they are not raising the title. So they are telling the survivorship. You are telling the intents. So where the property, whose property is this? So how the property has come? What is the flow of the property?
Malat, flow of the property. First, Malat, which property are they talking about? They have to discuss first. They have to show. Because in my affidavit of assets, Malat, whatever I've submitted, those are his properties. The testator's property.
His own.
His own.
Hmm.
Then it is for them to say that which property has not been, was not his. Even if he says that, that becomes a question of title. That cannot and ought not to be looked into by a probate court, Malat. That is well, a very settled law. That is why I'm saying, Malat, I'm trying to at least, Malat, try and limit it to a case of revocation of a letters of administration.
That is the matter.
Because everything what was being said, again, can a man have female jewelries? Malat, these are neither here nor there. If you say that it has come down by way of, let us say, survivorship, I'm taking his point, but show it. That is why I'm showing the pleadings, Malat.
Okay, continue.
Kindly sees that, Malat, the pleadings does not in any way say which properties. It only says there was nothing which was self-acquired by deceased Damodar Das Wadhwa. So the assets and properties belong to the joint Wadhwa family, and Damodar Das Wadhwa was a co-personal along with the other members. So it is basically then what is coming down to is that this testator, by some reason, had these properties with him as a co-personal and has dealt and has kept it with him on behalf of a co-personal. Where is that? Where is the particulars?
Okay.
Where are the details? Then kindly sees. At a recently family get-together, came to learn that the letters of admission in respect to the assets and estates of Damodar was granted to Onushwa Pujara. After the death of Onushwa, her son Nirmal Pujara was claiming to be the sole owner of the joint family assets and properties on the basis of the said letters. Which family assets, Malat, if I ask myself?
Yes.
Is there any disclosure? There is none. It's a pan, complete, whatever.
Okay.
Then kindly sees 9. In terms of, immediately upon coming to learn about the purported letters of administration in terms which Nirmal Pujara was claiming right, title and interest.
In the joint asset.
In the joint asset and properties of Wadhwa family. So now they say it's a family asset. Then you should have disclosed. The applicant engaged an advocate instructed to do the necessary. Upon necessary searches and inspection of the records, the applicant has come to learn that the letters in respect to the assets and properties were granted pursuant to a petition number such and such. Then they made. Now the grounds of revocation. Kindly seize, Malat. Page 6 onwards. The petition for grant of letters of admission was prepared by suppressing vital facts. And by such acts and or omissions, the letter of administration was obtained by fraud upon court. In the petition, PLA affirmed on such and such, Onushwa at paragraph number 4, although it was stated that Wadhwa died on April 4, but nothing was said about the surviving son, Dilip Wadhwa. Malat, surviving son, which he is talking about, Malat, he predeceased the testator. It was stated that Durgeshi Jerembhai Wadhwa died on April 4, but nothing was said about the surviving son, Dilip Wadhwa. Similarly, although it was pleaded that the sister, Kushum Lakshmikant Asani, had died on 10th January 2021, but nothing was said about her heirs. Thus, late Damodar Das Wadhwa died intestate and bachelor and was survived by his heirs, being his sister, Onushwa Pujara, and his nephew, Dilip Wadhwa. But how was he survived? I couldn't understand. Dilip Wadhwa was not there. Malat, kindly sees my application.
Why Dilip Wadhwa was not there?
I don't think Dilip Wadhwa was there, Malat. I'll just point out, Malat. Comes to page 14, Malat. That's important.
14 of this application?
Yes, Malat. না না ও বলছে না না দিলীপ পদ্ম মারা গেছে 11th March 2023 আর ও মারা গেছে 20th 29th July
Yes, before that.
সেটা
Before that.
বলছে ওকে yes yes মানে দিলীপ Wadhwa I'm sorry my lord what I wanted to say my lord that Dungeshi Jarambai Wadhwa had predeceased.
Correct.
So Dilip Wadhwa was not a direct descendant
That is
of Damodar Das Wadhwa.
That is from the Dungeshri.
From Dungeshri, who was his brother.
Brother.
So brother was not there when this person had passed away. Malat, on that entire first row, Malat, all are predeceased, save and except Onushua.
So that's why they have made out a case. You have made only the first row. You have not made out the second row. Now your case is that the second row is not necessary.
Malat, kindly takes Malat. It seems that Malat, let me also Malat point out the law which I am trying to rely upon, and then I will take
That's
your
now
lordship
I am telling with regard to what the Mr. Dutt.
Yeah, I understand, Malat. Why I am saying Malat? Malat kindly takes. Malat has down after that.
Hindu Succession Act.
My lord.
Hindu Succession Act.
Yes, my lord. Sorry.
नहीं हम लोग पास
रीड करा था देखो मतलब देना দিলো তো শর্ট হয়ে গেছে আমি এটা দেখি শেষ করে দেবো মানে kindly takes first section 6 section 6 मतलब
May I take your lordship's?
Yes.
Section 6 devolution of interest in co-personal property. Malad, this amendment has come in 2005.
September.
Now, Malad, on and from the date commencement of the Hindu succession 2005 in a joint Hindu family governed by the Mitakshara law, daughter of a co-person. Malad, this first 6(1) gives rights to the daughter. Then provide provision, and then 2 is also to the daughter. Now 3. Where a Hindu dies after the commencement of the Hindu Succession Act 2005, his interest in the property of a joint Hindu family governed by the Mitakshara law shall devolve by testamentary or intestate succession, as the case may be under this act, and not by survivorship. So survivorship is not there. It was beforehand, it was survivorship, my lord. Kindly see, my lord, your lordship will find. I don't know whether your lordship has that in the bottom, my lord, the earlier section would be there, my lord, if your lordship finds.
Yes.
There, my lord, it was determined on the basis of survivorship.
Correct.
Now it is changed. Even for joint Mitakshara Hindu family, my lord, it will be by intestacy.
Testamentary or intestate.
Intestacy.
Succession, as the case may be under this act, not by survivorship.
Not by survivorship. So survivorship has gone.
Yes.
Now, if that is intestacy, my lord, then your lordship will kindly come to section 8. Property of a male Hindu dying intestate shall devolve according to the provisions of this chapter.
Yes.
Firstly, upon the heirs being the relatives specified in class 1 of the schedule. And class 1, my lord, will kindly see the schedule, my lord. I don't know whether Mr. Doctor has shown your lordship, my lord. Class 1. Son, daughter, widow, mother, son of a predeceased, daughter of a predeceased, son of a predeceased, daughter of a predeceased, daughter, widow of a predeceased, son. But admittedly, there is no one.
No one.
But Onushua. That is my mother.
Firstly, upon the heirs being relative specified one. So Ansua is the
Onushua is also not in class 1.
not one. That's what I'm telling you. She's not the class 1.
There is no one in class 1.
Correct.
There is my lord. Onushua is in class.
Anshua has come where from?
Class 2, my lord.
Anshua is daughter of whom?
First, my class 1 goes. Now, kindly see again section 8, my lord, once more, my lord.
If there is no heirs of one, then upon the heirs of being the relatives, specified class 2.
Class 2.
Yes.
Then thirdly, if there is no heir of any of the two classes, then upon the agnates of the said deceased.
Correct.
And lastly, if there is no agnates, then upon the cognates of the deceased. I come in 2, my lord. Down now. My lord, kindly takes the schedule class 2, 2. I fall there. I am the sister.
Sister of?
Of the deceased.
Secondly, if there is no legal upon it, then being the relative specified class 2.
Class
The
2.
schedule.
Class 2, 1 is father. Father is not there.
Yes.
Class 2, 2. Son's daughter, son. Because well, he doesn't have a son.
Son.
Bachelor.
Correct.
Son's daughters, brother or sister. Brothers are dead.
Last one. Sister.
Sister. Now, my lord, sorry, my lord.
Yes.
Why I say the co-partners are not required. My lord, kindly as a look at section 9.
Yes.
Among the heirs specified in the schedule, those in class 1 shall take simultaneously.
Correct.
And to the exclusion of all others.
Correct.
Those in the first entry in class 2 shall be preferred to those in the second entry. Those in the second entry shall be preferred to those in the third, and so in succession. So if 2 is the person who will get it, he or she will get everything. Everything. No divisions there. In the order of succession. So this is where I come in, my lord. The case of survivorship, my lord, does not remain any further, because what is the scope of this now, my lord? What has happened? It says, well, I'll place a judgment that on section 6 being amended, my lord, it is tantamount to a fictional partition of entire property. Whatever is supposed to be that person, that is gone. And if it's a dispute of title, then you have to raise it otherwise. So you cannot say by survivorship, all the survivors, they become co-partners. I admit.
So, as per your submission, if you go by the survivorship,
maybe.
If we go by the survivorship also, then we have to follow the schedule.
Even for survivorship, we have to follow.
Yeah, that's why we have to follow the schedule.
Yes.
If we go by the schedule, follow the schedule, then the petitioner comes under the petitioner.
Comes first.
Comes first.
And because of section 9, it takes
schedule 2, schedule 1, class
schedule
2,
1, class 2,
class 2, Roman 2, 4. Roman 2, 4.
Absolutely.
And where he is pitted, the applicant?
Malad, he would be pitted, Malad, kindly.
Who is he?
Malad, he is, what he is saying today, he is the wife.
What is the name?
Wife of the brother's son.
Just what is the name? Jayashri.
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 Wife of the deceased brother's son.
Late Dilip Wadhwa. Dilip Wadhwa. He is the wife of the brother.
Malad, his claim is through Dilip Wadhwa because of survivorship. But now, because of section 6, survivorship is also not there. So it does not matter whether Dilip Wadhwa was alive at the time when the testator had passed away. Now it is no more required.
Survivorship.
And even if it is held to be that way, Malad, section 9 glares at their case.
Section 9.
Malad, they fall under
Section 9. Among the heirs of the specific schedule, those class 1 shall take simultaneously and the exclusion of all others. So that's why, serially.
Serially. And they fall under 2, 4.
Correct. 2, 4.
No,
they.
2, 4. 2, 4. Class 2, Roman 4, 1.
Father's 4, 1.
Brother's son.
Brother's son.
Dilip.
Yes. Brother's son.
Brother's son.
And brother's son. So brother's son gone.
Man, kindly takes page 14 once, my your lordship will.
Yes, 14 I got.
Brother is Dungeshi Jeram Bhai.
He is the son of the Dongeshi.
So therefore brother's son.
Brother's son.
Testator.
But
Testator brother is
now
Dungeshi.
again, the brother's son died.
That is, furthermore he has died, yes.
So how seek out the right here?
He doesn't. Mala, that I will come to, Malada. That's why it's challenge the maintainability at the very threshold. She is saying because of the survivorship of Dilip Wadhwa, she is entitled. So she is going to take the survivorship part also the intestacy part also. Succession. So she is on traveling on both Malad, both if I can
Where
say
it
that.
will be clicked.
Malad, I don't know. Your lordship will take it further, Malad.
Come on
Sir, because there are several judgments I'll have to, because they have shown lots of judgments.
Come with the table.
Which table, Malad, if your lordship can?
Schedule.
Sorry, Malad.
Schedule.
Yes, yes.
That will be better. Because you have given the table of the only the first here.
I'm taking their table.
Okay, no problem.
I'm on their table. I don't want any other table.
Okay.
Therefore, the question will arise as to whom I was required to cite.
Yes.
And citation gives the power of Malad revocation. And citation comes under the original side rules. Malad, these are my submissions, which I will explore further.
So appearing for the executor. So appearing for the applicant. Counsel for the executor has argued that in connection with GA1 of 2024, but due to paucity of time, hearing could not be completed.
Son of the administrator.
Son of appearing for the son of the administrator. Administrator. And so appearing for the counsel for the son of the administrator has argued at length, but due to paucity of time, hearing could not be completed. Friday? Wednesday, Thursday.
Wednesday.
Wednesday, Thursday, 20. 19. 19th March.
My lord, before lordship rises, my lord, in the morning, lordship, they had mentioned, my lord, 23, 24.
Which matter?
23, 24. Lordship, so if it is not taken up, then you can mention it. My lord, that is for that small amendment.
23, 24.
Yes, my lord. We mentioned a very small amendment. Lordship will remember, lordship had passed an order of injunction not to transfer the shares on the basis of the, my lord, affidavit in opposition filed. So that opposition I have to put in my pleading. So that is the small amendment.
So what you want?
That any day lordship fixes, my lord. It was today fixed at 3 o'clock. But my lord, both the matters. But today we can't, my lord. We have to. 23 and 24. This is the order, my lord. Kindly sees it was fixed at 3 o'clock. Both the matters. I can give the orders of both the matters. Both the orders are there. 3 PM it is written, my lord.
अच्छा इसमें नहीं है.
Yes, that is by mistake, I think. By mistake.
Not by mistake, due to the appellate side.
Oh.
Not by mistake. Due to the appellate side, you have been taken out from the fixed matter.
No, but then, my lord, we all read that it is only for a very short time.
I don't.
We all read, my lord.
So. So what you want? It is to be fixed.
Any day fixes, my lord. It will take only 5-6 minutes.
Fixing is the problem.
Any day, my lord. 11:30, any day, my lord.
11:30, no.
This is a 5-minute matter, my lord.
5-minute matter.
Take much time. Only the
His affidavit on the basis of which this amendment.
My lord directed them to give us
the detail.
First April. So appearing for the plaintiff. Defendant, who is defendant?
Defendant, we gave notice. He was there.
Appearing for the plaintiff, he submitted as in terms of the order dated 22nd of January 2025. The matter was supposed to fixed today at 3 PM, but it is listed without any date and without any time. Counsel for the petition prays for fixing the matter so that the application being GA3 of 2025 can be disposed of. In view of the submission made by the counsel for the pending, let the matter appear on 1st April at 3:45 p.m.
My lordship is keeping it on, my lord.
1st April,
Why,
3:45.
instead of that, my lord, 7th. 8th, my lord.
8th April.
Yes.
8th April at
3:45. Great.
My case, if that could be done on the.
My lord, both the matters, my
Your
lord.
lordship had fixed it between.
दोनों matter.
20th. You have taken a first. इससे पहले वाला दिया था.
My lord, both the matters, my lord. 23 and 24. Grateful.
And I'm sorry to mention one
जो order
matter.
किया ना 23 and 24 last two. 23 item number 23 and 24. 23 and 24 of the today's list. Huh? Yes.
And I'm sorry to mention a matter, my lord. In the morning, my junior had taken a leave to file a written statement. It is pointed out, my lord, there are some defects in the written statement.
No problem.
But, it has been filed with some defect.
It is affirmed.
Affirmed, but there is some defect in the sense that the statement of truth that does not contain the jural portion and the
when the 120th day is going to be over?
Tomorrow, 15th.
Tomorrow. So you
till
do
Monday, my lord, we should have that.
no. You do one thing. You file this written statement today in the court in the department. Correct.
Department has pointed out the mistake. Right?
Correct. No, it has not been accepted till today.
Yes. Yes.
Correct. So when the court is going to be accepted, you mention that we'll see what. Hmm. It is not affirmed. Affidavit.
Yes, but the affidavit portion in the statement of truth is not there. That is the mistake which has been done. My lord, what we can do, my lord, subject to your lordship's approval, we expunge this written statement and let them file a fresh, my lord.
Your time will be over. Then
it has to be done today. If they can file a fresh written
you can file fresh today.
If the last date is a holiday, then my lord, then my lord, the last day will be on Monday.
Monday, as per this General Clauses Act. General Clauses Act.
That is, my lord, the only thing, my lord, which is done. Either the client comes and affirms the fresh written statement today, or on Monday in the morning, my lord, they will have to take leave of your lordship and file it upon affirmation, because tomorrow is the holiday.
I don't know whether today is the 120th day.
No, tomorrow is the 120th.
Tomorrow is the 120th day.
Or, my lord, subject, my lord, if your lord, whatever falls from your lordship, my lord, since the wrong has been done by them, my lord, if this can be accepted subject to remedy the defect on Monday.
That's why what I propose to let it be filed. Now the master will not take whether it is a defect or not. Only I am giving the you file it. You find the defects, you come with the proper amendment application along with the new. On that day, it can be moved together. That will be better. Let it be in the department. So that your written statement should be in the department. If you want amendment, you come with the total new
amendment in the sense I will have to file a fresh statement of truth. Because the statement of truth does not have the jural portion.
Correct.
Which is the defect of the advocate.
Come with that, then that will be allowed on
kindly that. Make an endorsement in that case, will not accepted subject to defect.
No, not subject to acceptance, I hear.
Subject
to acceptance.
May I, lordships? Item number 40, it's still a hearing matter, your lordship. If it may be fixed, your lordship, so that I don't have any, I can wait for some time.
What is the matter?
This is a revocation application, your lordship. I have to start the matter.
Revocation?
Yes, it will take some time, your lordship.
Who is for the other side?
Other side was, I think,
then it should go to the June.
Then I wait, your lordship.
Your lordship.
Take a chance.
Your lordship.
You are finding the 40, but I have segregated Monday and Tuesday. I am taking the PLA, which is non-contentious cause. And Tuesday, Wednesday, Thursday, I am taking the applications. And Friday.
Can it be taken on Thursday then, your lordship? 19th.
Automatically it will come.
Your lordship, item number 41, your lordship. Yesterday, your lordship had said that there's no caveat, your lordship. Your lordship, we had applied for caveat 10 days back, but the department is saying since the file is lying in the court, we will require 10 days time, your lordship.
Yeah. What caveat?
Your Lordship, this was a contentious disposal. We had issued general and special citation, but no one has come up. So, Your
Correct.
Lordship, we have to provide no
Acha, no
caveat
caveat
certificate.
certificate.
Yes, Your Lordship.
It
Your
is there.
Lordship, Lordship, the department is saying we require 10 days time since the file is in the court, Your Lordship. So, I am just praying, Your Lordship.
Okay, file is sending to the department. Let them produce.
Lord, may I have my Lord's leave, my Lord, for drawing up and completion,
Lordship.
Lord.
What
Of
is
the
that,
order
which-
dated 10th of February, my Lord. Extremely grateful.
Vishnu Chaudhary yesterday. My lord, his I think witness was in China or something like that. So he had mentioned it. I think another day has to be fixed because they were supposed to file their affidavit and they have filed it. I was supposed to, after examination in chief, I was supposed to cross-examine.
So appearing for the plaintiff, so appearing for the defendant, the plaintiff means. None appears on behalf of the plaintiff, so appearing for the defendant, though the matter is fixed today, especially fixed today for witness action. But it was earlier mentioned, but the learned counsel appearing for the plaintiff has mentioned the matter earlier and submit that the witness, indeed, it is not possible for the witness to appear before this court today and fit for action. In view of the above, the case is adjourned. Let the matter appear on, give the date 11th June at 2 p.m. for witness X.
Now, my lord, it's June. Grateful, my lord.
Next.
Item number 17.
But I'm the plaintiff
Both the parties
petitioner.
are there.
I think my learned
Appearing on behalf of the defendant number 1, I'm being led by Mr. Devjit Mukherjee. And
Okay.
defendant number 2 is concerned. I do not have it.
Nobody is appearing for the defendant number 2.
Yeah. Milord, may I just, in short, Milord, tell you, Lordship, this is an application for judgment upon admission in a suit for declaration. Kindly take the cause title of the petition.
GA2. GA2.
GA2, my lord.
Yes.
Plaintiff petitioner and the mother of defendant number 2 were 2 sisters. Only 2 sisters. The original premises number, your lordship will find 6A Mohan Bagan Lane, as against defendant number 2, address, cost title in the cost title. From the cost title, I'm trying to give your lordship the synopsis, then will lordship give the date.
So the plaintiff and the
Defendant
mother
number
of the
2,
defendant number 2.
mother of defendant number 2 are 2 sisters.
Correct. And what about the one?
Defendant number 1 is a purchaser of undivided half share from the defendant number 2 after the death of the mother and the father of the defendant number 2. Now, premises number is 6A Mohan Bagan Lane. Now, what has happened in short, may I just point out to your lordship? In short, then I shall give your lordship the dates. This is a property in the Sambhajar area, huge property. Now, after originally, the father and the mother of Subrata Sarkar and Sutapa Sarkar, the mother of defendant 2, they were Vidyut Vikas Bosu and Anima Basu were the owners, co-owners of premises number 6A Mohan Bagan. After the death of Vidyut Vikas Bosu and thereafter Anima Basu, the 2 sisters became the joint owners of the property. It is a Dayabhaga law. So, unfortunately, after the death of Sutapa Ghosh, her husband also died. Now, we have come to know from a message which comes from the KMC that regarding mutation of the property. I shall give you, lordship, the details and the pages. We came to know on further Milord inquiry that Surojit Mitra, defendant number 1, purchased the undivided 50% share of 6A Mohan Bagan Lane from defendant number 2. And no right of preemption was allowed to be exercised by me. So our main case is under section 22 of the Hindu Succession Act, that I am entitled to
first right.
Have the first right. Now, my respectful submission in view of the decisions of this Honorable Court and other court, it is, the section says as if it is prior to the sale. But the judgment law says, no, that right is there. It is embedded. Even if the sale is concluded, my right, I can exercise my right. So I have filed a suit. Suit what I have filed, your lordship, history I have stated to your lordship. Kindly come straight away to, my lord, page 11 of the petition. Roman 34. These are the reliefs claimed in the suit. Fortunately for us, they have filed written statement, the defendant number 1. I shall point out to your lordship from their pleading, factum of sale by the defendant number 2 to the defendant number 1 is admitted. Their only case is that I have not exercised the right of preemption, presumably on the basis of a particular email. I shall point out to your lordship that that email does not mention that any sale was done by defendant number 2 to the defendant number 1. And my lord,
So at the time of sale, you have no knowledge about that?
no knowledge.
So the sale was between the 1 and 2.
Between, yes, from 2 to, by 2 to 1.
Correct. 2 has executed and got the right over.
Now, may I just hand up to your lordship a list of dates relating to GA2. The first part, 1969, how my father acquired the property, purchased the property. Then 2005, my father died. Then 2014, my mother died. Then 4th September 2020, my sister died, who was the mother of defendant number
2.
Then 22nd August 2021, the father of the defendant number 2 died, Satyanaran Ghosh. Then on 3rd April 2022, my lord, the property was mutated in the joint names of plaintiff and defendant number 2. Pages have been given, my lord, in the. Then on 11th August 2023, here comes, my lord, the impugned deed of conveyance was executed. The defendant number 2 transferred his undivided 50% share in the suit property to the defendant number 1. It is recorded in the impugned deed of conveyance. I shall point out to your lordship at third paragraph, page substances of petition inter alia, that defendant number 2 along with the plaintiff became joint owners of the entire property, 6M HON'BLE land. So this is admitted fact written in the document itself, as described in the first schedule. Then e-assessment sheet appended to the deed showing that the market value was 1,05,60,739 and the purchase consideration set for value was 30 lakhs only.
The 1 crore 5 lakhs is
market
the
value.
whole property or the share of the defendant number 2 only?
Share of the defendant. And this is another factor. Then 9th August 23, by an email, a draft agreement for sale was forwarded by one Debal Das, advocate, to the defendant number 1. Kindly come, my lord. This is very important. This is the, my lord, email. Sorry, there. Kindly come, my lord, to page 81 of my petition. Your lordship has got, my lord, that email.
Yes.
Agreement for from Debal Das to Subrata Sarkar, the plaintiff petitioner.
Yes.
One attachment, respected madam, Please find enclosed here with the agreement for sale. Now,
So this is of 2023, 8 September.
Yes.
19th August.
19th August 2023.
Correct.
Now, at page 82, the attachment starts.
Yes.
Agreement for sale.
Yes.
Agreement for sale, blank day of August in 23 between Subrata Sarkar and Surajit Mitra. Then if your lordship kindly come to, it goes up to page 95. There is no whisper about any deed having been executed or registered in favor of defendant number 2 in respect of 50% share. Kindly note that.
Yes.
This email or the attachment thereto cannot be considered merely as an intimation or information or a proposal intimating that they are going to purchase the property from the defendant number 2. That's my respectful submission.
So even as per, if you go by the simple way, this agreement does not disclose that you have a knowledge with regard to the sale by
Yes,
the defendant.
I'm grateful, my lord.
That is.
I'm grateful. Now comes, my lord, the very important bit.
Yes.
I was just telling Mr. Ghosh, Lord, that you should also be given an opportunity to
Oh,
ask.
yeah.
Why you are depriving this court to hear Mr. Ghosh?
No, no, I'm not deprived. So we should also ask.
Yes.
Now kindly take the next date, 5th December 23 at page 96.
Mutation certificate.
Oh, may I just point out to your lordship one thing? I think I must show at page 252. In volume 2. It is the email from Subrata Sarkar. In response. Received. Thank you. Subrata Sarkar. Received means receive the email along with attachment. That's all.
This is 28th of March 2024.
Yes.
Correct. And this
23 minutes, 19th August.
19th August was the earlier one. 19th August was the agreement which was forwarded to you.
Or towards the bottom, towards the middle, sent from my iPhone on 19th August. It was the sent. And in the right hand side, August 1920, your lordship.
Yes,
see the
5:55, 5:45 p.m.
Yes.
So this was sent by Subrata.
Subrata.
Subrata Sarkar. To whom?
To Debol. Name of the Debol is appearing in the middle.
Drafts, yes. Debal at the red, yes.
So this is the acknowledgement.
But how it can be? This acknowledgement you have given after, but this you have received the agreement, draft agreement on September 8th, the 19th of August 2023,
Yes.
age 81.
My lord.
Correct.
My lord.
And you are telling that this is the reply to that. And this reply is dated On 28th March 2024.
That is the printout date.
Acha, printout date.
Right hand side, your lordship will find the date.
19th August. 19th.
On the same day.
Thank you.
These days it is automatically done. Receive, thank you. So that does not mean that I have agreed to anything. And in any event, the draft deed does not contain any whisper about sale of the 50% by defendant number 2 to defendant number 1.
Yes.
Now, if your lordship kindly come to page 96 in volume 1. Fifth December.
Yes. 5th December.
This is the printout of the screenshot of the SMS received from KMC. Download mutation certificate from Contempt KMC portal. Your mutation has been approved. Mutation case number so and so. That means mutation has been approved. Mutation from the name of the defendant number 2
instead
to
of defendant number 1.
So this, if your lordship kindly come to me, Lord, the list of dates. This date clearly I have stated so that from this date, I came to know that
about the mutation.
About the mutation. So if your lordship kindly go back to the date 11th August 23, in the earlier page 2.
Deed of conveyance.
The knowledge of the same came to me
on December 23.
December.
After the mutation.
After the mutation.
Because in the mid they have given the information regarding the draft, but they have not disclosed it.
That they are not disclosed. That, Milord, factually I want to make it clear. Then kindly come back, Milord, to the list of dates. On 8 January 24, at page 98, we received a certified copy of the
deed.
Your lordship will find from page 98 at the bottom right hand side, after the seal of additional register of assurance, the date. Right hand side, bottom corner, the date is there. Then on 11 January 24, at page 97, the assessment, municipal assessment book showing, page 97, that the suit property was mutated in the joint names of the plaintiff and the defendant number 1. And we filed the present suit on 31st January 24.
Yes.
In this suit, we filed an injunction application, GA1.
So what is the date of the mutation it is mentioned? No.
Date of mutation.
It is not mentioned.
Not mentioned, but your lordship will find the date of 8 of
approved, yes, approved on 11th December.
5th December.
5th December.
In the
96, page 96.
We find approved mutation case, last voter. Your mutation has been approved. Mutation case number 11 of 5th December 23.
Yes.
Then on 8 January 24, we received a certified copy. Then on 11 January 24, municipal assessment book at page 97.
Yes.
Then on 31st January, we filed the present suit. I have placed before Lordship the prayers of the print. Then on 2nd January 24, kindly come back to the list of dates. We filed the first interlocutory application and obtained an injunction order. Ultimately, my lord, the special officer, learned special officer, inspected the property, submitted a report, and at page 184, the order dated 27th February 24, page 184, second volume of the petition. Your lordship will find the order will speak for itself.
Yes.
So this is the present status of the suit property.
Yes.
And my lord, then they filed the written statement on 19th April 2024, page 189.
Yes.
It was filed on 22nd March.
Served upon you 19th of
Yes, 189 page. Now kindly come to, my lord, their written statement.
Yes.
Your lordship will find, I am, my lord, ignoring the denial part. First one is defendant number 1, so he is the purchaser. They have tried to make out the case. Kindly come straight away to page 193. Roman 7.
Yes.
Upon the demise of Bidyut Vikas Basu and Anima Basu, the said Sutapa Ghosh and Subrata Sarkar acquired 50% each of premises number 6A Mohun Bagan Lane, thereafter mutation. So this fact is admitted. The two sisters. Then thereafter, Supriyo Ghosh left for, Sutapa Ghosh left for heavenly abode on such and such date. Then leaving so the husband and the only son, Swanso. And thereafter, Satyanaran Ghosh also died, leaving the son as his only legal representative. Then 9, Roman 9. Thus the said Supriyo Ghosh, being the defendant number 2 herein, became the owner of, to the extent of 50% undivided share of the entire property and lived in the said premises. The other Swanso is residing at such and such address mentioned in the cost title. Milord, we are paying the maintenance, that means the servants, everything we have been paying. Now, joint reading of subparagraph 7 and 9 clearly indicate that plaintiff and the defendant number 2 were 50% owner each of the property. Then kindly then the story comes up. Page 194. Roman 10. In the last month of the year 22, the answering defendant through a broker, namely Indranil Sarkar, came into contact of the defendant number 2 and defendant number 1 to know that suit property would be subjected to sale. Then he has narrated Ultimately, he has said in Roman 12 that the defendant number 2 insisted that the defendant number 1 for the money in order to face his financial harshness and assured the defendant number 1 that the plaintiff was also ready to sell her share and negotiation. So who assured? The defendant number 2 assured, not the plaintiff.
Correct.
Then Roman 13, thereafter the broker, namely such and such, so and so, made regular contract with plaintiff and the defendant number 1, converse with plaintiff by using mobile of the said broker, but did not hand over the phone number of the plaintiff to avoid direct contact with the plaintiff or the defendant number 1. It does not improve their case. Then 14, the defendant number 2, the broker took a lump sum amount from the defendant number 1. So it is all against the defendant number 2. Then, mirror, Roman 15 at page 195. Upon inducement of the defendant number 2 and the broker, the defendant number 1 purchased a 50% undivided share through the deed of conveyance, which was registered before such and such asset. So this fact is admitted. 50% undivided share has been purchased by him. It has been annexed here. Then, Roman 16. Meanwhile, regular negotiations were on with the plaintiff and the defendant number 1 through the above named broker, namely Indonil Sarkar, and the said broker said that the plaintiff has also agreed to 50% undivided share and wanted a draft copy of the agreement for sale. But it is, my lord, the hearsay evidence. It's a clear example. Indonil said such and such thing to him, such and such thing, and draft copy of the agreement for sale. There is no whisper that this fact is told. As such, plaintiff has provided an email. That email I have shared with your lordship. Your lordship, that is the 11th paragraph there. And my lord, then 17, next page. Negotiations were practically held by the said broker and the defendant number 1, bargaining, etc. Then 18, as a bona fide purchaser, defendant number 1 duly applied for mutation. Then 19, as the bargain about the consideration price were still on between defendant number 1 and plaintiff, and the defendant number 1 did not take possession of the property to honor the sovereignty of the law for land, that the defendant number 1 still wants to purchase 50%. So what is admitted here? Defendant number 1 has not taken possession. So these are the facts they narrated in the defendant number 1 and my lord. Whatever one can say thereafter, main thing is whether under section 22.
So what is the problem? Why the defendant are not coming forward? They wanted to purchase your property also.
No, there was.
It is a partition suit. It is a partition suit.
No, it is a declaratory suit.
Declaratory suit.
I need not file a partition suit.
Correct. Okay.
I need not file a
Got
partition.
your point. Yes.
That is the case made out by them.
Correct.
You go and file a partition suit. No.
Yes.
So this is, my lord,
Got your point. Yes.
In fact, they have stated so in the written statement. Now, kindly, my lord, take section 22 of the Hindu Succession Act. Now, to me, take about. Preferential right to acquire property in certain cases. where after the commencement of this act, an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon two or more heirs specified in class 1 of the schedule, and any one of such heirs proposes to transfer his or her interest in the property or business, the other heir shall have a preferential right to acquire the interest proposed to be transferred. Then 2, 3, they are there. This is a subsection 1 is the main section. Now they are trying to, my lord, it's my duty to point out to your lordship, if your lordship kindly take their affidavit in opposition to this application. Yes, this is affirmed on 19th December, possibly 2024. September.
19 September, yes.
Kindly come to paragraph 8 at page 9.
Yes.
Last but one line, starting with, there is no law in which provides that a co-sharer must only sell his or her share to another co-sharer, that the stranger co-sharer can purchase share even in a dwelling house. In that case, the remedy of the co-sharer to approach under Section 4 of the Partition Act and except Section 4 of the Partition Act, there is no other law which provides a right to a co-sharer to purchase the share sold to an outsider. So this is my duty to point out to your lordship.
So this is their defense.
This is their defense. Now, Calcutta data law. Section देखी थी lordship. (67 CW) for the law. But I am relying on a decision reported in 67 CWN 792, also Millard reported in 1963 SSC Online Calcutta 165.
Yes.
Millard, paragraph 2 of the judgment indicates that it arises out of an application under section 22 of the Succession Act. Then paragraph 3. Against that, there was an appeal, and appeal court held that the appeal would not lie by still expressed an opinion on the merit of the appeal, which was completely unnecessary. However, I agree with the appellate court that an appeal would not lie because no provision has been referred to me which would show that an order under section 22 of the Hindu Succession Act would be deemed to be a decree or would be applicable under the provision of law. Therefore, I would consider the judgment of the trial court. The trial court has not considered much except that the application was misconceived. Section 22 of the Hindu Succession Act says, then it is quoted. Then 4. The law of preemption refers to a cell already affected either under Section 4 of the Partition Act or under any other law. There has been no right to file an application before the transfer actually takes place. Section 22 goes a bit further, which says there would be a right to preempt as soon as there is a proposal for transfer and even before a transfer is actually effected. Therefore, the right of preemption would not cease because the proposal has merged into a transaction. This is very important. At the risk of repetition, therefore, the right of preemption would not cease because the proposal has merged into a transaction. If by a proposal there is a right of preemption, by the transaction it is proved. To do otherwise would be to do an act against the principles for which the section was enacted, and the purpose of the section would be defeated if an interpretation is made that the right of preemption is available as long as there is proposal, but lost as soon as the proposal comes into effect and a transaction is achieved. Such a construction should not be made for the simple reason that such construction would defeat the purpose of the act. Therefore, always. So, I think precisely and clearly it has laid down the proposition of law. And that is their only defense. Other things are admitted. Two limbs of their defense. Number one, you knew from the email. Factually, that is not correct. Number two, this is not a proper procedure. You file a suit for party. Judgment law says otherwise.
Why you not deny the after receipt of the draft agreement? Why you not denied the you have thanks, you have given the thanks after receipt. Why you have not denied the I am not interested? Why you send the draft to you? The draft
That draft agreement, but that does not mean
does not mean, but why? If so, what the case they have made out in the written statement, with the broker, the talk of consideration was going on, and the draft agreement was sent to you, and you have received on the very next day. You have sent yes, thank you, whatever it is.
Of the receipt.
On receipt. On receipt. Why you have not? If you are not interested with the sale of the property, so why you have not given?
That is not there.
That is
not there. I can't improve upon the fact.
Okay.
But I am on law in the
that is the
admitted fact. That's the conduct of the party. But even if I am deeply obliged to your lordship, what is the consequence thereof? That is passing through your lordship mind. Consequence in my most respectful submission is take everything against the plaintiff. It may be, assuming but not admitting, there was some negotiation. I am not admitting that. But the condition of section 22.
Yes, because there is no record. There is no record that you have been offered. Yes.
Kindly give him. Huh? Well, let us just find out, my learned junior has found it on the same proposition. I don't want to be trouble. In 11. There are various judgments that I am trying to cut short the matter. Was it these or not? This is Milord, 2007-6 Maharashtra Law Journal, page 706.
Yes.
As reported in SCC Online. Deals with section 22, subsection 1.
Yes.
Kindly come to paragraph 10. Section 22, subsection 1 is quoted. Then paragraph 11 at page 709. It is manifest that subsection 1 confers upon one co-heir a preferential right to purchase the property of the other co-heir. This right is akin to the right of preemption. The expression one of such heir proposed to transfer his or her interest also includes the final transfer of such interest by way of sale, gift, or any other mode. The right of preemption is not obliterated after the transfer of interest is completed through an instrument like sale deed or gift deed. There is no provision in either of the subclauses to take away right of the other heirs who are not party to such transfer of interest to acquire any interest of heir or heirs who propose to transfer their interest actually transfer the same. Well, it is the same melodic, I should say, language in a different way.
Yes.
Millard, we have found out, Millard, the SLP against special leave petition was dismissed. Cost title matches, Millard.
Yes.
Delay condone, no merit. Special leave petition is dismissed.
Yes.
So, Millard, this is the law, all along.
Yes.
These naughty juniors, they
Learning. I just told my learned senior Mr. Ghosh, give us some opportunity. How can you deprive?
কি বলে কোনটা বলো আমরা কত কত বলো কোনটা হ্যাঁ এটা একই জিনিস তো বলছে কত টাকা কত দাও প্রসেস দাও This is a judgment of the reported in 1970, volume 1 MLJ 358.
1970 MLJ.
Volume 1 MLJ 358. Your Lordship will find that citation in the left-hand side top, equivalent citation.
Yes, yes. 1971 MLJ. India Canon.
Your Lordship kindly come to paragraph 4. Kindly I won't not repeat paragraph 4. Then Milord paragraph 6. Then kindly come to paragraph 8. May I read this part? The right conferred under section 22(1) of the Hindu Succession Act cannot be enforced and a transfer secured if alienating co-heirs only intended to make a transfer. He or she could at any time abandon the proposal for transfer. It will be perfectly open to a person who is negotiating for a sale to withdraw from the negotiation, abandon the proposal for sale, etc. Such conduct is not unknown. A proposal to transfer may become manifest only on irrevocable act of transfer. It is sale against that right the co-heir that would constitute an infringement of the right under 22.
Yes.
The other way of putting things. And Kindly come to paragraph 11. Paragraph 11. Kindly come towards the bottom. And my lord, fourth line from the bottom of paragraph 11, sentence starting with the existence of the right. The existence of the right is patent, and the burden is upon the purchaser to establish that the other co-heirs declared or waived their preferential right when the occasion arose. It is not pretended that purchaser made any reference to the non-alienating co-heirs before his purchase. It follows that the plaintiffs have not lost their preferential right of purchase by the sale and are entitled to have the properties conveyed to him. Well, possibly that, my lord, will answer the query that fell from your lord.
Correct.
I, my lord, don't want to waste your lordship time on further decisions on the same point.
No problem. Yes.
And kindly come back to, my lord, the petition, the prayers. Kindly come to the prayers, my lord. Actually, my lord, this is a declaratory prayer. And if your lordship kindly consider the prayers made in the plaint as quoted, it is almost similar. So, in my most respectful submission, I am asking for really the final relief. There is no bar. Law is clear. Facts are clear here. And the proposition of law which the defendant number one purported to raise are not applicable or not supported. Well, these are my responses.
Okay.
I'm not reading out the prayers, you know, here.
Order 12 rule 6, the same prayer as of the plain.
Great footman.
Now, my lord, your lordship is considering only order 12 rule 6 application, judgment on admission, not any other.
Nothing.
Now, my lord, your lordship has already has a vast experience to see the language of order 12 rule 6, my lord. Now I will raise my argument on the basis of that admission part. Now, according to my learned senior friend, but if your lordship see once page 17 of the application under order 12 rule 6.
Page 17.
Page 17, my lord.
Yes.
But according to my learned senior friend, these are the averment which basically admitted by me according to my learned senior friend, and for which my learned friend has compelled to file this application. May I read for your lordship the averment? But these are the, my lord, paragraph 14 up to Roman 1 to, my lord, Roman 4. This is his statement, not my. Kindly see, my lord, paragraph 15, next page, page 18. The relevant admission of the respondent number 1 as more fully pleaded in the written statement is set out hereunder. That in the last month of the year 2022, the answering defendant through a broker, namely Indrajil Sarkar, came into contact with the defendant number 2, and defendant number 1 came to know that the suit property would be subjected to sale. Second 13, it is stated that defendant number 1 kept on persuading the plaintiff to sell his 50% undivided share in the property in his favor, but the plaintiff demand with regard to the consideration amount was very high in comparison to the property in question. Then it is stated that the defendant number 2 was in acute financial stringency, for which the defendant number 2 wanted to sell out his 50% undivided share towards the defendant number 1 upon receiving consideration amount which is negotiated in between the defendants therein. The plaintiff is not one to question the consideration amount paid by the defendant number 1 to the defendant number 2 for the 50% undivided share in the premises 6A Mohan Bagan Lane, Kolkata, such and such. Moreover, the condition of the said property is as such, the said consideration amount paid by the defendant number 1 to the defendant number 2 for the 50% undivided share in the premises number such and such was absolutely proper. Then it is stated, paragraph 20, it is stated from the averment made in plaint, it is clear that the plaintiff was aware about the fate that due to acute financial stringency, the defendant number 2 wanted to sell out his undivided share towards any prospective buyer, when through a broker, the defendant number 2 was introduced to the defendant number 1 hearing. It is further stated that when it was well within the knowledge of the plaintiff that the defendant number 2 is ready to sell his 50% undivided share in the property in question, and even then she has not approached the defendant and given proposal for purchasing the same, and thus question of having any preemptory right over the undivided share of the defendant number 2 does not arise at all. The plaintiff did not exercise his option of preemption by making unconditional undertaking that he is ready and willing to buy up to the share. Kindly mark this portion. This is then, moreover, the valuation of the property was fixed at proper market value, and the same was fair to both the parties. Then it is further stated that when it was well within the knowledge of the plaintiff, the defendant number 1, 2 is ready to sell his 50% undivided share in the property in question, and even she has not approached the defendant and given proposal for purchasing the same, and thus question of having any preemptory right over the undivided share of the defendant number 2 does not arise at all. It is stated that no law for the time being in force which bounds the defendant number 2 to sell the 50% undivided share in the property in favor of the defendant number 1 upon taking the consent of the plaintiff. Causing for a moment, on my understanding and reading, but it does not say anything about the admission. Rather, I deny each and every allegation.
No.
Now,
the plaintiff's case is that kindly come to the page 19, paragraph 20 in the middle portion.
May I beg your pardon, page
19.
Page
Just
19.
pointed out.
Yes.
Paragraph 20, which
20,
has been
yes.
quoted. Correct. In the middle, it is further stated that
when it was well within the knowledge of the, your lordship is reading what? Well within the knowledge of the plaintiff that the defendant number 2 is ready to sell his 50% undivided share in the property in question, and even then she has not approached the defendant and given proposal for purchasing the same, and thus question of having any preemptory right over the undivided share of the defendant number 2 does not arise at all.
So, in this written statement, in the affidavit in opposition, you have stated this. So, you are admitting with regard to the preemption right under 22, and you have taken the plea that she had the knowledge, but she has not.
But if
it is so, you have to show the document that the plaintiff had the knowledge that you are selling, but the plaintiff has not.
Yes. Now, your lordship, for that reason, your lordship has to go through my affidavit in opposition. Now, your lordship has seen paragraph 20. Now, I will argue. Let me just show to your lordship the affidavit in opposition, which I have stated. But if your lordship see, that has been affirmed by Surojit Mitra on 19 September 24. But in page 2, I have stated how the property comes to the plaintiff and the defendant number 2, everything. It is not required. Kindly I am requesting your lordship, your lordship see page 4. Page 4, Roman 7. Roman 8. That one Indrodil Sarkar, who is known as broker in the locality, contacted with this deponent and informed that he has good connection with Supriyo Ghosh, who intended to sell his share in the suit property. In a meeting between this deponent and Supriyo Ghosh in presence of the broker, the said Supriyo Ghosh expressed his financial trouble and agreed to sell his portion immediately.
Yes.
That this deponent requested the said broker, namely Indrodil Sarkar, that this deponent intend to purchase the entire premises and requested the said broker to talk with Subroto Sarkar, who is the owner of 50% share of the aforesaid premises. That the said broker, namely Indrodil Sarkar, assured this deponent that he will negotiate with Subroto Sarkar for transfer of her 50% share, so that this deponent became the owner of the entire premises. Unfortunately, in spite of best efforts, the said broker did not hand over the contact number of Subroto Sarkar, but assured this deponent that he has already informed the Subroto Sarkar about the intention of Supriyo Ghosh to sell his share. Subsequently, the said broker informed that the Supriya Ghosh will transfer his share immediately and Subrata Sarkar asks the said broker to send a draft copy of the agreement for sale. Ultimately, this deponent purchased 50% of the undivided share through a registered deed of dated 11/8/2023 from Supriya Ghosh. It is admitted, the date. Subsequently, the said broker informed this deponent that he has already sent a draft copy of the agreement for sale to Subrata Sarkar in her mail. On receiving such mail, a reply has been received from Subrata Sarkar on 19th August 23 with an endorsement received. Thank you. This deponent submits that the said broker informed that Subrata Sarkar has gone through the mail and had a talk with the broker, namely Indranil Sarkar. And during conversation, the said Indranil Sarkar requested Subrata Sarkar to send her Aadhaar number, PAN card, but in one way or other, the said Sarkar is taking time for sending the same. That while the negotiation was going on at the instance of the Indranil Sarkar, this deponent received the summons of the present suit. Now, my lord, what I say, my lord, kindly see the next para. This deponent submits that the plaintiff, knowing fully well about the intention of the defendant number 2, did not express her willingness to purchase the share from defendant number 2. As such, preemption as per the provision contained in section 44 of the Transfer of Property Act does not and cannot arise. It is a fact that the meeting was scheduled at the office of the plaintiff situated at such and such, but the broker did not provide any opportunity to the deponent to attend the meeting in order to secure his brokerage from both sides. This deponent submits that the plaintiff wanted a draft copy. These are the things, receive, thank you, another thing. Now, if your lordship see section 44, now, there is a your lordship experience, I should not trouble your lordship,
the DP Act.
Transfer of property. Now, in the suit, I have already filed written statement. Now, everything has been now at that stage, but he is filing that application. Now, kindly say section 44.
Yes.
Now, where one of two or more co-owners of immovable property legally competent in that behalf transfer his share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as it's necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the condition and liability affecting at the date of the transfer the share or interest so transferred. Next, where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the house. Now, why I am reading this, if you let's see that there is no law, it is my submission, that a co-sharer must sell his share to other co-sharer. He cannot sell the other party.
Not that, but
right of preemption will only come if your lordship see. I will, when this point has came up for consideration before your lordship, I will just rely one judgment to meet your lordship's query, 2000 volume 8 Supreme copy 2000 volume 8 Supreme Court cases, page 330. Kindly come to I'm sorry, kindly come to page 20, paragraph 23.
Yes.
We are in agreement with this opinion. There is no law which provides the co-sharer must only sell her share to another co-sharer. The stranger outsider can purchase share even in a dwelling house. Section 44 of the Transfer of Property Act provides that the transferee of a share of a dwelling house, if he or she is not a member of that family, gets no right to joint possession or common enjoyment of this house. Section 44 adequates protects the family members against intrusion by an outsider into the dwelling house. The only manner in which an outsider can get possession is to sue for possession and claim separate in his share. In that case, section 4 of the Partition Act comes into play. But pausing for a moment, the question of applying section 44 of the Partition Act will arise only if the subsequent purchaser filed a suit for possession and claim for partition.
No dispute.
Now, what is the suit for? If I put this question, may I just read this? Except section 4 of the Partition Act, there is no other law which provides a right to a co-sharer to purchase the share sold to an outsider. Thus, before the right of preemption under section 4 is exercised, the condition laid down therein have to be complied with. As seen above, one of the conditions is that the outsider must sue for partition. Section 4 does not provide the co-sharer a right to preempt where the stranger outsider does nothing after purchasing the same. But why I'm reading, but here the suit has been filed by my learned senior friend. What is the prayer? If you see once the prayer, now it is not the case. My learned senior friend is asking that preemption. But here the preemptory right. But my respectful submission before your lordship, preemptory right section 4 will only come if I, being outsider, filed a suit for partition or my lord the possession. Now, if your lordship see once, but I'm just traveling to your lordship.
So what you will do after the execution of the deed? What you will do?
But kindly see where the
deed was executed, mutation was done. What you will do?
I'm sorry, madam.
Deed was executed.
Deed executed, mutation done. I have already applied for sanction plan.
Mutation is carried out. So how the partition will come?
Now,
how the partition will come if you are not able to go for the partition?
But that stage has not come. If you lordship see the prayer in the suit, kindly see the prayer. Difficulty only thing, my lord. I went to that building, my lord. I forgot to bring my.
How much you will take time? Because 3 PM my other matters are
fixed. Then I kindly keep it another.
I'm giving.
Only just 1 minute, I am showing the prayer of the plaintiff, my lord.
Quoted in the
page. Page 12, my lord. Declaration that the transfer of the right and title and interest by the defendant number 2 in favor of the defendant number 1 in respect of 50% undivided share in the property being such and such, deed dated such and such is illegal, unsustainable and bad. Degree for permanent injunction and not on that, degree for permanent injunction. Then my lord, deed of alternatively, prayer E, my lord, kindly see. Therefore, prayer E. His basically prayer is for cancellation of my deed.
Correct.
Therefore, in due respect, from the written statement, there is no part of admission where this degree can be passed and judgment of admission. This can be, my learned senior friend can succeed after a contested hearing, but this is not within the domain of Order 12 Rule 6.
No, that's correct. No, that's why you are harping upon section 44.
Yes.
The TPA. Correct. And other side is harping upon section 22 of the Hindu succession.
Absolutely.
His contention is that admittedly it is a joint property. Admittedly, the 50% you admitted 50%. Admitted the 50% was sold to the third party by the defendant number 2 to defendant number 1. As per his case, he has sold in terms of the section 22 of the Hindu Succession Act, no intimation, nothing, and you have sold the property, preemption right has occurred, but that has not been utilized because he has no knowledge about this. So that's why he's
therefore the question with subject one, don't take me away. Question will whether he has at all any knowledge. We are making a statement in the body of the plaint or
not his knowledge. That's why you have. That's why the first question has put the court has put the question to you because now you have taken the plea of the section 4 and all these things and section 44 of this. Correct.
In the written statement also have taken.
But in the written you have taken. But in the written statement, if you are not harping upon section 22, so why the statement you have taken that he had the knowledge? There was a term.
I understand what is falling from your lordship. I will argue on that point, my lord. I will argue. But only thing, my lord, it can be subject to after 24th because I will not be here in the next week. 24th.
So appearing for the plaintiff, so appearing for the defendant. The plaintiff has filed an application being GA2 of 2024, praying for judgment upon admission. Police counsel for the plaintiff has concluded his argument. Police counsel for the defendant, defendant number 2, huh? Defendant number 1. Defendant number 1 has argued the matter at length, but due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. Appearing for the plaintiff and defendant number 1 only. None appears on behalf of the defendant number 2. Release the matter. After 24?
Yes, sir. 20
तो non-commercial है ना?
20.
हैं?
On a Thursday, where adjourn motions are given.
Alternative, either come in Thursday. It is
Thursday,
alternate. Sometime I take the new motion
28 or something.
because I have to adjust the whole
I
part.
know, Milord, I don't really appreciate Milord.
Uh,
First Thursday, if it is possible.
okay, 27.
27 is
Thursday.
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 No,
But-
or next week.
Next week. Today is the 27 I will take. 27th of March.
27th,
You will not be available. Then 3rd March, 3rd April.
My 3rd April only in our house Annapurna Puja. 4th, 5th, 6th. It is 31st year. Then after.
But I suggest not to take a Thursday because Thursday I am
Oh,
keeping
any
the
day.
appellate side. Come on, second?
Second.
Second April. As part of
Any time. Milord?
time is the difficulty. As part head, it will come as top.
I'm good.
Good.
One thing I have, Milord, make it clear that we'll be paying them 30 lakhs and the registration touch time duty.
Consider it. Consider.
I've taken instruction on that.
If so, then come with the settlement agreement. Terms of settlement so that the suit can be disposed of.
Milord,
Yes.
item 22, Milord. I am opposing this. It's my possibly Lordship has heard this before, Milord.
Which was the other
This is my application, Milord. I am for the plaintiff. This is a chapter 13 application, Milord. Affidavits are completed. Very short conspectus of the matter. Your Lordship had considered this matter. Thereafter, it went down in the list, Milord. Any day, if your Lordship can give precedence, Milord, fixing is not.
It will come up. Let it be in the list. Let it be.
I have no difficulty, Milord. I am opposing this, Milord, considering my learned junior friends' constraints, Milord. If a date may be fixed, Milord, when
Date fixed, then you have to wait till June.
Oh, Milord, I am opposing. I am not supporting his cause, Milord.
Let it be in the list.
Yes.
Yes. The court will find the time. I will.
Item number 28, I believe.
Yes.
The trust matter. My learned junior, Milord, may come up a bit. Adjourn motion topic বলে দেন একটা দিন। Shabil Das or something.
Yes.
কোনো একটা দিন যদি adjourn motion topic
ঠিক আছে, দেখবো।
বলে এটা বল। এইটা বলে দে।
Milord, just if that 22 could be at the top on the adjourn motion list, Milord, any day. Milord, 2200.
I have no difficulty.
23, 22.
I have no difficulty.
28. ऊपर कर दो.
Deeply obliged.
Next Thursday, Milord, Lordship will be.
Not Thursday. It will the list will continue.
Whenever, Milord.
Deeply obliged.
I have helped him, Milord. Great.
Lordship, the circuit bench matter will be 3 p.m. circuit bench.
I will call. Please wait.
Lordship.
Circuit bench है क्या? One second. Circuit bench call करो पहले.
Lordship, I am for the petitioner, Lordship.
Yes.
Last occasion, Lordship directed me to serve upon the contempt. Now I have served. The affidavit of services with me. Most probably my learned friend, Mr. Vikas Singh, is appearing.
Yes, Lordship. I on behalf of the opposite party, Lordship.
Yes.
Order is complied today, Lordship.
Complied today.
Yes,
so
Lordship.
fixing the next week, you file the affidavit of compliance.
Lordship.
I
don't have any instruction as to the compliance.
Okay, that's a letter compliance.
At 2 p.m. It was complied, Lordship.
Okay.
And thanks to my learned friend.
So appearing for the petitioner. So appearing for the alleged contemner. Counsel for the alleged contemner submits that the contemners are complied with the order and he will file the affidavit of compliance. In view of the submission made by the counsel for the alleged contemner, Let affidavit of compliance be filed within a week. List the matter on 20 March 2020.
Grateful.
Under the same heading.
Grateful. Grateful.
Grateful, Lordship.
Yes, call the next. Call the main matter.
Lordship, may I please your Lordship? Your Lordship, this application is appearing at my behest.
Yes.
This is an application by the respondent number 3. The applicant before your Lordship is the assistant engineer of the Howrah Municipal Corporation. Your Lordship will be correct that on 30th of January 2025, your Lordship had taken up this matter when your Lordship had inquired to the authorities as to how much of more time will be required to comply with your Lordship direction. And your Lordship was pleased to fix the matter on 4th of April 2025.
Correct.
However, your Lordship, 2-3 facts which were overlooked by us is that just after passing of this order, the examinations of the Madhyamik started. Thereafter, your Lordship, the examinations of the HS and the other school examinations started. Most importantly, your Lordship, the period of Ramadan 2025 has started from 1st of March 2025. Most of the local people residing there are from the minority community. They are observing their prayers and also their fasts, your Lordship. We have received a request from the local people at large to stay our hands till their festive period, your Lordship. So, Lordship, we are just praying for your Lordship's kind consideration to allow us some further time so that we can comply with your Lordship's order and come back so that we are able to satisfy your Lordship.
Yes.
I don't have any objection, madam.
So how soon you will complete?
Your Lordship, I will.
Ramadan will complete in the month of April.
Your
Exam will also complete in the month of April.
Your Lordship, I will be very candid, your Lordship. I had a consultation with the assistant engineer. He has said that the subject property is situated in a very narrow lane, your Lordship. Everything is being done manually, your Lordship.
Correct.
There is no space to put up a scaffolding, your Lordship, in order to prevent the debris falling upon the passerbys, your Lordship. So the work is going to be very slow, your Lordship. He has requested me to ask for a further time of 3 months, your Lordship, if your Lordship may.
So and so applying for the petitioner. So and so applying for the state respondent, municipal corporation.
Municipal corporation, assistant engineer.
So and so applying for. So and so applying for the petitioner. So and so applying for the Howrah Municipal Corporation.
Your Lordship.
The who has filed this?
The assistant engineer, respondent number 3 in the writ petition.
The assistant engineer within bracket in charge, comma building department, Howrah Municipal Corporation, has filed the present application being can number 4 of 2025, praying for extension of time for compliance of the order passed by this court dated 30th January 2025. Counsel for the Howrah Municipal Corporation submits that by an order dated 30th January 2025, this court has directed the Howrah Municipal Corporation to
relevant part is at page 18 of the application, your Lordship.
to comply with the order passed by this court and to file the compliance report on 3rd of April 2025. Full stop. The London Council appearing for the Howrah Municipal Corporation submits that at the time of passing of the order by this court, the respondent could not brought to the notice of this court that the examination of the Madhyamik as well as higher secondary of 2025 started from 3rd of March 2025.
And February, your Lordship, 10th February.
10th February 2025 and 3rd March 2025 respectively. And also they have taken the consideration that the building in question is situated at the narrow streets and the residents of the said area are observing the Ramzan month of Ramzan, and as such it is not possible for the Howrah Municipal Corporation to comply with the order dated not in a position to file the compliance report on 3rd of April 2025, and as such, he prays for further 3 months' time to comply with the order. Consider the submission made by the counsel for the petition, counsel for the Howrah Municipal Council. This court found that the grounds on which the Howrah Municipal Corporation prays for extension of time to for filing of the compliance report is genuine one, and as such, to file the compliance report, such time to file the compliance report is extended for a further period of 3 months from date. Full stop. The Howrah Municipal Corporation is directed to file the compliance report before this court. Compliance report of the order passed by this court dated 31st of January 2025. On 12th of June 2025. CAN number 4 of 2025 disposed of.
Item number 2, I am for the petitioner, my lord, led by Mr. Lahiri, my lord. We have already completed our argument, my
Where is the other side?
lord. No, my lord. Probably there is a resolution, that's why.
They are enjoying the favor of party.
Probably there is a resolution not to pass any.
That's why. Since appearing for the petitioner, none appears on behalf of the opposite party. According to stop. In view of the resolution of the bar, the case is adjourned. Let the matter appear on 20th March.
Item number 3.
Your Lordship, my lord, this matter, my lord, was fixed at by instance, my lord. Lord, this is the supplementary affidavit, my lord, containing the, my lord, translated copy of the, my lord, documents from Bengali to English, my lord. May I submit, my lord, subject to your Lordship's consideration. Lord, this is a, my lord, order, my lord. I am challenging an order passed by the, my lord, revisional court, my lord. My lord, setting aside the order.
Where is the order?
My lord, kindly have a look at, my lord. First, my lord, kindly have a look at, my lord, the order which was passed by the learned trial court, my lord. My lord, that is order dated, my lord, 7th March 2022, my lord.
Which page?
My lord, relevant page, my lord, inner page number 2, my lord.
Page number?
My lord, page number 19, my lord.
19, 19?
19.
Yes.
It is an application for interim order, my lord. From the very outset, it prima facie appears that marriage and the burning of the issue are the admitted facts. It is further crops up that the OP is a group D employee, so and so, so and so, so and so. Therefore, logically at this outset, that the claim of the petitioner as to marriage,
You're reading.
my lord, that is, my lord, inner page 2, my lord, of the order
Paragraph?
which was paragraph, my lord, second paragraph, my lord.
From the very outset?
Yes, my lord.
Yes.
Inner page 2, my lord.
Correct.
Inner page 2, my lord. There has been the document BS, my lord, the OP that it appears from a document furnished by the OP, my lord, that it is the petitioner who left the house of the opposite party voluntarily on 15/3/2020. The documents bear the same date, that is on 15/3/2020, when the petitioner claims to leave the office house in her petition. There has been furnished no explanation challenging the document. But the document which was furnished, my lord, by the, my lord, opposite party husband, my lord, that was never challenged in the interim application, my lord, the objection which was raised. From the part of the petitioner at the time of hearing of the interim maintenance petition, on being as the learned advocate for the petitioner fails to table any plausible explanation and plausible argument as to why the petitioner voluntarily entered such declaration. The document has not been challenged by the petitioner either orally or through written submission. The petitioner never lodged any complaint as to the authorities concerned that she has been forced or compelled or to enter such declaration. The document is further witnessed by 3 witnesses. Therefore, it leaves no room before this court to presume at this stage, my lord. Kindly, my lord, mark the word at this stage, that the petitioner, because in the interim application, my lord, that there is no question of trial on evidence at this stage, my lord. The petitioner is residing in her parental house voluntarily without any justification. Therefore, the prayer of the petitioner for the interim maintenance seems necessary to bite the dust as apparently as appears at this stage, my lord. Now, my lord, what was there, my lord? Then what the learned judge, my lord, learned magistrate did, my lord? Kindly have a look at the page 3, my lord. This thus the interim pair of maintenance under section 125B and the same is partly allowed on contest. The prayer of the petitioner for monthly interim maintenance for herself be refused at this stage, my lord. Because the main maintenance application is pending, my lord. Now, my lord, second part, my lord, so far the question of, my lord, maintenance to child is concerned. The opposite party is directed to make payment of rupees 2,500 for his minor son per month as interim maintenance till the disposal of the case, my lord. So, my lord, we are paying that maintenance amount, my lord. Now, what the opposite, my lord, the petitioner wife, my lord, the opposite party wife did, my lord, he challenged this order, my lord, before the, my lord, before the sessions court, my lord, and the learned sessions court, what did, my lord? Can you have a look at, my lord? The order dated, my lord, the impugned order challenge, the subject matter challenge before the lordship, my lord, 22nd August 2024, my lord. Today is for fixed for delivery of judgment. Both revisional application as well as the respondent are present today by filing Hajira. The case record is taken up so and so and so. The judgment report so and so. Order that the instant criminal division being number so and so, the same is allowed on contest against the respondent. There shall be no internal court till the order is passed by the learned judicial magistrate court is hereby set aside.
Where
And
from you are reading?
my lord, the 71, page 71, my lord. That is order dated 22nd August 2024. Order number 11, my lord.
71.
Yes, my lord.
56.
That your lordship got it, my lord.
Inner page?
Inner page, my lord.
Yes, got it.
Yes.
The instant revision
Yes.
application. Yeah,
They're
which time
directed
is
to
allowed?
make payment of rupees 9,000 per month to the revisionist for herself. Your lordship, my lord, may kindly consider that so for the purpose of assessing the maintenance, my lord, that is the procedure, my lord, for filing the declaration of assets and other things are there, my lord. And rupees 4,500 per month for our minor son as interim maintenance till the disposal of the miss case. So far, son is concerned, even if it has increased, my lord, although no prayer for increase of the amount was not there, we are, my lord, agreeable to pay the amount. But so far as 9,000 is concerned, my lord, kindly have a look at the, my lord, the learned trial judge is finding for the purpose of.
So what is the stage of the main case now?
My lord, repeated dates, my lord, at least, my lord, it is ready for evidence, my lord.
The Leonard additional session judge has passed an order on August 2024.
Yes, my lord, before that, my lord.
Correct. So whether you are paying this amount?
Yes, my lord.
This,
Yes. So far, no, my lord, so far, son is concerned, my lord, we are paying the amount.
You
But
are not
so
paying
far,
the amount with
yes.
regard to this. As per the order of the session judge, you are not paying the amount.
No, my lord, because we have challenged it. Our contention is that, my lord, the main maintenance matter, whether the document he has not challenged, even the revisional application which was, my lord, filed before the learned session judge, my lord, he has not uttered a single word that this document which was filed, which was used at the time of hearing.
Where is the document?
The document is that, my lord. I'm coming, my lord. The declaration in Bengali, my lord, in the supplementary affidavit I have annexed, my lord. My lord, this is the declaration, my lord.
7A.
My lord, 6A, my lord.
6A.
It starts from, my lord, 5, my lord. That declaration is, my lord, Bengali, that's why I will translate it. My lord, that it was the
I was
special.
married in the Ratsingham, son was born at night. On this day, I voluntarily moved from my in-laws' house to my father's house with my parents, taking my son with me. In this regard, in good health, in a simple mind, with my knowledge, without the request or inducement of others. It's an interest. I have read the declaration.
देखिए कोई cosa देखिए revision application टेबल P1 revision application
Yes.
Milord, in the revisional application, even Milord, the Milord wife never challenged Milord that this document has been entered into by me under coercion or for so.
What is the finding of the session judge with regard to this document?
Milord, document Milord.
Where is the finding of the
The finding
session
দেখি
judge?
দেখি আসো ওরা কি বলেছে দেখো
Because the
Milord, kindly have a look at Milord.
The London magistrate has considered this document
Yes.
as not awarded. So what is
Yes.
the finding of the
Milord,
London
finding of the Milord. Milord, kindly have a inner page Milord 4 of the Milord impugned order which subject matter challenge before your lordship Milord. Kindly have a look Milord the second paragraph Milord. The Milord. The Milord, it starts from Milord 3 Milord. Let us better Milord. Kindly have a look at Milord the page 3, inner page 3. Admittedly, the respondent number 1 had in its written objection duly supported by an affidavit disclosed that that revisionist had made a written declaration on the prayer on 5/3/2008 that she was leaving her matrimonial house along with her minor baby and her parents, never to return. Undoubtedly, the revisionist did not furnish counter affidavit. It means Milord the wife. Counter affidavit the written objection specifically denying the execution of such document. That was produced by the respondent number 1, Milord, the husband Milord, before the trial court as well as before this court. Milord, even that court, Milord, revisional court, Milord, this document was not impugned or Milord was challenged on any ground. Even the objection, in the objection, no objection was taken against that declaration made by her, Milord. Now the Milord logic, Milord, which was Milord, that was Milord finding arrived at Milord. In other words, same was not scribed in its entirety by the revisionist. And for all intents and purposes, the revisionist had nothing to gain putting pen and paper on such declaration. And then, Milord, kindly have a look at paragraph 8, Milord. Section 125(4) of the CRPC postulates that a wife who chooses to live separately from her husband without a valid reason may not be.
Have you enclosed the revisional application?
Yes, yes, yes.
Where is the revisional application? What they have stated about this document?
Revisional application is 11A, Milord. Kindly have a look at 11A. 11A of the supplementary affidavit, Milord. No, no. Milord, 11. No, Milord. That is wrong, Milord.
Revisional application.
Revisional application, Milord.
Filed by the wife before the district judge.
Yes, Milord. Milord, I am coming to that. Milord.
What is the ground taken? What justification they have given in the revisional application?
Milord, I am coming to that. Milord, that is Milord. Kindly have a look at page 52, Milord. Page 52, Milord.
Yes.
Yes, Milord. First paragraph, Milord. The humble petition of the petitioner has filed an application 125 for maintenance along with the interim maintenance for herself and her son. So and so the learned SCM requirement transfer the case so and so after hearing the interim maintenance petition is refused to pass the interim order of maintenance so and so that being agreed by the order. Milord, nothing has been stated about the document or the Milord the order which was Milord the document which was considered. No objection was taken. That was the finding of the learned trial judge. Even in the revisional application, he has not challenged the document. And the learned Milord, the session judge also Milord, stated that he has not Milord filed any objection or protest against the Milord declaration which was Milord filed in the even the revisional application Milord. But the learned session judge of his own volition Milord passed this impugned order Milord. Logic is that Milord paragraph 8 Milord. Paragraph 8 Milord of the inner page 4 of the Milord impugned judgment Milord. The interim section 125 so and so so and so and the same produces a couple being separately by mutual consent. However, Hindu laws recognize the right of a married woman to live separately and claim maintenance, even if she is not seeking divorce. Milord, that is Milord, that is totally beyond the tenets of the Milord, the provisions of 125. And on the basis thereof, Milord, the learned judge, Milord, learned session judge passed the order, Milord. Setting aside, Milord, this is Milord interlocutory order, Milord, interim maintenance was refused at the stage, Milord. And thereafter, Milord, I will refer to your lordship, Milord, series of dates, Milord. Case is otherwise ready for evidence, Milord. From Milord, from 12 September 2022 to Milord, till date, Milord, evidence is not being taken up till the Milord order was passed by the learned session judge. Milord, whether even if Milord he has to challenge Milord that at the time of trial whether the document is genuine or not, whether it was engineer document or not. Neither it has been challenged before the learned trial court, nor it was before the revision court in the filing the revision application. But the learned charger by it's inserting the paragraph 8 in the impugned judgment order here set aside it was at this stage interim maintenance. If the final maintenance, if it is found that she is entitled to get, or the document was in any way that is not tenable, or it was under any coercive circumstances or any other circumstances, then on trial can be decided trial on evidence So learned magistrate has not come to a definite finding that she is not entitled to get maintenance at this stage just.
Who is appearing for the other side?
Now it is the motion stage motion stage admission stage we simply move the application and pray for stay interim stay. So for child is concerned, we are paying and we go on paying without prejudice to rights and contentions
But you pay some amount. Instead of 9,000, pay some amount. Wife is there.
But when propriety of the order, that is a it falls from your lordship, that is a different thing, But
Wife is there. After all, she is the wife. Under the Hindu law, even after
that is true, But if somebody
divorce also sees in
somebody tenets of the provisions of 125 if somebody voluntarily goes and claims maintenance, one of the ingredients he has sufficient reason must be there, No, fact is different. No, fact is different. The challenge the documents. You should challenge the document. You never challenge with the revisional court. So, for the time being, let us, kindly admit the petition. We'll serve a copy. So far as the order of stay, order of impugned order of sentence may kindly remain stayed, because it is for number of occasions, the main maintenance application is ready for hearing,
When the next date is fixed?
Next date of 28th of March is fixed,
No evidence is started.
No, number of dates, I have collected, from 2022, 12 September 2022, there is evident date of being adjourned.
And she has not filed the affidavit of
No. Rajni versus Naya. Otherwise, how can it be, how the learned judge, I am asking this question to Michelle, come to a finding, at 9,000, and the so far as the maintenance of child is concerned, he has increased. We are at a meeting, let us do that, For the time being, kindly pass an interim order of stay, let them come, because affidavit of assets have not been filed.
So appearing for the petitioner. The petitioner has filed the present revisional application being CRR number 4613 of 2024, challenging the order passed by the learned additional district judge, Rampur Hat, Birbhum, dated 22nd of August 2024 in revision criminal revision number 10 of 2022, wherein the learned additional district judge, by setting aside the order passed by the learned judicial magistrate, 3rd Court, Rampur Hat, dated 7th March 2022, directed the petitioner herein to make payment of rupees 9,000 per month to the wife at the rate of 4,500 per month, and
wife 9,000.
9,000 per month for the wife, and rupees 4,500 per month for her minor son as interim maintenance till the disposal of the miscase number 119 of 2021. Full stop. Learned counsel for the full stop. The wife had filed an application before the learned magistrate for grant of maintenance, along with an application for grant of interim maintenance. The interim maintenance, the petitioner, being the husband, opposite party, has contested the interim application by filing the written objection. Contested the interim application for grant of maintenance for filing written objection. In the written objection, comma, the petitioner has disclosed
A
the
declaration.
undertaking signed by the wife dated
Declaration.
15th declaration signed by the wife dated 15th March 2020, wherein she has categorically stated that she is voluntarily moving from her in-laws house to her father's house with her parents, taking her son with her.
And father was a witness to the declaration.
In the said undertaking, in the said declaration, it was further stated that she is voluntarily and having the knowledge and without any request inducement from any corner, she is moving to the in-laws house, moving from the in-laws house. The said declaration is signed by the wife in presence of three witnesses. Considering the said undertaking dated 15th March 2020, comma, the London magistrate, while disposing of the interim application for grant of maintenance, has refused to grant any interim maintenance to the wife.
At that stage, mirror.
Interim maintenance to the wife, and only granted the interim maintenance to the only granted rupees 2,500 being the interim maintenance to the minors with effect from the date of order. Full stop. The petitioner has the wife has filed the revisional application. The revisional application challenging the order of the London Magistrate. The petitioner in the present revisional application has annexed the copy of the revisional application filed by the petitioner before the London district judge, additional district judge. In this revisional application, comma, the petitioner has not, and the petitioner, the wife has not averred. Where is that revision? The revisional application, which page?
The revisional application is at page, mirror, starts from page number, mirror, 52, mirror.
Has not averred any ground with regard to genuinity of the declaration signed by the wife in presence of three witnesses.
Even in the mirror trial court, mirror, she did not object.
Full stop. The London district judge, while passing the additional district judge, additional district judge, while passing the impugned order, has considered the said declaration, but has come to the conclusion that under section 125 within bracket 4 of the Code of Criminal Procedure, postulate that the wife chooses to live separately from her husband without a valid reason may not be eligible for maintenance, and the same includes a couple living separately by mutual consent. But the London district judge has considered the Hindu law recognizes the right of married women to live separately and claim maintenance even she is not seeking divorce. The London district judge has not taken into consideration with regard to not taken into consideration of the declaration where the wife has categorically stated that she is voluntarily leaving the house of her in-laws and voluntarily she is going with her parents to reside with the parents' house along with the son. Full stop. This is the matter of trial whether the declaration was voluntary or not. The petitioner has not challenged that declaration in the revisional application in any word.
Even in the trial court, mirror, he did not take any objection.
The London magistrate, while passing the order refusing to grant interim maintenance, has also held that the petitioner, the wife, has not challenged the declaration. Full stop. Considering the above, this court find that the learned district judge has not considered the prospective value of the document signed by the wife in presence of 3 witnesses. Though that is the ad interim stage, that is to be decided during the trial whether this document is genuine or not, or whether the said document is to be taken into consideration at the time of grant of maintenance. But at the time of grant of maintenance, the court has to see whether the whether the wife has voluntarily left the house or not. In the present case, from the declaration, it is found that the wife has voluntarily left the in-laws house.
Prima facie document.
Left the in-laws house and is residing with the parents' house with the son. And as such, this court is of the prima facie view that the order passed by the London district judge, the finding of the London district judge with regard to the declaration is not correct. Accordingly, the order dated 28th August 2024 passed by the additional district judge with regard only to the maintenance of the wife for rupees 9,000 is stayed.
But son is concerned, will go on.
Stayed till the disposal of this present application.
And super son is concerned, will go on.
Police of the petitioner is directed to pay the interim maintenance to the son.
My lord.
Son regularly without any fail. Police of the petitioner is directed to serve the copy of the revisional application along with the documents and the supplementary affidavit to the opposite parties
and file
within a week from date and to file affidavit of service on the returnable date. Let the matter appear on 27th of March 2025.
Number 4.
Your Lordship, I am appearing on behalf of the petitioner. I am led by Mr. Gunjan Shah in this matter. Your Lordship, due to personal difficulties, he couldn't come. As such, I am praying for not
today. Next. Yes, in any matter, both the parties are there.
I don't know, but so far as 12 is concerned, your Lordship will 9.
9. Okay, serially, who is up there? Then I will take serial.
Opposite party number 2.
Item number 9. 3, 4, 5, 6, 7. Anybody is there? No. You are for the 9. You are for the opposite party.
Party number 2.
Which for the petitioner is not here. Not today. Come next week. Yes.
My lord, in item number 11, my lord, I am the petitioner.
Ah.
Notice was served, my lord.
Notice is served.
My lord. 11. My affidavit of service.
Let do.
Idea.
Have you served?
Yes, my lord.
Where is the affidavit of service? Item delivered. Whom you have served? Techno Haldia. What about the state?
Hello, sir, man. And sir.
No, here is only one receipt is there. This is a Techno Haldia. What about the other states? State of West Bengal?
Yes, my lord, yes, sir. The office of the PP, my lord.
Where is that? Ah, yes. Got it. But today is the bar resolution. So and so appearing for the petitioner. The petitioner has filed the affidavit of service showing, let the same be kept with the record. None appears on behalf of the opposite parties due to the bar full stop. Let the matter appear on 20.
My lord, kindly keep it little higher, my lord, in the list.
Higher 11 is the higher. How it?
Within 10, my lord.
Let already today two matter has been dismissed. One matter it will come 10. Yes.
Deeply obliged. Much obliged.
Anybody?
So far as 12 is concerned, my lord, Lordship will recollect, my lord, on the last occasion I was appearing on behalf of opposite party number 2 and
The other is not here.
now, my lord, your Lordship kindly records the order, my lord, that I am appearing, and my lord, let it be because there is a resolution. This is in regard to a hate speech, my lord, where they have come before Lordship. I have shown the transcript, my lord, of the.
So have they deposited the amount? 75%?
This is in regard to what, my lord? Item number 12.
Hey, item number 12. He have there. 4592. तुम 13 दे दिए हैं.
4584.
4584. These are 13.
আগেরটা 12টা ওই তো probably they will not even appear next time. They don't have any case. This is not a case where it should be called.
It is made clear the interim petitioner failed to serve the copy. They served.
Yes, yes.
But nobody is appearing.
The petitioner, they are not appearing. Opposite party number 1, 2 and 3, my lord, we have appeared.
Since none appears on behalf of the petitioner, counsel for the opposite party number 2 and 3 are present. Due to the bar resolution, the case is adjourned. Let the matter appear on 20.
Your Lordship, take up item number 21. It is admitted.
Serially, I will seek. Okay. Yes. Any further? Before 20?
Item number 15, my lord.
15. Just the 15. You are appearing for?
My lord, I'm appearing for the petitioner. This is the first time the matter has been taken up, my lord.
You the 15.
My lord, allegation under section 420 and 300.
What is the application for?
My lord,
Washing?
My lord, washing of the proceedings, my lord. My lord, it is under section, my lord, 420 and my lord, 304A. My lord, this is the second application, my lord.
304A.
My lord. My lord, this is the second application that too lodged after a delay of, my lord, 3.5 years, my lord. My lord, the first application on the self-same cause of action, my lord, was
Is
dropped
it
off.
IPC or
My lord, IPC, my lord.
New Act?
No, my lord. The
old one?
Old one, my lord.
Why 420?
My lord, I shall tell you, lord.
304, how the 304 is connected with the 420?
My lord, I tell you, lord. If your lord
death by accident.
My lord, the petitioner.
I thought I
No, your lordship is correct because it's how come it's an causing death by accident.
My lord, the petitioner is a doctor by profession. Now, the allegation of the de facto complainant is that due to prescription of certain medicines, the de facto's brother died.
Correct.
That is their allegation. And my lord, the other allegation is
that's
that.
Correct. Okay,
Yes, my lord, so far as 420, I'll tell you, lordship, their allegation is, my lord, that the petitioner was an homeopathy doctor and he was prescribing allopathy medicines. That is what. But my lord, this is the second application, that too, my lord, not supported by an affidavit 154.1 and 154.
So 304 died.
My lord, died.
So how the 420, 315,
My lord.
313? IPC. 313 of the IPC. How 420?
Major act.
हम आपको IPC बोला भी है वो ठीक है ओके छोड़ो रहने yes so you want to quash
My lord, this is the
paying for
second
the
application. I'm paying for washing of the
Washing
proceedings,
of the
my lord.
proceedings.
First
Issue
application has
notice?
already been dropped off, my lord, by the learned magistrate. This is the second application, my lord.
so second application whether magistrate taken
Yes, my lord.
cognizance where is the cognizance order
Yes, my lord. I'm showing your lordship. It's starts from page 37, my lord. The application, my lord, which has culminated into the FIR at page 41.
156.3
My lord, 156.3, not supported by an affidavit, my lord. This is the second time they have filed, my lord. The first 156.3 has been dropped off by the magistrate after taking consideration of all the reports and everything. Yes, that, my lord, Priyanka Srivastava's judgment is very clear, my lord.
Correct.
It has to be supported by an affidavit. That is not there.
and even once it has been dropped how the second
My
of
lord.
the same cause of action
I'm grateful, my lord. And that too, my lord, 154.1 and 154.3 not complied with. As per Priyanka Srivastava's judgment, no document. Nothing, my lord.
where is the cognizance order you challenge the cognizance order
I've challenged the investigation and proceedings. It has not, my lord. Oh, charge sheet, my lord, it is at page. If your lordship sees the original certified copy, after page 41, my lord, 156.3, after that, my lord, FIR has been registered, my lord. The second page of the original certified copy. The order dated 26/4/2024.
Considering the report as on a paper case FIR, I see consent PS director to start MP case as FIR. Let the same MP dispose of. Original MP case is sent to the IC Batapara PS. So then they have initiated FIR.
And my lord, may kindly comes to page 39. Page 39, my lord. The last paragraph. In the 156.3, in the second 156.3 application, the de facto complainant has stated the fact that the earlier 156.3 was dropped off.
Paragraph?
And paragraph
39, which
14, my lord.
14?
My lord, last para of page 39 of my application.
Barakpur for the same cause of action, but the inadvertently the London Magistrate Barakpur had dropped the petition where the police and the Medical Council of India submitted their report with sufficient cause to it. So they are not challenging that dropping order.
No, my lord.
So and so appearing for the petitioner. The petitioner has filed the present application for quashing of the proceeding initiated by the Bathapara police station, being case crime number 273 of 2024, dated 6th May 2024, under section 420/304A of the Indian Penal Code, corresponding to GR case number 3155 of 2024, pending before the London Additional Chief Judicial Magistrate Barakpur. Counsel for the petition submitted. Counsel for the petition submitted. Before initiation of this case, on earlier occasion, the de facto complainant has filed an application under section 156(3) of the Code of Civil Criminal Procedure, and the said case was dropped by the London Magistrate on 28/8/2023. After the dropping of the said case, the de facto complainant has again filed the present application, and the London Magistrate has directed for initiation of the FIR. And in terms of the order passed by the magistrate, an FIR has been dropped and the police has started investigation. Considering the submission made by the counsel for the petitioner, produce the materials on record, this court find that the petitioner has made out an arguable case, and as such, this court find that the investigation of the Bhatapara police station case number 273 of
Bhatpara police station.
Bhatpara, BHAT, Bhatpara, not Bhatapara. Bhatpara police station case number 273 of 2024, dated 6 May 2024, under section 420/304A of the IPC, pending before the London Court of Additional Chief Judicial Magistrate Barakpur, being GR case number 3155 of 2024, is stayed for a further period of 6 weeks from date. The petition is directed to issue notice upon the opposite parties and to file affidavit of service on the next date fix. This is the matter on 27th of March 2025. ठीक है? कुछ छूटा?
In terms of the order passed by the magistrate, an FIR has been
initiated,
and police has started investigation.
ठीक है?
I'm great.
Yes. Next. कोई है सीरियल में कोई है?
This is appearing first time. Yes.
Item number 21.
Well, this is my application for quashing of a proceeding of a complaint case filed by the complainant under section 420, 422, 406. My lord, come to the complaint last but 4th page.
This is also 156.3.
No, my lord. This is not, this is complaint case.
Complaint case is acha. Where is the cognizance?
My lord. Before 2 pages, my lord. The order
Essay is done under section 200. Complaint and witness are preliminary examined and separate search sheet. Produce the complaint as well as the position. FSA case 406 when established. Yes. So what
My
you
lord,
want? What is the stage of the what is the stage of the criminal proceeding?
My lord, I have obtained bail, and thereafter, my lord, what happened? This petitioner belongs to Uttar Pradesh.
Correct.
Agreement was made outside of West
Correct.
Bengal. And my lord, this is filed by the my lord. Kindly come to complain another one. My lord,
Pankaj
Money
Tiwari.
Private Limited.
Huh?
Complainant name.
Apple money. EP money.
Private Limited, 7th floor.
Mumbai.
Called such and such, having office Mumbai.
Correct.
Represented by Mumbai and KS Rai Road, Kolkata. KS Rai Road having no office. And my lord, represented by his authorized representative. First point, my lord, this is the 420 case. My lord, the agreement, loan agreement was executed between the petitioner and the complainant and the petitioner. My lord, kindly come to page 13. A considerable amount out of 10 lakh was paid.
Who?
My lord, this petitioner. Payment was made. And after payment of my lord, the balance, now it is 6 lakhs 94,000. After payments of considerable amount, it cannot be the 420. Misappropriation of fund, something not like that. Another thing is, my lord, both the office is outside the jurisdiction. My lord, I am handing over the agreement.
Where is, leave aside, where the incident occur? Where the agreement executed?
Agreement executed at UP.
UP, correct.
Yes.
Where the payment was made?
Payment was all made from UP.
In the at the UP or from
UP
or
to
transfer
Mumbai.
from UP to Mumbai. Correct. Then
Nothing was in West Bengal.
what the 10 lakhs was paid by you from where?
Mumbai.
From Mumbai to UP to Mumbai.
Mumbai to UP.
Mumbai to UP.
The complainant office at Mumbai. And the petitioner resident is and business is at UP.
A loan agreement executed with the regional office of the complainant company by and between the complainant and the accused person K.S. Shankar Roy, Hare Street.
This is the loan agreement, my lord. Top the registration office.
No, where this business agreement? Where is your name?
My name is
It is no,
Pankaj.
in this agreement. Where is the agreement?
My lord, agreement was not supplied to me.
So
that's why, my lord, specimen copy most humbly. My lord, another thing.
So suffering for the petitioner.
Another
the petitioner has filed the present application. Present revisional application.
And my lord,
for quashing of the proceeding initiated against the petitioner, petitioners.
Petitioner, husband and wife.
Against the petitioners. Being against the petitioner being complaint case number CS 9595526 of 2024 pending before the London Court of 15th Metropolitan Magistrate, Kolkata Kolkata. Counsel for the petitioner submits that the complainant is the non-banking financial company having the office at Mumbai. The petitioners being the accused are the resident of Uttar Pradesh. Counsel for the petitioner submit that the complaint has been filed by the complainant on the basis of the agreement, on the allegation that the petitioners have borrowed the amount but has not paid the amount. Not paid the amount.
Considerable amount paid, thereafter not paid.
Not paid the pending amount. Police. Counsel for the petitioner submit that neither any agreement was executed at Calcutta nor any transactions have been made at Kolkata. There is no incident with regard to this case has occurred at Kolkata, but the London magistrate has taken the cognizance on the false complaint made by the complainant. Consider the submission made by the counsel for the petitioner. This court find that in the cause title of the complaint, it is mentioned that the office of the complainant is situated at Mumbai, and the address of the accused persons are also mentioned at accused persons / petitioners herein are mentioned at Uttar Pradesh. Uttar Pradesh. There is no document on record to show that any incident was occurred at Kolkata, so that the London magistrate can take the cognizance for the case filed by the complainant. Considering the above, this court find that the petitioner has made out an arguable case, and as such, the petitioner is directed to issue notice upon the opposite parties and to file the affidavit of service on the returnable date. Let the matter appear on
Stay of all further proceeding. Otherwise, my lord,
on
the petitioner
27th of March and on 3rd of April 2025. Pending the proceeding of complaint case number 95526 of 2024, pending before the London 15th London Metropolitan Magistrate 15th Court at Kolkata is stayed for a further period of 4 weeks. 4 weeks. Let the matter appear on 3rd April 2020. Yes. That's all.
My lord, in non-commercial matter, one of the non-commercial matter, my lord had passed an application.
Which one?
Non-commercial matter where
This is appellate side is going on. This is not the original side.
tomorrow.
Yes. What is the matter?
Your Lordship, I am for the petitioner, Your Lordship. This is against the order passed by the CJM Alipur rejecting my 156 clause 3 application. Lordship, the petitioner, I am a tenant under the tenancy of the opposite party number 3 and her mother, who is now no more. Your Lordship, the opposite party number 2 and the opposite party number 3, they had obstructed my access to the rooftop. Against that, I had filed a civil suit. While the civil suit was pending, Your Lordship, I am a businessman who is into the business of outdoor advertising. I had a hoarding structure which is about 14 tons, including all the metal halides, the iron bars, and everything. And that was that structure was located on the rooftop of the tenanted premises. Now they have blocked my access, and the entire area, including the right
You
to
have filed the
access.
civil suit.
The
Go
civil
for
suit.
the civil suit
Your
time.
Lordship,
Take an interim order.
No, Lordship, while the civil suit was pending, the entire structure had been dismantled and stolen by the opposite party number 2 and 3. Now, I had filed an application of 156 plus 3 and representation was made to the OC as well as the other police officials. However, if Your Lordship kindly comes to the impugned order, which is present at page number 111 of my present petition,
Okay, issue notice. No stay. Issue notice. What is stay? It is rejected. Your 156 is rejected.
Your Lordship, I'm before you for praying for the drawing of an FIR and setting aside the order of.
That's why that is to be heard.
Yes, Your Lordship, a service has been made. I'm filing the affidavit of service.
Without the order. There's an order for issuance of notice.
Then, Your Lordship, may notice be issued kindly.
Yes, there is an order. By an impugning order dated Sunday, the court below has refused to accept the petition's application of the preliminary. Like to serve the copy of the application to the opposite. Have you served the application?
Yes, yes.
Nobody is appearing, but today is the bar resolution. Maybe somebody is appearing.
Lordship, if it's kindly kept in within a week's time.
Okay, next week. It will come next week.
Much obliged.
I do not want to.
Come next.
Long, my lord, there is a long pending expeditious expeditious hearing matters.
Expeditious hearing by? What is the case?
The case is instituted against me under section 341, 323, 325.
341. Go plead guilty. 500 rupees fine.
No,
pleading.
my
Go.
lord,
341. What is the?
506 also there.
506. What is the amount?
379 also there. My lord, kindly, there is a case counter case is there. The pain is a long pending matter. The FIR was lodged in 2020.
Correct.
Till now, charge has not been framed.
Charge sheet is not framed.
Charge not framed.
When the charge sheet is
charge
filed.
sheet has been filed, but charge has not.
It cannot be charged. It is a plea. 341 summary trial.
No, 341, 323, 325,
Huh?
354.
Acha, 325. They like that.
Yes.
So what do you want?
Expeditiously.
It is not.
Kindly, please
Instead of
timeline.
buttons,
My lord, kindly. This is a long pending matter. From 2020 till now, there is a case counter cases. Yeah, that's it.
But 120, how my officers will find out the file? A file मिल सकता है क्या? File मिल सकता है? Come on next day, I will see it. 120, how? You have a file?
Yes. 122.
You not have a file? You don't have a brief?
Yes, that is it.
Where is the order? What prayed for?
Expeditious. Expeditious.
Where is the prayer? No, we don't know. There's no prayer. Where is the prayer?
In the last page. In the last page.
Direction to London Trial Court. Below to dispose of the proceeding of GRE case number so. Which court it is pending? Konta hai?
Yes, my lord. Yes, my lord.
Where is the FIR? Charge sheet? FIR lodged on 2020.
2020.
And charge sheet filed 2021. So and so appearing for. What is the good name?
Shoman Nanda.
So and so appearing for the petitioner. The petitioner has filed the present application. Petitioner has filed the present. Petitioner has filed the present application, praying for a direction upon the London magistrate for expeditious disposal of the criminal case pending before criminal case being GR within bracket capital E, case number 1255 of 2020 in connection with Agra PS case number 652 of 2020 dated 17th December 2020 under section 341/325/324/379/506/334 of the IPC. Full stop. This court finds that the police of Agra PS has initiated an FIR being FIR number 252 of 20, FIR number 652 of 2020 on 17th of December 2020, and on completion of investigation, the police has completed the investigation and charge sheet has been filed on 18th of June 2021. 18th June 2021. Full stop. Counsel for the petitioner submits that till date charge has not been framed. and the case is pending since the year 2020. Since the year 2020. Consider the submission made by the counsel for the petitioner, comma, the learned magistrate, second court Kontai, learned judicial magistrate, second court Kontai, is directed to complete to dispose of the criminal trial in connection with GRE case number 1255/2020, in connection with PS Agra case number 652 of 2020, as early as possible, preferably within a period of as early as possible, as per the convenience of the magistrate and as per the diary of the learned.
The time frame cannot be, my lord.
Cannot.
This is a long. Kindly see, my lord. This is a long.
Preferably within a period of 8 months from date.
Grateful.
From the date of receipt of the order.
Grateful, my lord.
My lord, before your lordship I was praying for one indulgence. I'm only saying, my lord, one item number 142. Kindly, my lord, upgrades this, nothing else.
उसे ऊपर कर दो. Yeah, what is the matter?
This matter, my lord, relates to. I'll tell you, lordship. But it's a quashing we are praying for. My lord, the case was registered under section 376. No. There is a judgment where I tell your lordship, promise to marry is not a false promise.
The recent judgment.
Yes. So that is the case. Otherwise, my lord, I would not have trouble.
ऊपर 4-5 के बीच में कर देना.
142.
One humble prayer, my lord, with respect to item 76, the lordship upgrade this. Deep job.
I'm so grateful, my lord.
76.
Now what mentioning?
Your lordship, I am for the private respondent in item number 1, your lordship.
Item number?
1. Because of the traffic jam, I was not able to come at.
Item number 1 has not passed any order.
It has been adjourned.
Adjourned.
Your lordship, I just need to inform the court that they have took the briefs and we are not engaged in this matter. We have just appeared before the court because we have been served with the notice, your lordship. Just
Okay, come on the next day.
Grateful.